Everybody, is June 1st, 2021. City Council is back from a closed session and we're reconvening to open session. Give us a roll call, please, Eleanor.
Councilmember Nierenheim.
Here.
Councilmember Lowenstein.
Here.
Councilmember Horvath.
Here.
Councilmember Obaji.
Here.
Councilmember MD.
Here.
Mayor Brand.
Here. Thank you, Eleanor. Joe or Mike, do we have any announcements from closed session actions?
We do have reportable action from one of your closed session F3. In that closed session, the City Council voted unanimously to direct the City Attorney to file in support of the City of Berkeley's petition to the State Supreme Court that related to housing and the application of environmental regulations for housing projects that they are municipal affairs. That's the reportable action.
Okay, thank you. With that, I'll entertain a motion to adjourn to our regular meeting.
So moved. Second.
Okay, motion by Councilmember Horvath, second by Councilmember Nierenheim to adjourn to a regular meeting. Any opposed? Okay, so ordered. Now I'd like to call to order a regular meeting of the City Council. Roll call, please.
Councilmember Nierenheim.
Here.
Councilmember Lowenstein.
Here.
Councilmember Horvath.
Here.
Councilmember Obaji.
Here.
Councilmember MD.
Here.
Mayor Brand.
Here. Thank you again. Eleanor, let's all rise and salute the flag. And take a moment of silence afterwards. Ready? Begin. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, liberty, and justice for all. Okay, thank you, folks. So, with that, I guess I'll move right to announcements. Councilmember Nierenheim, do you have any announcements to make?
I do not have any announcements. Thank you.
Councilmember Lowenstein.
I have two. Thank you, Mayor Brand. The first is the next District 2 community meeting will be held on Thursday, June the 10th from 6 to 7:30 on Zoom. There will be an invite link to register on the District 2 Council page on the city website, redondo.org. The second is I was lucky enough with Mayor Brand to attend a very small honor ceremony yesterday for one of our local vets, 103-year-old Joe Eskenazi. I'm sure Mayor Brand can elaborate on this. Quite a ceremony. It was very small. He was stationed at Schofield Barracks on December 7th, 1941, when Pearl Harbor was bombed, and he came within 50 feet of losing his own life. It was a really nice ceremony. I believe it's in the local newspapers that it was covered, but it was great to be there. It was at the Veterans Park Memorial. We didn't have an official one this year. It was just small because of COVID, and it was really neat to be there. So I really appreciate being able to celebrate with his family, his life. So thank you. That's it.
Okay, Councilmember Horvath.
Yeah, I think tentatively the District 3 community meeting will be Saturday, June 19th, 9:30 to 11 a.m. More details to come hopefully by next Tuesday. And I just wanted to congratulate Mayor Brand on the news that I read in the breeze. So,
Yeah, thank you, Councilmember Horvath. Okay, Councilmember Obaji.
All right, thank you, Mr. Mayor. I'd like to announce the June 5th cleanup that's occurring from 8 a.m. to 10 a.m. in the right-of-way, North Redondo cleanup. We've got volunteers, leads from District 5 and District 4. And I'd really like to thank Paige Brunt, a local resident, for helping organizing it and creating a flyer. But it says if you want to help, come out, be sure to wear sunscreen, put on a hat. And if you've got any shovels or de-weeders, bring those. Otherwise, Athens is going to provide trash bags. We got a lot of de-weeding to do, including on that newly improved stretch of the right-of-way on either side of Artesia Boulevard. There are weeds growing, tons of them growing there that need picking. So let's clean up our right-of-way. That's the first step to being able to plant new native vegetation like you see over my shoulder, and should be a great community event. Thanks.
Okay, Councilmember MD.
No, everybody's covered it. Thanks.
Oh, great. Yeah, I'd just like to tag off what Councilmember Lowenstein's was a great event yesterday. And it was just such an honor to honor a 103-year-old veteran. 103, I did the math. I go, that means if I make it to 103, it'll be 2060. So that's, it was really eye-opening. And he was spry and he was talking and he was excited. And he got presented a flag by a Marine Corps RATC chief here at Redondo Union High School. I talked to him briefly, and the funny story he told was he wanted to be in the Navy. He was actually in the Army, and he wanted to be in the Navy, and they wouldn't let him in because he said, I didn't have enough molars in my teeth, and they wouldn't let me in the Navy. I was very upset. This was like in 1939. So anyway, it was a lot of fun, and kudos to our Veterans Park Memorial Task Force, Tom Lasser, and everybody. It was really, really just another very small but demonstration of their dedication to keep that memorial going, and what a great group of people those guys are. So thanks to them. Anyway, and then we have a wonderful new hire of a new department, and with that, I'll turn it over to our city manager, Joe Hefkin.
Sure, this is introduction, probably more than an announcement tonight. We have a new community services director, Cameron Harding. It's his first meeting. It's been on the job about a week. Cameron comes to us from the city of Cypress, where he served as the Director of Recreation and Community Services. He's got 19 years of related experience, having worked in Orange County as well as LA counties with the city of Lomita. He's worked with the city of Manhattan Beach. He has a background in recreation and aquatics, a master's degree in recreation admin from Cal State Long Beach, a bachelor's degree in a similar field from Western Washington University. Cameron emerged at the top of the field from over 90 candidates for the position. So he lives local. He has a young family. We're very happy to have him here. Here at our meeting. We'll be in person at some point fairly soon, our first meeting in July. So with that, just wanted to introduce you to Cameron. A number of you have talked to him, met him. Cameron, if you want to say a few words.
Thanks, Joe. Yeah, just very, very excited to join the team in Redondo. As Joe mentioned, have lived in and around the South Bay for better part of 20 years and have worked in various cities in the South Bay, and have just been very impressed with the community services team in my 5 days on the job so far, and want to thank the council and Joe for the opportunity, and look forward to working with you all. So thank you very much.
Mm-hmm. Yeah, well, welcome aboard, Cameron. You've got some big shoes to fill and a lot of responsibilities, and a lot of people don't realize what community services director in Redondo, you've got, all the parks, of course, and all the community services associated with the parks, the Performing Arts Center, programming there, our transit, and not to mention our housing authority. I mean, you got a tall order, so I really appreciate you taking that on, and looking forward to working with you. So in case anybody doesn't realize what we're talking about, he is our new director of community services. He replaces a former director, John LaRock. So there you go. Anybody else wanted to say anything? I don't see any hands up. Anyway, thanks, Cameron, and thanks for coming on. I take it your email is cameron.harding@redondo.org. Okay. All right. With that, we'll move on to our regular agenda, I guess approval order of agenda. Are there any motions to make any changes or approve the order of agenda?
Motion to approve.
Second.
Okay, motion by Councilmember Horvath, second by Councilmember MD. I'll do a roll call vote. Councilmember Narenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
Aye.
And Councilmember MD.
Aye.
Okay, great. Now we move on to our agency recesses, or our agency recess. First, we have regular meeting of the Community Financing Authority. With that, I'd like to call to order a regular meeting of the Community Financing Authority. Roll call, please.
Member Nierenheim,
Here.
Member Lowenstein,
Here.
Member Horvath,
Here.
Member Obaji,
Here.
Member MD,
Here.
Chairman Brand.
Here. Thank you, Eleanor. I guess first up is our order of agenda. Is any motion to approve the order of agenda?
Motion to approve the order agenda.
Second.
Okay, motion by Councilmember Nierenheim, second by Councilmember MD. Are there any objections to their motion and the current order of agenda? Okay, with that, so ordered. Blue folder items. Are there any blue folder items?
No, not for this, not for the Community Financing Authority.
Thank you. Consent calendar, we have 4 items on consent calendar. There's the opportunity for the public to comment on any item on the consent calendar or any member to pull any item on the consent calendar. I'll go through the various members first. Are there any members of the Community Financing Authority that would like to pull any item from the consent calendar? Okay, I'm not seeing any hands with that. Is there anyone from the public who wants to comment on any item on the consent calendar for the Community Financing Authority?
I don't see any, Mayor, and
Motion to approve.
no,
Second.
Okay, there's a motion by Councilmember Horvath, second by Councilmember Nierenheim to approve the consent calendar for the Community Financing Authority. I guess I'll take a roll call vote. Councilmember Nierenheim.
Here. Aye.
Councilmember Lowenstein.
Aye.
I'm sorry, Member Lowenstein. I should say Member Horvath.
Aye.
Member Obaji
Aye.
and Member MD.
Aye.
Okay, do you need to read anything on the consent calendar, Ellen?
no, Mayor.
Okay, great. We'll move on to public participation on non-agenda items. This is the opportunity for the public to comment on any item that is not on the agenda. Again, this is the Community Financing Authority. Anybody sign up to comment under non-agenda items for the Community Financing Authority?
No, Mayor. No. No raised hand.
Okay.
And no,
With that,
no comment.
move on. There's no ex parte communications or old business or new business, but we do have a resolution item. I-1, approve resolution of the Community Financing Authority, Redondo Beach, establishing a regular meeting schedule and providing for matters related thereto. So, is any motions to approve this resolution?
So moved.
Second.
Okay, motion by Councilmember MD, seconded by Councilmember Horvath. Sorry, members. Is there any public comment on this?
I have none.
Okay, with that, I'll call for a roll call vote. Councilmember Nierenheim,
Aye.
Councilmember Lowenstein,
Aye.
Councilmember Horvath,
Aye.
Councilmember Obaji,
Aye.
and Councilmember MD.
Aye.
Okay. Do you
I'll
need to read that, Eleanor?
Yes.
Thank you.
Approve resolution number CFA-2106-01, a resolution of the Community Financing Authority of the Redondo Beach, California, establishing a regular meeting schedule and providing for matters related thereto. Thank you, Mayor.
Okay, thank you. Are there any member items or referrals to staff? Okay, I'm not seeing any hands up. So with that, I'll entertain a motion to adjourn to the June 15th regular meeting again of the Community Financing Authority.
So moved.
Second.
Second.
Okay, motion by Councilmember Obaji, seconded by Councilmember Horvath. Is there any objection? Okay, so order. We are adjourned from the Public Financing Authority. Next up is a regular meeting of the Redondo Beach Housing Authority. We were going to have a meeting of the Public Financing Authority, but that was canceled. So this is a regular meeting of the Redondo Beach Housing Authority. I'd like to call to order. Roll call, please.
Let's see, we need the 2 commissioners.
I'm here.
Okay, and I thought I saw Bogo saying, there we go. Okay. So Member Nierenheim,
Here.
Member Lowenstein,
Here.
Member Horvath,
Here.
Member Obaji,
Here.
Member MD,
Here.
Commissioner Linez,
Here.
Commissioner Vogoseng.
Here.
Thank you.
And Chairman Brandt.
Oh,
Here.
excuse me, and Chairman Brand.
Here. Thank you, Eleanor. Order of agenda. Is there anybody like to change the order of agenda or make a motion to approve the order of agenda?
Motion to approve the order of agenda.
Second.
Okay, there's a motion by Commissioner Lioness, seconded by Member MD. Any objections? Okay, so ordered. Any blue folder items for this?
No, Mayor.
Okay, thank you. A consent calendar. There are 2 items on the consent calendar. They'll be passed in one motion. Are there any comments from the public on the consent calendar for the Redondo Beach Housing Authority?
I have none.
Any member like to pull any item from this consent calendar? Any member want to make a motion to approve this consent calendar?
Motion to approve the
Second.
Okay, motion by Member Lowenstein, seconded by Member MD. I'll do a roll call vote. Member Narenheim.
Aye.
Member Lowenstein.
Aye.
Member Horvath.
Aye.
Member Obaji.
Aye.
Member MD.
Aye.
Member Vogelskane.
Aye.
And Member Lioness.
Aye.
Okay, well, there you go. You don't need to read anything, correct, Eleanor?
No, Mayor.
There are no excluded items. So public participation on non-agenda item. Again, this is a meeting of the Redondo Beach Housing Authority. Are there any members of the public like to comment on non-agenda items for this particular meeting?
I see none, Mayor.
Okay, thank you. There's no ex parte communications, public hearings, old or new. The new business is a status report on the Section 8 and fair housing programs. I guess, Cameron, are you going to give this report?
I am not. Actually, we have our housing supervisor, Angelica Zavala, on the meeting tonight, and she will provide the report.
Great. Take it away, Angelica.
Hi, good evening. Let me go ahead. Let me share my screen for this presentation.
Mm-hmm.
Okay, so this is a quarterly status report of the City of Redondo Beach Section 8 and Fair Housing programs for the months of March, April, and May of 2021. We currently have 445 program participants. 3/4 are seniors or disabled. Our current goal, as outlined in our agency plan, is to house 633 families. The challenges that we face to reaching our goal include rising rents, low vacancy, negative stereotypes about our program, poor landlord participation, and the fact that we are understaffed right now. The table on screen reflects the Section 8 activity for the last 3 months. We have 13 new contracts. We were able to renew 127 leases. 8 families permanently moved off the program. Now, the average monthly housing payment is $1,191, and this is the amount that the city, through its HUD allocation, contributes towards the rent of the program participants. And the total payments of housing support over the last 3 months was $1.572 million. The following are funding highlights with regards to the Section 8 program. In March of 2021, the Housing Authority received its calendar year 2021 funding award letter. Our Housing Choice Voucher Program and our VASH program will continue to be fully funded. Our administrative fee allocation was increased. This will enable us to focus on hiring staff as well as maintaining the daily operations required of the program. The Housing Authority received a little over $242,000 in supplemental administrative fee fundings under the CARES Act. And we are using this funding to create a healthy, safe, and sanitary environment for our staff and for our program participants for when we reopen. And I'm hoping this will be soon. And HUD continues to recognize our agency as a high-performing agency. Another highlight for us is the VASH program, which is housing assistance for veteran families. We received an allocation of 40 HUD VASH vouchers. We've already housed 27. Well, actually, we just housed another veteran this morning, so we're now at 28 veteran families here in Redondo Beach, and we are working to house the remaining 12. The increase in payment standard that we received has allowed us to secure better housing for our veterans. And needless to say, we are very happy to be able to participate in this program. And hopefully once we reach our goal of 40, we can request more vouchers to house more veterans. Last time that we opened our waiting list was in 2015. We have approximately 4,500 families on that waiting list. Any applicant who wants to check the status on their waiting list can call the Housing Authority, or they can call the number on screen, 855-361-9512, or visit website www.waitlistcheck.com. The Housing Authority continues to refer customers who need fair housing assistance to the Housing Rights Center. Persons needing assistance can call the number on screen, 213-387-8400. Their services include housing discrimination investigations, landlord-tenant mediation, and counseling services. And this concludes my report. I'm available for any questions that you may have, and I appreciate your time.
Angelica, before you stop sharing your screen, can you go back to your first slide where you talked about, or second slide, about our goal of 665?
Of course, let me go back.
Because I've seen, this goal hanging out there and we're far from it. And I'm wondering what the purpose of holding that goal out. Should we ever reduce it? Is there a reason to leave it there because of funding from the federal government? That's really my question.
Okay, well, what it is that HUD sets that goal for us. And I'm sorry, are you able to see my screen with that?
I can't see it. I just see a black space, but just tell me what the numbers are. You can stop sharing. Just tell us what the numbers are and then go from there, I guess.
Okay. Sorry if you cannot see it, but the goal is 633, and that goal is set by HUD, not by us. And that's because HUD sees potential in our city. Now we're at 445, and a lot of it has to do because we do not have the manpower, the staff to do everything that we can to pull people from that waiting list. That does require a lot of time, and we face, like I said, right now we are understaffed. We do have a lot of owners that are unwilling to participate in our program due to negative stereotypes, but we're hopeful. HUD sees potential in us, and I know that we are capable of reaching or getting close to that goal, given the tools that we need.
Okay. Do they provide more funding to hire more staff to, move this list along?
I just had this conversation with Cameron, and yes, HUD does pay for our admin fees, and we did discuss with Cameron hiring perhaps another full-time person. The budget that we have, it does allow us for one more full-time and one part-time. So that is something that Cameron and I did sit and discuss on what it is that we need to do to reach that goal or get close to that goal.
Well, I try to speak for the rest of the council. I'm sure we're all supportive of getting and assisting as many people as we possibly can if the federal money's there, and we have, we just need to hire more staff with more federal money. I would imagine the entire council and all the members here from the commission would certainly support that. So
yeah, thank you for bringing attention to that. Yes, I thank you for bringing attention to that. It's something that's on my mind, and now, like, I know that with the staff that we have, we're all committed, and we all believe we can reach that goal. But without the manpower, there's very little that we can do.
Okay, well, hopefully we can fix that. Councilmember Obaji.
I was looking at the number for the waiting list, 4,508. How quickly are we getting people off the waiting list? Let's say per year, how many people are getting off the waiting list into affordable housing? Ms. Zavala.
Affordable housing is different from Section 8. So for Section 8, there is a waiting list, and this waiting list was open in 2015. So right now, the average wait time is 5-6 years to get pulled from the waiting list.
So within 5 to 6 years, we would have cleared 4,500 people off of the wait list into Section 8 housing?
That would be great if we could. That would be great. I mean, the goal, the last time that we were able to pull people, and that's when I had more staff, was in December, and we were able to pull 200 families from the waiting list. From those 200 families that we pulled, we were only able to convert 15 into Section 8 families, and that's because the requirements to becoming part of the program, they need to be residents right now, they need to be disabled or have a family, they need to be under a certain bracket of income. So it becomes complicated. So it's not just a matter of calling and pulling people, it's making sure that they're eligible. And then
residents of Redondo Beach when
right now, the preference, or the people that were being pulled, are people that are Redondo Beach residents and they're elderly or disabled. So they need to meet those two preferences.
Got it. And when you said that about $111,000 would be going towards promoting I don't get your exact phraseology, but promoting a healthier environment among the housing authority personnel, what would that go towards? Is that like hiring one additional person, or is that like a new office space? I can't imagine you could buy a new office space for $110,000. So.
We've done several things in the housing authority. For starters, we do plexiglass all over. We did buy a lot of masks and to sanitize. We did look into redoing our shelving. We're also looking into going digital. So we did purchase software that will allow us to do remote inspections, as well as we do want to look into converting our files into digital files. That way our staff can work from home if ever the need be. Throughout the entire pandemic, we've been coming to work, most of us, with 1 day working from home, and that's because our files are paper files. So the next step is for us going digital. That way we have less people touching files. We can access them from home or wherever it is that we are.
Okay. Thank you.
Mm-hmm. And thank you for your questions. I appreciate the interest.
Absolutely.
I had another question.
Yes.
Escaping me, Angelica. So we're working on clearing that list, and I guess what a lot of people probably don't realize is the work, and you described, that goes into qualifying somebody and actually issuing, a Section 8 voucher. Is not just being on the list and getting your name called. You now have to get income qualified and a lot of other things. But you mentioned something interesting, that preferences Redondo Beach residents. I thought when the list opened, you could be living in Alaska and apply for Section 8 in Redondo Beach.
And you can. It's only that when the list is sorted, we do give certain preferences. So we give preferences to Redondo Beach residents. We give preferences to elderly and disabled. We give preferences to veterans. After we call everyone else. So everyone can apply for the program. However, the people that have those preferences are towards the top of the waiting list.
Okay. And the ones that live in Alaska are at the bottom.
Oh, they're welcome to apply as well.
But you will get to them.
We will, hopefully. Hopefully we will get to them.
You open the list once it's cleared, as I recall.
We do want to open the list once we start reaching, maybe once we go down to 2,500, we can reopen that waiting list.
I see. Okay. All right, great. That's good information. I don't see any more questions. Are there any more members who'd like to ask any questions? I don't know. Is there any member from the public who'd like to comment? Eleanor, you're muted.
Yes. No e-comments and no raised hands.
Okay. Well, I guess this is really just a receive and file item. I guess I'll just entertain a motion to receive and file.
Motion to receive and file.
Second.
Okay, motion by member Obaji, seconded by member Lionez. Any objections? Okay, so thank you very much, Angelica, and welcome Cameron to the Housing Authority. So,
Thank you.
Thank you very much.
Thank
Any
you.
referrals to staff? Member referrals to staff. So with that, I'll entertain, well, it looks like Councilmember Obaji, you have a referral to staff?
No, I just want to say thank you to Ms. Zavala because our residents in District 4 have really appreciated working with you at Breakwater Village in particular, and commend you for your great work. So thank you.
Thank you.
So the next scheduled meeting of the Redondo Beach Housing Authority is on Tuesday, September 7th. So seeing no more comments, I'll entertain a motion to adjourn to that date.
So moved.
Second.
Okay, motion by Councilmember Obaji, second by Member Horvath. Are there any objections to us adjourning? Okay, thank you very much, Angelica and Cameron. Moving right along. Now we'll go back to the regular meeting of the City Council. Roll call, please.
Councilmember Nierenheim.
Here.
Councilmember Lowenstein.
Here.
Councilmember Horvath.
Here.
Councilmember Obaji. Councilmember MD.
Here.
Mayor Brand.
Here. Thank you, Eleanor. Blue folder items. I know we have some blue folder items for tonight's council meeting. Did you want to list those for us, Eleanor?
Yes, we have some public comments for public participation in non-agenda items. For our public hearing L1 for Fire Lane Unit B, we have staff presentation, proponents presentation, appellant's presentation, and public comments. For L3, which is related to the budget for fiscal year 2021-2022, and the CIP is the fiscal year 2021-2022 budget presentation and public comments. That's it, Mayor. Thank you.
Great. Is there a motion to admit those blue folder items to the record?
So moved.
Second.
Okay, motion by Councilmember MD, seconded by Councilmember Nierenheim. Are there any objections to admitting those items? Okay, hearing none, so ordered. Next up is our consent calendar. These are items that will be voted on all at once unless any item gets pulled. We have 19 items on consent calendar. I'll go through the council, see if anybody wants to pull anything, and the public will be more than welcome to comment on any item on the consent calendar. So Councilmember Nierenheim, do you have any items you want to pull?
I'd like to pull item H8, please.
H8.
And H10 as well. Thank you.
H8 and H10. Councilmember Lowenstein.
No, I was going to say H8, so no, thank you.
Councilmember Horvath.
No, thank you.
Councilmember Obaji.
No, thank you.
And Councilmember MD.
No, thank you.
Okay. Eleanor, other than items H8 and H10, are there any public comments?
Okay, let's see. I have, H16. I'm not sure if someone from the public would like to speak. I'm looking.
Eleanor, H16 and H19, the two participants for those items were only in attendance in the event the council had questions.
Got it.
Those items, they're not going to be.
Okay. Great, thank you. I have.
So no public comments then about the other items?
Let me just double check. Vicky? I don't think we have any.
No, we don't have anything until J1.
Okay, great. None.
Okay. With that, I'll entertain a motion to approve the consent calendar other than items H8 and H10.
So moved.
Second.
Okay, motion by Councilmember Horvath, second by Councilmember Nierenheim. I'll do a roll call vote. Councilmember Nierenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
Aye.
And Councilmember MD.
Aye.
Okay, Eleanor, I think you got to read a
Yes.
couple of things. Yeah.
Yes. Okay, starting with H11, adopt by title only resolution number CC 2106-046, a resolution City Council City of Redondo Beach, California, claiming Sunday, September 12, 2021 as Open Water Swim Day in the City of Redondo Beach in sponsorship and support of the third annual Swim the Avenues Water Sports event to be held in the City of Redondo Beach coastal waters, and in appreciation of the County of Los Angeles efforts to permit the event and provide logistical support. H13, adopt by title only resolution number CC-2106-047, a resolution City Council, City of Redondo Beach, California, awarding a public works contract to Pavement Coating Company, a California corporation, in the amount of $720,725.75 for the construction of the citywide slurry seal project phase 2, job number 41140. H14, adopt by 4/5 vote by title only resolution number C-2106-048, a resolution City Council, City of Redondo Beach, California, authorizing a fiscal year 2020-2021 budget modification to transfer $173,701 in the wastewater maintenance and operations funds and appropriate $183,569 in vehicle replacement funds to the City Public Works Department 2020-2021 fiscal year operating budget, Fleet Services Division, Vehicle Equipment Account. H16, adopt by title only, resolution number CC-2106-049, a resolution City Council, City of Redondo Beach, California, leasing certain property to Sunrise Harbor LTD. Have one more. H17, adopt by title only, resolution number CC-2106-050, a resolution City Council, City of Redondo Beach, California, approving the suspension of preferential parking hours in the Vincent and Vincent II preferential parking districts for limited hours on June 10th and June 11th, 2021, due to commencements and graduate ceremonies. Thank you, Mayor.
Okay, thank you, Eleanor. Item H8, Councilmember Narenheim, you pulled it?
I did. Thank you, Mayor Brand. Joe, I got a couple questions on this. When did we, I know you called us, or called me at least, and mentioned this, but you said it would come back to the council. And I don't remember this item ever coming back to the council for discussion and the rates regarding this item, $290, I think it is, per inmate. Like, what's the history on this? Why are we doing this?
You know, there's a little bit of a backstory on this. The city of Palos Verdes Estates was looking at a variety of potential contract arrangements previously. It ranged from pieces of their department to the potential to contract with another agency, the Sheriff's Department or the City of Redondo Beach, for all of their services. And for staff-to-staff conversations that happened, I advised you that these were happening, sort of weren't sure where this was going to go. Chief Kaufman was very involved with this, obviously. The discussions focused on kind of their most pressing need, which was their jail services. And through the discussions, we wound up with what we think is a mutually beneficial arrangement. And then maybe at this point, Keith or Joe, if you're on, if you want to kind of take it from here.
Sure. Yeah, so basically we had offered to Palos Verdes to kind of assess this. They came back to us with a pressing need for the jail. So this was parted out from the rest of any study we were doing. And then we came to the amount based on recovering the costs of what our personnel would endure by booking their arrestees. And then in the grand scheme of things, I mean, the way that we work in the South Bay, we're very collaborative with all the other agencies. So when we have requests from other agencies, we'll entertain those. Our neighboring cities collaborate with us on various programs, and so you know we try to be a good partner where we can.
Okay. How will this impact our operations? What's the process? This report doesn't describe anything really about. Do we go up there and pick them up? Do they drop them off here and then we book them and we have then responsibility of them? What does the responsibility look like if they get hurt? If they hurt one of our employees, and then how do they get essentially? How do they leave our jail?
Yeah, it's a great question. No, so we wouldn't have entertained this if there was a huge impact on our personnel or the ability or have it take away from any of our services that we provide. So this is something that we could easily absorb based on the numbers that they had given us with the current staffing that we have. The way this would work is instead of booking someone in Palos Verdes once they were under arrest, their officers would drive them here and book them into our jail. We would take custody of them. If something happened during the time that that person was in custody, let's say they needed a court appearance or they needed some type of medical attention, it's all on Palos Verdes. They have to send the personnel back to pick up the person from custody and take them wherever they need to go. And
what if they hurt one of our employees?
I'm sorry?
What if they hurt one of our employees?
Well, hopefully that doesn't happen. But if they hurt one of our employees, we'll use the force necessary to take them back to custody.
Yeah.
But, I mean, it's the cost of doing business. We can't. I can't put an estimate on that.
Who pays for that hurt employee is my question. Meaning,
Workers'
are we
comp.
absorbing that cost? Are we going to them? What does that look like?
No, that is, as far as I know in this agreement, that's going to fall under us. I don't think we're going to bill them for anything medical wise to one of the employees.
Okay, and
there's a pretty extensive indemnification clause in the back of that contract, and that's basically where that's what took the most time with this. So this contract was vetted by both city attorneys, and indemnification was obviously the biggest point of contention.
Right. I mean, I obviously we know about long-term injuries. And if someone were to have an injury resulting in a long-term injury, we're not paying for that long-term injury. I saw the indemnification, but that's a lot of legal mumbo jumbo in there. And
it would just go through the current workers' comp system that we do with all of our public employees.
And what if they call us and we say, hey, you know what? Sorry, we got Beach Life Festival. We have this for 4th of July. We're too busy. We can't handle you right now. What happens in that case if we have ability to say no?
Yeah, absolutely. They'd have to make other arrangements. And that does happen from time to time with all of our local jails. Sometimes there's issues with not having appropriate levels of staffing because of some need or something, and we can just make other arrangements. There's already a loose agreement in the agencies within the South Bay that we can book at another agency if there's a need. So there would be no problem with us if we had some rare occasion where we couldn't accept an arrestee. They would just have to take them someplace else.
Okay, that's all the questions. Oh, hold on one sec. And leaving our jail, they come and what does that look like if they want to leave or when they leave our facilities? So either they get bailed out or they go to sheriff. What does that look like? What is that process for them leaving us?
Yeah, so it could be many things. At this point in time, most people are being cited out of custody. So they would be cited out and released, or they would be transported to the sheriff's custody facility if they were going to remain in custody. Or they could post bail and be released that way. So it would be the same processes that we currently follow.
Okay, thank you.
Chief Kaufman, it seems like an awfully good deal to Palos Verdes Estates to me. That they don't have to have a jail now. They just if they need a jail, they now for what was it, $299 a night, just send their inmates for whatever. It was a drunk driving or something very, very serious. They don't have to maintain a jail now. They don't, I guess they were taken to the sheriff's. Maybe they weren't, but I don't know. And it seems like a very good deal to me. If I was a Palos Verdes Estates council member, I'd be thinking, okay, yeah, this is what we're going to do. We don't want to maintain a jail. Let Redondo do it. And then if you do read down to number 12 under indemnification, which, it is a lot of very technical legalese, but I read it. It says, to the fullest extent permitted by law, the city of Redondo Beach shall defend, indemnify, and hold the city of Palos Verdes Estates, its officials, officers, employees, volunteers, and agents free and harmless from any and all claims, demands, causes of action, costs, expenses, liability, loss, damage, or injury in law or equity to property or persons, including wrongful death in any manner arising out of or any incident to any acts, omissions, negligence, or willful misconduct of the city of Redondo Beach, its officials, officers, employees, agents, consultants, and contractors arising out of or in connection with the performance of this agreement and rising to a level of legal liability, on and on and on and on. So that like makes me worry. And I don't know when that sentence ends. Looks like about another 250 words. It worries me that we could take one of their drunk drivers, whatever, could be having, an event of some sort and could die in our jail. Let's just go right to the worst case. That's what insurance is for. And all of a sudden the family's suing everybody. And we wrote in this contract an indemnification of the city of Palos Verdes Estates when their officer may have done something to contribute to this person's death who's now in our jail. I know it's, an outside chance, but this is why we have insurance and, these things do happen. So, how do you respond to that? You're comfortable with this? Because you heard what I read and it sounds like we're responsible for whoever they bring to us.
Yeah, well, these were the same questions that were asked by the city attorney's office as we went through this contract, and they looked into the insurance coverage that both cities have. We're under the same pool, so things would be deflected from one to another in that case. But yeah, there's no doubt there could be something that could happen. That's the nature of the business that we're in, and it would not be right of me to say there's absolutely no risk. There's always a risk. But the reason that we entertain this is they asked, we can do it with the current level of personnel and housing capacity that we have. Part of what we do to protect Redondo Beach is also assisting our neighbors. We've had lots of talks about this, and I don't want to see people not booked in Palos Verdes because of staffing issues, where there could be an effect on Redondo Beach. So in the big picture of cooperative policing, that's why we would entertain something like this. It is a small revenue item for us. We're estimating that somewhere in around $29,000. That's a huge number, especially if something should happen, but it's something that we could do with our current staffing. But again, that's why contracts come to council.
Mm-hmm. Okay, that $29,000 figure, is that something we get regardless?
So that's an estimate. They're estimating approximately 100 prisoners at $290 a prisoner. So that would be a revenue item you would see in the upcoming budget. There's no guarantee. Sometimes bookings go up, they go down. That's just an estimate.
Yeah. And how long is this contract for? I'm sorry, it looks like it's good for just a year. So if you make some changes or make some, see some things you need to add, like it seems to me like it's just, I don't know what you call it, but just like a participation fee. The fact that we're here, we should pay some small amount to.
Yeah. That's something that could be negotiated later. Generally, when public safety is looking at costs of something, we don't look at it as a revenue source, more of a recovery of costs. So that's really where the estimate comes from. Mm-hmm. But yeah, there's no doubt. They're going to be able to decrease their non-sworn staffing in Palos Verdes, but we all know that they're having issues with that. So this was a potential remedy. They have a small holding facility there that they will keep and maintain. They just won't staff it 24/7 like they do now.
Mm-hmm. Yeah, I just would be mindful of proper cost accounting. That we have costs associated with this, including carrying costs of our jail that they should probably participate in. To some extent, and maybe that's worked into your figure. So anyway.
Yeah, we have with 30-day notice, we can cancel the contract with them too. So.
Mike Webb has his hand up. Go ahead, Mike.
Yeah, just to address your concerns, the paragraph you read was if Redondo Beach is responsible. The section right after that is where PV Estates indemnifies us for willful acts, or if they direct the actions that our employees take. But this was not the wording of the indemnification that we wrote. It's they rejected it. We took a harder line for the initial draft, which was done by Christine Shin, and they rejected it. So if you have concerns that outweigh the public safety benefits, because this is essentially a public safety benefit of if you have a neighboring city that can't adequately police its city, then it's definitely going to spill over to us. The financial benefit isn't great. As the chief said, it's capped out at $44,500. If they have many more, it's for a 1-year agreement, or if they, once they spend $44,500, it ceases. So certainly, it's the council decision. It's likely not to they're not likely to enter into agreement, but the council could say, no, we want, tougher indemnification language, and then we can send that message to PV's estate. So this is the time for the council to make a determination. I think the chief's done an excellent job of explaining the public safety concerns if we don't do it. And you've done an excellent job of sharing our concerns, or expressing our shared concerns with the indemnification language. We could live with this, but there's certainly a risk. And, the hypothetical that you and Councilman Nierenheim gave, the simple answer is we're both going to get sued. And we're going to, try and determine if it's our officers or jailers' fault, then we're going to own it. If it's something that their officer did, then they're going to own it. And it's a very fact-intensive decision as to who's at fault.
Yeah. Okay, thanks, Mike. Thanks for that clarification. Councilmember Obaji.
Yeah, thank you guys for answering all these questions. Quick question. Do we know how much the city of Palos Verdes Estates has gotten sued for police misconduct or anything like that? As far as, kind of what's the liability quotient for partnering up with them in a deal like this?
I don't know the answer to that, but I do know that they've got an excellent policing reputation. They're seen as a very professional agency. I don't have any qualms about partnering with the city of Palos Verdes for anything regarding policing.
All right, that's helpful. And to what extent do we think that this $289 or whatever the figure is per inmate or booking is negotiable? Was that like, their final last best offer essentially?
No. we again, we're not in the business of making money. We're in the business of public safety. So
well, I get it, but we are eliminating, right, an employee or two that they're going to have to keep to run a jail cell, right? So that's a significant cost savings. I just feel like they could pay more than $289, not for the purpose of us paying money, but I understood from our conversations that we need to rehire a new jail officer or somebody who's going to work our jail. So we're gonna carry a hefty cost, and I feel like that they might be able to bear a little more of that. So anyhow, I'd be interested maybe potentially to approve this with the caveat that the price gets bumped up to $350 or something like that. But I don't want to dwell on it too long. It's not that significant of a number, but I'll leave it to y'all. Thanks.
Okay, are there any comments from the public on this, Eleanor?
I have no hands raised, but there is an e-comment. Vicki, if you would like to read that e-comment.
Yes, submitted by Leslie Campeggi. The indemnification language cited doesn't pass the smell test. Further examination needs to be done by the council before approving this. and especially since this proposed program wasn't given to City Council for copious review. Let that happen first before making any decisions. Small revenue item with too much exposure to liability and risk. That concludes the public comments.
Okay, thank you, Vicky. Going on to section 12.2, it says, to the fullest extent permitted by law, the city of Palos Verdes Estates shall defend, indemnify, and hold the city of Redondo Beach, its officers, officials, directors, shareholders, employees, consultants, contractors, and agents free and harmless from any and all claims. It's the identical boilerplate language that I read earlier. So there's like 2 indemnification clauses in this contract that, yeah, it's not a risk-free proposition, as Chief Kaufman has said. And yeah, we want to be helpful to our neighbors, but Councilmember Obaji makes a good point. Saving them a lot more money than we're making. So anyway, is there a motion, or Councilmember Nierenheim?
I'll make a motion. I just want to, next time for something like this, I can approve this now for a 1-year term, see how it goes. But this is something that we need to bring back in closed session to talk specifically about public safety on a regional basis. If something like this is worth it, and then we can come back to an open session and then discuss the cost accounting, what it costs us. So I don't like this being so sprung on us, so to speak. Like I said earlier, this was never talked about as a council level. So I'll make a motion to approve this item for 1 year and 1 year only, and to be reviewed again in 1 year from now.
City Attorney Mike Webb, this probably wouldn't qualify for closed session discussion.
Yeah, that's what, unless you're talking about specific threats to public facilities, that sort of thing. And so that's why I raised my hand. But the other thing is, don't feel the need to approve this if you don't feel comfortable with it. I don't know, Chief, if when they need to know by, but this is your opportunity to weigh in on it. And there are many things you could do. We have nothing to do with the business terms. You could direct, staff to return with different business terms. But as the chief has explained, this really isn't, it's not in the business of raising additional funds. It's in the business of making certain we're safe in our city, and regional, neighboring cities is part of it. You can direct us to strengthen the indemnification language and go back to the first language that we drafted. But in conversations with the police department, it was pretty clear that that wasn't going to be make the deal go through. And the difficulty with any of these deals is everybody is fine with owning the acts of its employees. The question becomes, if we're not sure whose employee caused it, if it happened out in the field by a PV officer, they should own it. If it happened in our jail because of misconduct by our jailer, we should own it. And the question becomes, how do you determine which it is? And if you try and make them responsible for actions of our jailer, which is the way we wrote it initially, hey, we're not in the business of providing jail services for other cities. You've got to own anything that may happen, whether it's our employer or not. Well, I can understand that would be unacceptable to them, that our officer or jailer could do anything and they're responsible. They're responsible for it. But we can push back. I would just say, maybe just continue this for a week to have further discussions with the city manager or Chief Coffin and make certain you're comfortable with it.
Well, personally, I think you should indemnify anybody they bring to us, period. I mean, even if it is our officer misconduct, because it wouldn't have happened if they hadn't brought us that person.
So that's the way we wrote it. That was not acceptable. And if I were their attorney, I wouldn't be jumping at the
Right.
chance to,
And then it's like,
to recommend.
everybody's going to know that. And then, yeah, it's complicated. Okay. Councilmember, anything else, Councilmember Narenheim?
No, I'm going to listen to Mr. Councilman Abaji.
Is there a second to Councilmember Narenheim's motion?
I'm going to withdraw that motion and kind of redo that motion for that.
Councilmember Abaji.
I can see why the indemnification language is written as it is. I think the real risk is if they do something in the field that only starts to become apparent once the person's in the jail cell, and then we get blamed for it. But in any event, Chief Kaufman, how much of an opportunity does Redondo Beach getting contracted by Palos Verdes Estates present as a chance to essentially enhance the quality of our size of our police force, resources that our police force has, etc.? I mean, is that the thought here, that this is kind of like the beginning of a working relationship that could end up with us, growing essentially our ability to police and our force?
There is always that potential. Those were some of the initial talks. This happened to be one of those menu items, but we did a dispatch study with them as well. So there's other things that they are interested in. So it could lead to that. This particular item, though, doesn't support that notion that our police department would be growing or we'd be increasing.
Right. I get that.
It's just something where we would absorb.
All right. I'll make the motion to approve this contract, subject to the amount per inmate or day in custody booking being changed to $500. And the reason I say that is they only have 100 in custody bookings approximately per year. I understand it. That would be what, 5,000? Let's say 500, $50,000. $50,000. There we go. Yeah. And that's still cheaper than one single employee with all the benefits and the like. One, employee, but it takes more than one employee to man a jailhouse. So that would be my motion. It takes 2 or 3 employees. What do we think?
Can I ask a question? Do you want to leave the cap at 44,500 in the contract?
Let's make it 50,000. Cap at 50,000.
That would make sense.
And that cap is, if we get 101, that 101st booking is going to be free.
Yeah.
No, we no longer have to take it because the contract ends the minute. That's why I kind of wanted to, based on the math that you were using, the contract ends in 1 year, or the sooner of 1 year, or when they reach. Right now, it's written 44,500 in reimbursable agreements. The way in practice, I think what happened is Chief Kaufman would, anytime we got close to it, approach them about, do we want to amend the contract to, because you're going to, the contract's going to end of its own accord once we reach that.
I'll second that motion, for the reason being that doesn't seem like they want to take on more of the risk of indemnification. And if something happens, we're not here to make the money, but we are. But if one of our employees gets hurt for long term, it's going to be a fair amount of change. So this could be a good trial run for now.
There's a motion in the second, and
Chief
put a little bit in the context. I know they've had issues in Palos Verdes Estates with funding some basic services, and if I'm not mistaken, they had to pass a special assessment on properties to keep their own police department. So maybe I'm wrong about that, but I think I'm close to what happened. Anyway, Chief Kaufman.
Yeah, I just wanted the council to realize they also looked at other agencies to do this. So they've reached out to Torrance, they've reached out to the sheriff. I think the sheriff gave them a price of $245 per inmate. So that will probably weigh into their decision when we come back to them. I just wanted you to be aware of that. And the reason that we're more attractive at a higher rate is obviously distance and relationship. We're closer. So the longer they can keep their officers on the road, the better it is for Palos Verdes and us.
And what was the indemnification like with the county and and Torrance?
I don't know. I didn't get to see a fully executed contract with them. Those were just quotes that they got.
Okay. Councilmember Lowenstein?
Yeah, is this just as simple as just raising it to $500 for inmate and then seeing if they accept it or not, and that's it? Nothing more than that? No further negotiations, Mike? Or is it, you know, you got to go through the whole round again? Because I have no issue with raising it to that level, but is it basically, okay, we've signed off on it, here it is, and take it or leave it kind of thing?
Yeah, you'd be approving the contract and authorizing the mayor to sign it at 500 per. Based on what Chief Kaufman said, that will probably never come to fruition. They will probably choose the sheriff or Torrance. And I would think that, to answer Councilman Nierenheim's question, I think at least for the county, my guess is that they have very similar language in it to what is in this contract. As you'll see in the next item that was pulled, where both parties indemnify each other for the acts of their employees.
Okay. Okay, that's it then. That's my main question.
Okay, did you have a comment, or Councilmember MD?
I get the concerns, and I think that if we just put it as a 1 year cap just to see how this goes, this could be an avenue in which you find other ways where we can have some synergy and start that relationship to be able to find some cost savings in other areas when you start working together. I would like us to just take the chief's recommendations now, and if you want to cap it at 1 year and then we can reassess it, that's fine. But I say we go forward with what the chief has recommended at this time.
Was that a substitute motion?
I think I'll try. Yeah, I'll make that a substitute motion.
And by the way, the contract is just to May 31st, 2022 already, correct, Chief?
Sorry, I was muted. Correct.
Yeah, it's already at 1 year. So, okay, but that's a motion. Is there a
Yes.
second?
I'll second that.
Because a substitute motion and a second. And there's no public comments other than that comment you read, Eleanor?
No more public comments.
Can I offer an amendment to her substitute motion?
Yeah, go ahead.
All right, let's make it based on information the chief shared at $325 per inmate.
Let's make a deal.
Yeah, no, I mean, look, the chief's not in the business of money, but we are in the business of funding our police department and finding dollars for our police and fire department and public safety program. So
are they.
We're not going to compete on price with the county. All right. Well, it's not the county, not Villanova's sheriff's department. We are going to compete on quality, and they know that their inmates are going to be not in a jail cell that has been investigated by the FBI and prosecuted by the U.S. Attorney's Office. All right. This is Redondo Beach. This is a premier police department. They're going to be in good hands. They pay a premium for our jail cell.
And so is Torrance. I mean, Torrance is just the same thing. So
Do you know what Torrance offered, Chief?
I don't recall. It was in that ballpark. I know that.
Which ballpark? The 350?
The 245 ballpark.
245.
Sorry, not the 325. The 245 ballpark, I think, is where it was.
I feel like I'm trying to cross the border and bartering.
And look, it doesn't matter to me. I have no horse in this race. It does not matter to me whatsoever. I just think, based on what I know of how our police chief works, I think I'd like to support their efforts to try to create this relationship. So that's it.
Withdraw.
You don't support the amendment, and then therefore.
I'm open to it, to get us to a vote, but.
Okay, well, you either accept it or you don't, Laura. We need.
I'm going to say no.
Well, I think saying no, it said he withdrew it.
I would
after listening to him.
Oh, okay. Councilmember Nierenheim has his hand up again.
I mean, my concern is not the price; it's the indemnification portion of it. And if they don't want to indemnify more, because I'm one of our employees, I see these long-term injuries coming in, and someone's in jail. They don't want to be in jail, and I can only imagine what it's like. You get somebody who comes in, And especially this day and age, you know, if there's a long-term injury, we're going to be paying for that. And that's my concern. And I want to work with the other agencies and departments. And we'll never be able to compete with county on the price, but our food is better. And so
buy it from the county.
And honestly, if it was another city that maybe I'd have a little more concerns with, but it's Palos Verdes, guys. Come on.
What, they have better quality criminals?
Chances are there are Redondo Beach teenagers going up there going to parking in their parking lot, you know, using substances, and that are going to get put back into Redondo. So I mean, it just, but whatever.
I as long as for a 1 year term, and you know, what I want to see is a full report on this next year, so we don't just come back and approve and approve and approve. You know, the pricing, how many times we've been full, how many times we've had to deny someone. You know, again, how many incidences we've had long-term costs, because $290 just seems, including insurance and indemnification, is a lot of money. I mean, not a lot of money. It's cheap. And I mean, yeah, if we can find some synergies, I hear what you're saying, but I am worried about the long-term cost. So I'd be willing to go along.
I'd accept that amendment. We can include a report in the motion. That's be fine.
Yeah. Thank you.
So, for the next time this comes up in a year.
Yeah. With those items, you know, the issues that we've had, the bookings, amount of volume, if you had to deny anyone, any employee injuries, you know, risk assessment. I think it's very prudent for us to be able to have that report so we can make a better decision next year.
Okay, so that was a friendly amendment. You accept that friendly amendment?
I do.
Yeah.
Okay.
To me, this is one of those cases where it's not a problem till it's a problem, and then it's a big problem.
Yes,
So,
exactly.
You know, I grew up there, and there was an incident where some cops got really beat up.
Yeah, the other thing, if I may, you may want to build in an earlier review date, not to wait until May of next April, but to bring it back in January. You know, we'll have 6 months of 6 or 7 months of this service, and kind of
maybe bring it back at mid-year, Joe, something like that. Ask them to bring it back at mid-year.
Well, I don't want to do mid-year, Mayor Brand, because I'd do something like April, because then we get the majority of the year.
Okay.
Or March, April, May. So end of April, third meeting in April. Because that way, if we need to amend something in the contract, we have enough time. 3 council meetings in May to deal with PV estates if we need to, and go from there.
Okay. So
I'd
early
be fine with
April.
that.
All right, fine. Early April.
Yeah.
Okay, so there's a motion and a second and a friendly amendment. I don't see any more hands up. Any more public comments come in, Eleanor?
No, Mayor.
Okay, I'll call for a vote. Councilmember Nierenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
Aye.
And Councilmember MD.
Aye.
Okay, there you go. Do you have to read that at all, Eleanor?
No, Mayor.
Okay, thank you. Next consent calendar item is proposal item H10. Again, Councilmember Nierenheim.
Thank you, Mayor Brand. Yeah, so my question on this is, I noticed we're using CDBG funds on this, $8,000 roughly of CDBG funds, H10 here. And $10,800, almost $11,000. So let's just call it 11 grand for CDBG funds. That's coming out of the 21-22 budget, and LA County is matching us for that money as well. It's going to cost roughly $22,000. I want to make sure, since we're using our money that's coming to us, as we have a housing authority, our hard-earned CDBG funds from the feds, that we're not taking on other cities, because now we're going to be subsidizing this program for other cities to use. And I'm going to have I'm really concerned on that. So that's what I want to talk about here for a minute. It is, no other cities are using this program right now, and they are not asking to use our program. And if they are, they're going to be paying their fair share. Yeah. Who's that question go to?
I could take first stab at it. So no other cities are using our program. These are people that are facing criminal complaints in the city of Redondo Beach that that we are mitigating through homeless court. But the statement of no other cities have asked, that would not be true, and I'll let Mike take it from here.
Well, and it's not true because the last meeting you approved an item in terms of exploring, but with expressing similar concerns. Manhattan Beach is request to explore homeless court and using our homeless court, and for us prosecuting state misdemeanors that would need the district attorney's approval since they're not a charter city. And you gave approval. Manhattan Beach did not get to that item that night, so they're discussing it tonight. We have had a request from Hermosa Beach that we do provide prosecution services. And so, we're currently exploring what that would look like. And I'll certainly, return with a contract amendment if you wish to go forward with that.
So what would that look like? Since we're using CDBG funds, we have to go through this process in April, May and in fact, I think leave tonight, I want to say, part of the budget. So if we get money back, is that going to be an issue, Joe?
Well, we would, if there's a partnership agreement with one of the other cities, we can specify where the money goes to if we're receiving funds, to the extent that they're reimbursing CDBG related costs, then we would need to take that money and use it on another CDBG related eligible item.
So we can move that money around that. So if we get $5,000 from another city, we can move that CDBG to another.
If the contract's written that way, otherwise it would just defray our general fund expenditures.
And that would be like, for example, if we amended the existing contract we've had with Hermosa for a number of years, we can amend it to specify that. And it's way too early to decide whether or not it makes sense for us as well as sense for Manhattan Beach to do something. But Hermosa Beach, more sooner rather than later, I'll return with something for you to consider since we provide active prosecution services to them now. And many of the homeless are shared homeless, they may be they may, whether they're Hermosa or Redondo, the South Bay, it may vary on the day of the week. So
just take the bike path.
Yes, exactly. So it's something I'll return to you with before, but for the entire existence of homeless court up to and through this month, it has only served people who've been charged with committing crimes in Redondo Beach.
And we're busy enough at our homeless court. We've got, a whole morning long with lots of people that we're doing. We're not running out of clientele, so to speak.
Well, we hope to eventually. So
right.
As Councilman Abaji went through the numbers, we have in the first 5 months of this year, we've taken 38 people off the street and 18 of them have become permanently housed. If that sort of success proves to continue, we may become less busy, and we eventually may reach the point where we don't need some or most of the enhanced response. That's the hope.
And if we would get to that point, we could. If we need to move the homeless court, if we could work with other cities, then I would say move it to a different location. But I am, like you said, I'm not interested in really hosting other cities until we start having a decrease in clientele and it's becoming, we don't have a need for it. Take care of ourselves first. That's what I'm worried about.
Understood. The goal is that every city take advantage. You have Long Beach, which has already moved forward with plans on having a homeless court and a pallet shelter based on our model. Torrance is discussing tonight pallet shelter, but not homeless court. I had never talked to them about that, but I could see a model where, we might,
round robin.
Yeah, well, or even we do homeless court and they do more pallet shelter beds that Redondo Beach Bowl could. I could see a regional approach, and like all of it, I don't want to have
not regional, South Bay approach.
Yeah, South Bay. That's what I mean.
Beach cities.
So, South Bay, and I don't want to say no until you're looking at specifics, because I wouldn't have envisioned many of the things working the way they do. But I also don't want to become, try and solve all areas homeless problem. We can't. And if we can, work to first and foremost to address the Redondo Beach homeless, we do. If we can reach partnerships that address the beach cities without an undue impact on us, then that makes sense to at least explore. But as of right now, it is only our homeless court. We got approval from the LA Superior Court to continue homeless court for another fiscal year through June 30th of next year. This contract provides it's good until 2026, and the sheriff just does stuff on their own timetable. So we had approval initially to run it from September of last year through August of this year. But because the sheriff raises their rates each year, they said, nope, we won't do it past June. And we have to do that contract to be able to have homeless court in July. But, you have a 60-day notice to end it if we ever, reach the point where we no longer need to do homeless court. But this is essential that we need that in order for the sheriffs to agree that they have adequate protection for the judge. And we need it to go along with the council's previous direction to continue to enhance response to homelessness, through the next 4 years at least.
Yeah, and what you just said is something that I agree with. We can do homeless court, and then they do some more shelter programs over there. They have that large county lot over there for the courthouse, a lot of blacktop. So, so until we make great strides here, they can have, we can work those kind of things out. That's it. Thank you.
Well, it seems to me like that's a perfect spot for both, really, because the court is right there. So, we could help fund it, certainly. But anyway, and the Torrance bus line goes right there. So, anyway, is there a motion to approve this?
Well, public comment first.
Is there any public comment?
No public comments, Mayor.
Thank you.
All right, I'll make a motion to approve item H10.
Second.
Okay, there's a motion and a second. I'll do a roll call vote. Councilmember Narenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
Aye.
And Councilmember MD.
Aye.
Okay. Great. You don't need to read that, do you, Eleanor?
No, Mayor.
Okay, great. So our next item then is public participation on non-agenda items. This is the opportunity for the public to speak on anything that does not appear on this agenda. Everybody gets 3 minutes, normally limited to 30 minutes, but usually don't take that long anyway. So with that, Eleanor, how many people do want to comment on non-agenda items?
Okay. I have, right now I have 2, and I think we have 1 on e-comment, and there might be a couple more.
Okay.
If they raise their hand, I have them. Okay, so the first one I have is Sandra Siegel. Go. Sandra.
Hello, my name is Sandra Siegel. I'm a 34-year resident of and 28-year homeowner in Redondo Beach. I'm a lifelong environmentalist. Like most residents, normally I don't pay much attention to what's going on in city council meetings, but I have been paying attention lately. I have a background managing government money for nonprofits, and I checked into the $18,316.50 of taxpayer funds, which were sent to the nonprofit South Bay Parkland Conservancy, or SBPC, for the Wilderness Park project. Here's what I found. 9.8% of the money went to a corporation whose CEO is on the board of SBPC. 36.5% went to an individual who is on the advisory board of SBPC and who came up with the idea of the Conservancy project at Wilderness Park. 53.7% went to a corporation whose CEO is the president of SBPC and who is a commissioner who serves on the Recreation and Parks Commission and who is the very commissioner who made the motion to fund the Wilderness Park project. That adds up to 100% of these taxpayer funds ultimately going to individuals very closely related to the nonprofit. I have documentation of everything I've said, and I'm happy to share it with city management. When a separate financial entity is inserted between City Hall and the ultimate recipients of taxpayer funds, it is very difficult for the people paying the bills to know whom they're actually paying. It would be very easy to blame staff, but the problem is that running these expenses through the nonprofit obfuscates the identities of the payees. This mayor and council have created the type of environment which leads to this kind of problem. Just recently, this same nonprofit came before you with a new project for another $53,000 on another parcel of public land. In this case, they even drafted rules for how residents can use this public parkland. Despite being begged by residents to let city staff perform their due diligence, 4 of you insisted that the project move forward with no review by the professionals. This feels like a shadow government which makes rules about how public lands can be used, prioritizes the spending of taxpayer funds, and then turns around and hires themselves to do the work. And what about the donors? The people who donated money for the Wilderness Park project thought they were paying for that project. If the city paid for the project, what happened to the donations?
Okay, thank you. Next up, Ellen.
Okay, next person is Maggie Healy.
Good evening, Mayor and Council members. This is Maggie Healy, lifelong resident and retired Redondo Beach management employee of nearly 30 years. Please explain to the public why the City Council is not following its standard policies when it comes to partnering with the South Bay Parkland Conservancy. You have a policy and guidelines for public-private partnerships that were adopted 10 years ago when the mayor was on council, and it has been applied since then to all other volunteer groups who want to perform projects in partnership with the city. For the last 10 years, the city has made organizations such as the CERT, Community Emergency Response Team volunteers, Leadership Redondo, public art groups, and the Veterans Memorial Task Force comply with the guidelines stated in your policy. Those guidelines are there to protect the city and its citizens and assure a good outcome by requiring a memorandum of understanding that addresses things like public input on scope of work and design, appropriate liability insurance and indemnification, and oversight and accountability for project funds. Yet we have none of those protections with South Bay Parkland Conservancy. There's no agreement, no MOU, no guidelines at all. Instead, the organization has access to public parks and resources without any vetting or requirements whatsoever. Why is that? Is it because the organization was started by the mayor and is staffed by his family and friends, and it therefore gets to be exempt from all our rules? It sure looks like favoritism and cronyism, and it's very disturbing and unfair to the public. You're exposing the city to liability and risk when you do this. And now there appears to be a big problem. We heard from a previous speaker that the president of South Bay Parkland Conservancy seems to have used his position as a city commissioner on Recreation and Parks Commission to promote paid employment for his own company at Wilderness Park. Self-dealing is a clear violation of the city's ethical standards. The City Council has failed to protect the public from this kind of financial abuse by not following your own policy. And recently, the mayor and 3 council members rushed through another partnership with Parkland Conservancy with no guidelines required. As an elected body and as individuals, you have a fiduciary duty to constituents to make sure that our public land, resources, public monies are protected and administered in a way that is transparent, ethical, and accountable. I urge you to put aside your personal agendas and do the right thing here for the community. Please call for a staff investigation and report to the public about the funds and resources that have gone to the South Bay Parkland Conservancy. Secondly, please follow your own policy on public-private partnerships in dealing with the South Bay Parkland Conservancy in the future. Treat them as you do other groups. The guidelines are there to protect the city and its citizens. The policy is there for a reason. Thank you.
Okay, just so everybody knows, this is a non-agenda item and we can't respond. Although many of us would like to, we won't be responding because of the Brown Act. So we're not allowed to speak about something that has not been agendized. Anyway, anyone else? Eleanor?
Okay, see no hands raised on Zoom. We have one e-comment. Go ahead, Vicki.
Thank you. Submitted by Matthew Hensley. Good evening, Mayor and Council. I have a conflict and I'm unable to call in, but I want to talk about my public comment from the last City Council meeting on the draft land use map. I learned that I really should not make verbal public comment when I am angry. I inappropriately directed my anger and frustration at Councilmember Obagi more harshly than I intended regarding the process to plan the city that I saw unfolding. I have always prided myself on being able to talk to any council member and at various times to agree with all 6 of you on certain things and disagree with all 6 of you. I always did it respectfully because at the end of the day, we are all neighbors in this city, but at the last meeting, I lost sight of that. I have privately apologized to Councilmember Obagi, and now I will publicly apologize for the harsher comments of my previous public comment. To be clear, I have not changed my opinion one bit that I do not like the final outcome of the draft land use map, and I like even less the process of planning a city at midnight on a 3-2 vote in the reckless or careless manner, in my opinion, that I saw. The topic of land use is what this city disagrees about the most, and getting it right is why I started getting involved. I don't have any side, and my goal when I speak is only to speak truth to power. To Councilmember Nierenheim and his entertaining tirade in response to my comment at the last meeting, don't let facts get in the way of your verbal outburst. It certainly makes it more entertaining. Finally, Councilmember Obagi asked me not to contact him in the future, and I will respect that, but you know that I am always willing to talk. I was harsher than I intended in my previous public comment at the last meeting, and I apologize for that. That includes public comments on non-agenda items.
Okay, thank you. Okay, moving right along. Next up is our first public hearing. It's a continued public hearing for consideration of an appeal of the Planning Commission decision approving the request for an accessory dwelling structure's roof attached to the rear elevation of the main home within the rear setback of the rear unit of an existing 2-unit residential condominium development on property located within a low-density multifamily residential R2 zone. So with that, I will take a motion to open the public hearing.
Ex parte.
Oh, I'm sorry. Thank you, Councilmember Horvath. And I know there are, let me start with ex parte communications, Councilmember Nierenheim.
I forgot about this item until the day when Councilmember Lowenstein talked to me today, so I did not get a chance to talk to anyone about it. So just Councilmember Lowenstein, that's it.
Councilmember Lowenstein.
I have talked to Councilmember Nierenheim, the appellant, and the proponent. Thank you.
Councilmember Horvath.
Yeah, same as last time. I've talked or corresponded with the appellants, with the proponents, staff, and Councilwoman MD.
Okay, Councilmember Obagi.
I met in person with Ms. Suffner, Mr. Stock, and I also had a telephone conversation with Mr. Stock.
Councilmember MD.
Met with Ms. Suffner, Lisa Stock, and Councilmember Horvath. And then we received 2 emails since the last meeting.
Okay, and likewise, I received those same emails, and over the time that this has been going on, I've spoken with Councilmember Obagi and Councilmember Lowenstein about this. and I had a brief discussion with our staff about this, but I have not met with either the appellant or the applicant. So with that, now I will entertain a motion to open the public hearing.
So moved.
Second.
Okay, motion by Councilmember Horvath, second by Councilmember MD. Is there any objection? Okay, the public hearing is open. First thing I want to do is apologize to both parties for having to continue this from our last meeting. It went to, I don't know what time it was, midnight. They hung in there and only to watch us continue the item. So I know myself and the entire council apologize for that. It's just an unfortunate consequence of some items taking much longer than we expected. Very important items. So with that, I hope you'll accept our apologies, and we'll give you a full hearing here for sure. So with that, I guess we're going to get a presentation from Brandy. Are you going to do this?
Actually, we have Lena Portalese, who's our planning analyst, and she's going to give the staff presentation on this item.
Great. Thank you. Lena, welcome.
Thank you. Thank you, Mayor. Let me just pull up my presentation on my screen. Just take me a minute. Actually, Mayor, before you start, we need you to a motion to receive and file the affidavit of publication, case file, and written correspondence.
Okay, is there a motion?
So moved.
Second.
Okay, motion by Councilmember Nierenheim, second by Councilmember Horvath. Is there any objection? Okay, so ordered. Thank you, Eleanor.
Thank you. Okay, so the item L1 before you this evening is a public hearing to consider an appeal of the Planning Commission decision approving an attached accessory structure on the property located at 2015 South Lane Unit B. So just a brief overview of the flow for tonight's staff's presentation. Since there is quite a bit to cover, we'll start with the project background, which will include code enforcement, the various site plan approvals and permits issued, planning division review of the roof structure and the director's decisions, planning commission review of the roof structure and appeal of the director's decision. We'll then provide the information related to the zoning code statutes which apply to this project, and we will conclude with an overall summary and the city council's role. Okay, so starting off with the project background, the subject site is on the north side of Spire Lane. It is a 2-unit condominium development. The underlying zoning is R2, low density multiple family residential. Surrounding properties consist of other 2-unit condo developments. The subject of tonight's hearing involves the rear unit of the property, Unit B. Unit B would be required to have a 15-foot average setback from the rear property line per the R2 development standards. The zoning code does allow for certain encroachments into the setback area, and we will discuss those as part of this presentation. So the owners of 2015 Spire Lane Unit B began backyard renovations back in June 2020. Code enforcement received an inquiry regarding the work and if permits had been obtained at that time. Code enforcement staff did follow up by reaching out to the property owners who confirmed that the following work was occurring: an installation of a barbecue island area, an installation of a fireplace structure, and some hardscape improvements. A stop work order was issued and the owners were instructed to contact the planning division and provide a site plan for our review. So this was the first round of site plan approvals. So this was in late June 2020. And so then the first one shows the concrete hardscape work, a fireplace in the center of the backyard with an extending base support structure that also in this proposal included a tree planter area. And then a barbecue island area towards the northeast corner of the property. This plan notes 3-foot setbacks from that rear property line. Planning did approve the site plan, as the zoning code does allow for accessory structures in rear setback areas. Specific details on those allowances will be provided later in the presentation. So once planning division approves the site plan, the homeowner is then instructed to contact the building division for information on what permits will be required and what materials are needed on their end to apply for those permits.
After the homeowner spoke with Building and Safety, they contacted planning with a revised site plan. So on this first site plan, if you note, it's the fireplace was noted as 9 feet in height. After a discussion with Building and Safety, a revised site plan was submitted to planning that now showed a height of the fireplace down to 4 feet. All the other details remained the same, including the concrete flatwork, the barbecue area, and the rear setback. So the Plan Division, we approved the site plan, and then we directed the homeowners back to the Building and Safety Division. So permits were issued by Building and Safety for the gas lines running to the fireplace and to the barbecue island. Those permits were issued July 13th, 2020. A penalty fee was charged in addition to the building permit fee since the project was already in process at the time that the permit application was submitted. The 4-foot tall fireplace and the barbecue island do not require building permits. And then the permits for the gas lines were inspected and finalized by the city's building inspector. So stop work order number 1 was released once these permits were issued for the work. Okay, so then about a month later, in early August 2020, code enforcement received complaints that included removal of a sliding glass door on the rear elevation of the home, and then construction of a concrete structure that seemed taller than the existing property line fence that abuts that back rear property line. The senior building inspector conducted an inspection, confirmed the door replacement and the new structure did need permits, and then issued a stop work order at that time. The property owners, after that stop work order, they did contact the planning division requesting our requirements and what we would need to see for approval. Work did continue without permits, and a 3rd stop work order was issued. So in response to stop work orders 2 and 3, the property owners submitted a new site plan for planning review, which now noted a new bifold door on that rear elevation right over here, about 13 feet in width. And the fireplace, once again, this time back up to 9 feet. If you recall the last site plan we approved, it had gone down to 4 feet. So now is the fireplace back up to 9 feet, the bifold door at 13 feet in width, and then the same flat work in the backyard area along with the grill area. So planning approved the site plan on August 24th, 2020. And then in the meantime, the senior building inspector had gone out another time and then made note that they had also laid a 6-inch concrete slab had been poured adjacent to the bifold door. So the homeowners were asked to add that to the drawing. So an updated drawing was approved a few days later, noting that right over here. And then the homeowners again were directed to proceed to Building and Safety for their review and permitting. So once the building division reviewed the request, they actually now at this point required full architectural drawings with structural notes for the new door and the fireplace. The full drawings would take a few more weeks for the owner to secure, and were required to be signed off by a structural engineer before the building division would review and approve them. In the meantime, during this time, code enforcement did receive another complaint that work continued. So at that time, the chief building official actually contacted the owners directly by phone and issued a verbal stop work order. The full architectural drawings with structural, they were submitted in mid-September for our review. They were ultimately approved. So this slide now shows that last round of site plan approvals. Shows the 13-foot wide bifold door and the new fireplace. These professional drawings now note the distance from the base of the fireplace support surrounding the rear property line is only about 1 foot, differing from the initial drawings done by the property owner depicting 3 feet. Permits issued for the bifold door and fireplace structure were issued September 23rd, 2020. Again, a penalty fee was charged on top of the building permit fee since the project was already in progress at the time the permit application was submitted. Inspections on both these permits passed in early October 2020. And so with inspections on in-process work, they can be done through a couple different ways. I mean, one way is having them open up the construction to see, to see the structure. But then, this could be time-consuming, difficult, can expose the structure to weather intrusions. So the other alternative is obtaining a structural observation by the engineer of record. So the building division did move forward with that option in their review. So they were able to obtain the structural observation, including photos and videos at the time that the work was done, signed off by the engineer of record, where the engineer's sign-off is tied to the engineering license. So this is acceptable practice and when work has already been underway at the time the permit is obtained. So stop work orders 2, 3, and 4 were released once the permits were issued for this work. So in late October 2020, code enforcement received an additional complaint regarding a roof structure that appeared to being constructed from the back wall of the home extending out towards the fireplace structure. The complaint included concerns regarding electrical for lights and heaters integrated in the roof structure. Code enforcement issued a 5th stop work order. Complaints were received that work continued. The property owner contacted planning in early November 2020 in response to that 5th stop work order to seek approval for the new structure. At that time, they were stating it was a replacement of a previous pergola that had existed there in their rear yard. So then planning began working with the property owner. Pergolas are addressed in our zoning code under a section that allows for architectural projections into required setbacks, which can be reviewed under an administrative design review application or an ADR. ADR application is subject to a decision by the community development director. So the property owner submitted an ADR application requesting an attached pergola in early December 2020. The application included photos of a fully completed structure, indicating work continued under that 5th stop work order. So these are 2 of the photos included with that ADR application packet for the pergola. They show the completed roof structure with the solid roof element attached to both the rear elevation of the home and the fireplace structure. You can see posts extending to the ground, supporting the roof at the other end, those posts being right next to the rear property line wall. The roof structure includes integrated heaters and recessed lights. In the first image, you can also see the new bifold door and the elevated slab. So at this point, the only items that had permits were the fireplace with surround and the new bifold door. Building permits would still be required for the roof element and the integrated lights and heaters. So the community development director did deny that ADR application, stating that the structure did not meet the intent of a pergola and exceeded the height by which a pergola could be approved by the director, which the code does limit to a 9-foot height limit. Again, the specific provision will be more fully discussed later in the presentation. The property owner appealed the denial, but ultimately withdrew that appeal and concurred with staff that the structure did not meet the standards for a pergola. So the property owner continued to work with us, planning staff, to garner a better understanding of the zoning regulations. We work with them to see if a solution could be reached and which process or application could best move them forward. Through this dialogue and further studying of the structure, planning staff determined that since the roof and fireplace are attached to each other, they can be considered one accessory structure, which in this case is attached to the main home. Accessory structures are allowed to encroach into the rear setback per the zoning code. However, they are required a 5-foot separation from the dwelling unit. Since the structure is technically attached at the rear elevation, staff and the property owner discussed the potential of a variance application to ask for relief from the 5-foot separation requirement. After further consideration of the specific language in that code section, the property owner asserted that the 5-foot separation provision does not apply to their structure, and therefore they shouldn't be subject to a variance, but rather that their structure fully complies. Again, specifics on that particular code section will be provided in a little bit. So given that the property owner felt a variance isn't required, they instead submitted a new ADR application for an attached accessory structure in January 2020, for which a decision would be made by the community development director. The director did deny this application, stating the structure does not comply with the minimum 5-foot separation requirement. The property owner appealed the denial to the Planning Commission. So the Planning Commission held a public hearing on March 18th, 2021, and considered all the testimony provided by staff, by the applicant, and by the public. The neighbors directly to the rear of the property spoke under the 3-minute public comment, and the commission granted them a 3-minute extension of time to hear all their comments. As the public hearing progressed, the commission even asked questions of them to get a better understanding of their concerns. Ultimately, the Planning Commission did approve the structure on the following grounds: that the structure does comply with rear setbacks, side setbacks, and the height limit, and that the detached structure from the rear elevation, or detaching the structure from the rear elevation, would actually lead to a less desirable design. It's noted here in this basic illustration. First, new posts would have to be constructed as new supports to this end of the structure closest to the main home. Second, the zoning code does allow for 30-inch eave projections into separation requirements. Those could project from both the accessory structure and from the main home, resulting in eaves that would basically touch. So this would potentially result in a design that appears to have a continuous roof, but not as aesthetically desirable as one solid roof element. So the Planning Commission did approve it, and then the Planning Commission decision was appealed by the neighbor to the rear on the following grounds: that the structure does not comply with the accessory structure code provisions, and that the Planning Commission made its decision based on conforming with the structure already built. The City Council is now considering this particular appeal. So we'll now review the zoning code provisions which apply to this matter. Specifically, what is allowed in a setback. The zoning code allows for 2 subset of encroachments: architectural features and accessory structures. So we'll first discuss the architectural features. They are addressed under the zoning code section entitled Building and Other Projections in All Zones. These are typically elements that extend out from a building, such as eaves, cornices, bay windows, and chimneys. But they can also include structures such as arbors, archways, and pergolas. And they are allowed to encroach into required setbacks under certain provisions. The allowed projections for certain architectural features are subject to administrative design review, with the decision made by the Community Development Director. They do not have a specified separation from other structures, and the code section limits these features to 9 feet in height. At the tallest point, the property owner's structure is 10 feet 7 inches high. Therefore, it exceeds the height by which the Community Development Director could approve it as an architectural projection. So here's that specific code section with the language highlighted related to the 9-foot height limit. So basically reading, other architectural features and structures. Height: no lamppost, arbor, architectural archway, barrow, pergola, or similar structure located within an otherwise required setback shall exceed a height of 9 feet. So since this, the applicant structure is at the highest point, again, 10 feet 7 inches, it does exceed that limit, which would allow the Community Development Director to approve it under an ADR application. So since the structure exceeds the height, for it to be approved as an architectural feature, then the only other option is to allow it to encroach into the rear setback as an accessory structure. So the zoning code defines an accessory structure as a structure that is subordinate to the main building on the same lot. Accessory structures are regulated by the zoning code section entitled Accessory Structures in Residential Zones. So we can think of these as like the detached garages, pool houses, sheds. There's a variety of, when we think of an accessory structure, but something that's subordinate to the main home. So they're overseen by the Accessory Structures and Residential Code, and provisions include a 5-foot separation between accessory structure and dwelling unit, limited to 1 story, an overall height limit of 15 feet, no larger than 800 square feet, cumulative side setback of 10 feet, or required 5-foot side setbacks if forward of the rear 23 feet of the lot, but that's not the case in this instance. And then no rear setback is required if the structure is not habitable, which the structure is not considered habitable. So this is a quick analysis of the applicant's structure and its compliance with the individual provisions of the accessory structures. So in terms of rear setback, again, if none required, if not habitable, The applicant's structure is about 1 feet from that rear property line, so it is in compliance. Side setbacks, this would be required a cumulative side setbacks of 10 feet. The structure's setback about 16.5 feet from each side property line, so it does comply. Overall height requirement is no higher than 15 feet. It's 10 feet 7 inches at the highest point, so it does comply. Stories limited to 1 story. It is 1 story, so it does comply. So it's this last provision, the setback between buildings, where the code states the minimum 5-foot distance between the accessory structure and dwelling unit and between other structures it needs to be 5 feet. So the structure is attached to the rear wall of the dwelling unit. So in staff's opinion, it does not comply with this provision of the code. So the area in question is this where the roof structure attaches to the rear elevation. So that staff does contend that per the accessory structure code, there should actually be a 5-foot separation from the end of the structure to the main home. The property owners actually assert that the section title referencing setback between buildings means the section does not apply to the structure, which is not a building. So this is the code section in question. The subsection is entitled setback between buildings. And goes on to read the minimum distance between a dwelling unit and an accessory structure or between 2 accessory structures on the same site shall be 5 feet. And then so the zoning code does have a definition for building, which includes shelter and enclosure of persons, animals, or property, which in this instance is not the case for this structure. The structure is not enclosed. The property owner asserts that since the section heading states setbacks between buildings, this section does not apply to the structure, and therefore the structure complies. In staff's opinion, we also refer to another section of the zoning code which oversees applicability and discusses the rules for the construction of the language set forth. That provision states that the article and section headings shall not be deemed to limit or modify nor affect the scope, meaning, or intent of any section thereof. So therefore, in staff's opinion, although the section title references buildings, the following sentence specifically states accessory structures. Thereby, accessory structures in general are not excluded from the separation requirement. Therefore, the structure does not comply with the zoning code as it does not meet the 5-foot separation requirement from the dwelling unit. So we know there was a lot covered this evening, so this is just to provide an overall summary of the matter. For each complaint that came in, code enforcement did reach out to the property owners, each time requesting that they contact the community development department for the required approvals and permits, which the property owners did do. So each time they did receive a stop work order, they did immediately contact staff to see what needed to be done. So the property owners did work with planning and building. They obtained permits for gas lines running to the fireplace and barbecue island. They submitted drawings stamped by a structural engineer that demonstrated the bifold door and fireplace met structural code standards. They obtained a permit for the new bifold door in the rear elevation, and they obtained a permit for the 9-foot tall masonry structure consisting of the fireplace and the base around. Penalty fees were added to the building permit fees since these they were applied for in process as construction was occurring. Each permit issued has passed final inspection by the city's building division. The only item which does not have permits is the roof structure with electrical. A reminder of the allowed encroachments.
I'm sorry, can you say that again?
Sorry.
Back one more?
Yes.
The only item which does not have permits is the roof structure with electrical. Okay, thank you.
Yeah, correct. So this is just a reminder of the allowed encroachments into setbacks, which are either architectural features or accessory structures. The structure would be allowed to encroach as an architectural feature, but exceeds the height limit by which such features can be approved by the community development director. The structure does meet several of the accessory structure development standards, except for the 5-foot separation requirement from the dwelling unit, since the roof is attached to the rear elevation of the home. Lastly, the homeowners have obtained the required permits for the new bifold door, the 9-foot high fireplace, base surround, gas lines to the fireplace, and the barbecue island. Penalty fees were assessed in addition to the permit fees for each, since permits were applied for during the process of construction. Final inspections were passed for all permits issued. So again, just the permits that are still required would be for that roof structure and then the electrical for the lights and heaters in that roof structure.
Were those inspected?
So only the check-marked items were inspected. The roof structure and the electrical for the lights and the heaters in the roof structure, neither one of those has permits, nor have they been inspected. So in conclusion, the City Council tonight is asked to consider evidence presented by all the parties and either grant the appeal, overturning the Planning Commission approval, making findings that the structure does not comply with the zoning code, or deny the appeal and uphold the Planning Commission approval, making findings that the structure does comply with the zoning code and adding conditions for approval. So this does conclude staff's presentation. The Community Development Director, Brandy Forbes, and Planning Manager, Sean Scully, are in attendance and can answer any questions as well. Thank you.
Okay, thank you, Ms. Portalese. Very good, very concise. I really appreciate that. There's great tables and really laid it out quite well. It's a lot to summarize. So thank you. I guess we'll take public comment first. Maybe we'll take a few brief questions. Make them brief. I want to let the public comment. So I don't see any hands up. Nobody wants to ask any quick questions. I'll go ahead and turn to the public and see if there's any public comments. Eleanor.
So, Mayor, I'm just going based on our rules of conduct. It says here the proponent maximum of 1 hour, and then the appellant for an hour, and then public comment.
Well, I guess we could do that. I don't like to break any rules, so I guess why don't we do that according to the rules? Let's let the proponent take an hour. I'm sorry, what was the order?
So the proponent has a maximum of an hour, and then the appellant has a maximum of 1 hour.
Okay, and you're going to keep track. So.
Yes, we will be keeping track.
Okay.
I'll take an hour.
So with that, why don't we turn it over to the proponent and let them give their presentation in whatever form they'd like.
Perfect. Thank you. One second, please. Sorry.
Okay, take your time. Don't worry about it. You got an hour.
It'll go fast, I promise. Okay, can everybody see my screen okay?
Yeah, see it fine.
Okay, perfect. Good evening, Mayor Brand, Redondo Beach City Council members, and fellow neighbors. My name is Corey, and my husband Matt and I adopted Redondo Beach as our home over 25 years ago after moving here from the Midwest. I am proud to say that my husband is an Air Force Academy graduate, former Air Force officer and veteran, and has worked in the local aerospace industry for the last 23 years. I am a mom to twins. I work full-time and have been employed with AT&T since 1999. This entire building code and permitting process has been overwhelming, and we have learned a great deal since we started our outdoor living space project in May of last year, 2020. And I will definitely be the first to say we have made some mistakes along the way and have really stumbled our way through this entire process. We had no idea the long list of things that the city requires a permit for. The permitting process was even more challenging during the COVID pandemic, with the city being closed and having to communicate only via email or phone. My husband and I bought our home on Spire Lane in 2002. We are the original homeowners and made a conscious decision to raise our family right here in the city. The Southern California beach lifestyle, the Mediterranean climate, the Blue Ribbon schools made for an easy decision at that time. And since that decision point, 23 years have passed. And what keeps my husband and I in Redondo Beach is the strong connection we have with the community and the deep relationships that we have cultivated over the years with our friends, neighbors, church, and local outreach program groups. And to the city council members, please let it be known that my family takes tremendous pride in our home, our neighborhood, and community. Thank you for allowing us the opportunity to present our testimony this evening in this public hearing forum. We have great respect for your duty as our city leaders, and we recognize your obligations are to develop plans and implement policies that affect how the community manages change and growth and development, such as outdoor living spaces, while making thoughtful decisions that are in the best interest for your fellow residents. And as we move forward this evening towards rendering a collective decision, we respectfully ask that the city council members keep in the forefront of their minds and reflect on two key tenets of the city's general plan. It states, and I quote, "Our city leaders foster meaningful civic engagement to ensure their decisions related to the future of our community are reflective of our citizens' views." The plan indicates our city has a variety of housing that appeals to the lifestyles and affordability needs of all of our residents. So our presentation today is comprehensive and will address the building code pertaining to accessory structures in residential zones. The first few slides will provide a brief overview of our presentation in its entirety and recap the building code as it is written today. So the next few slides are the summary overview. So first of all, there have been no updates, changes, or modifications to the accessory structure section of this building code since it was established over 25 years ago. And what we have in place as defined by the RBMC building code definition is an accessory structure and not an accessory building. So our accessory structure is not a building as defined by the code's definition of a building, as the structure is not enclosed. So once again, the accessory building definition specifically denotes that it must be detached. This is an accessory building. But what we have is an accessory structure. And that definition does not require that a structure be detached, only that it be subordinate to the main building. And on March 18th, the Community Development Director and the Planning Commission confirmed projections into required setbacks. Per 10.2.1522 are permitted into required setbacks and setbacks between buildings in all zones. The Planning Commission unanimously voted 7-0 in favor of upholding the appeal to the Administrative Design Review, finding the structure complies with the provisions of Title 10, Chapter 2 as set forth in the RBMC 10.2-1500 accessory structures in residential zones. So our presentation includes overwhelming adjacent neighbor and community support, along with numerous written letters from local licensed realtors acknowledging the project increases adjacent neighbor home values. We will also show several examples of attached accessory structures setting precedent in our neighborhood and within walking distance of our home. Our backyard and outdoor living space project offers many key benefits to us as homeowners and to all nearby residents. And these benefits will also be addressed this evening, including backyard details on the project itself. So the current RBMC accessory structure building code is displayed at the top of this slide. Building code 10.2/1500 setback between buildings. The minimum distance between a dwelling unit and an accessory structure, or between two accessory structures on the same site, shall be 5 feet. This subsection shall be applicable to the RMHP mobile home park zone. And for the purposes of this presentation, certain words and terms used are construed and defined as follows. So here are the definitions. We have the definition of a building, and it says, shall mean any structure with a roof supported by columns and or walls securely affixed to the ground, which building is designed and are used for the shelter and enclosure of persons, animals, or property. Now we have the definition of an accessory building. An accessory building shall mean a detached building, which is subordinate to the main building or structure on the same lot. Accessory structure, which is what we have, shall mean a structure which is subordinate to the main building or structure on the same lot. This classification includes accessory buildings. Now, as you can see, The accessory building definition and the accessory structure definition are very similar. However, the only but very important difference is that the accessory building definition clearly states that it must be a detached building, and the accessory structure definition clearly states that it is only subordinate to the main building and makes no reference that the accessory structure be detached. So words have meaning, and it's very clear to a reasonable person that the author of the code took very careful steps to define these terms. Note the word shall is used in each of the three definitions, which clearly intends to impose and express a formal obligation upon the reader. The definitions are also in bold type and underlined, and their purpose is to draw attention to the reader for emphasis in eliminating any interpretation ambiguity. So slide 4 here includes critically important key points and provides a summary recap. So 10.2.1500 requires a 5-foot setback between dwelling units and accessory structure. This is the Redondo Beach Building Code for accessory structures. However, 10.2.1522 delineates an exception to 10.2.1500, which specifically allows eaves to project up to 30 inches or 2.5 feet into these setbacks. This is the building code for projections. Now, 10.2.402 requires that for any structure to be considered a building, it must be designed and are used for shelter and enclosure of persons, animals, or property. So this is your definition of a building. The accessory building definition specifically denotes that it must be detached. However, the accessory structure, which again is what we have in place, does not require that a structure be detached, only that it be subordinate to the main building. So while 10.2.402 includes accessory buildings, it does not require that an accessory structure be considered a building. So once again, an accessory building must be detached per your code. However, the code is silent and does not require an accessory structure to be detached. So it is clear that what we have is not an accessory building because it does not meet the requirements of an enclosure. However, it does meet the definition of an accessory structure as it is subordinate to the main building on the same lot. So under the code definitions, only an accessory building is required to be detached. An accessory structure does not have that same requirement to be detached. So the building code for projections then allows eaves up to 30 inches to project into the required setback of 5 feet. It does not limit this to only one or the other of the main building or the accessory structure, and thus both are allowed 30 inches of projection into the required setback for a total of 60 inches or 5 feet. As noted above, an accessory structure is not required to be detached from the main building. And as such, the two projecting eaves are not required to be detached from each other and thus may be a contiguous structure. This is what we have built. So the determination by the Planning Commission concluded that what we have in place is allowable. And furthermore, what we have built does not violate the requirements of the applicable municipal codes. So slide 6 for reference purposes is the current Redondo Beach Building Code for building and other projections in all zones. This building code is allowable and applicable to what we have in place, confirmed by the Planning Department. So here on slide 7, the image on the left represents the prior structure we had in place that was attached to the house for 17 years. And in comparison to the image on the right, which represents the existing current structure, again, as attached to our home today. We did not have a permit for the previous structure, in which we clearly now know is a city requirement. Also, I'd like to note for the City Council, our family has never received a complaint, whether that be a formal complaint filed through the authorities or an informal complaint made in person from any of the adjacent neighbors, including the rear resident appellant, over the 17-year period that our prior structure was in place. Previously, we had large 30-foot high overgrown standard privacy trees that were planted along our very own backyard property fence by the developer. And unbeknownst to us, and prior to purchasing the home, the developer was ordered to plant these trees by the Planning Commission as a result of 2 consecutive petitions that were filed in 2001 by the rear resident appellant. Unfortunately, for many reasons, such as tree root system damage to our house and foundation, and a tree falling on our roof causing thousands of dollars in damage, but more importantly, due to severe allergies from our daughter, these trees had to be removed. So due to the removal of these overgrown trees on our property, which resulted in a lack of screening privacy for the rear resident appellant, that tree removal action triggered their first of 17 formal complaints made to the city over the project's period of performance. The appellant was not aware of key project details surrounding the different stop work orders, very imperative deals where, for instance, the chief building official, Michael Ross, approved work to continue under a work stop order on permitted work such as the barbecue area. My husband and I are kind people and we treat others with mutual respect. I can attest without reservation that we have demonstrated respect and cooperation while closely working with all city planning stakeholders and doing as they have asked throughout this entire challenging process. So in summary, what we have built meets all RBMC building requirements. The 5-foot distance between buildings in which our structure is not a building nor enclosed is equivalent to the allowable roof projections under Building Code 10.2.1522. These projections under this building code allow for 30 inches, 2.5 feet on each side. This equals 60 inches or 5 feet, and the structure is not required to be detached and may be contiguous, which again is what we have built today. So here on slide 8 represents both current and alternate views of the existing accessory structure per the building code 10.2.1522 projections. The image on the right side of the slide, which is the alternate view, represents a rendering of the structure per the building code pertaining to the projections. So essentially, we could have an allowable cantilevered roof projection of 30 inches, 2.5 feet from our home, and then another cantilevered 30 inches, 2.5 feet projection from our accessory structure roof for a combined total of 60 inches or 5 feet. So if we were to separate the 30-inch projection from the home facade side and then separate the 30-inch projection from the accessory structure roof side, this would create a feeling of bulk or mass and compromise the structural integrity of the roof structure. So keeping these allowable projections on each side of the accessory structure roof contiguous allows for the roof to be directly attached to the house and is supported by a parallel engineered beam in accordance with our stamped professional engineer drawings. The alternate design, as depicted on the right side of the slide, would not have this structural engineering support. Therefore, new load-bearing columns would need to be designed and constructed in place to support the accessory structure roof span. So here on slide 9 are just some current photos of our backyard. You've seen a couple of these already, but we have views from every angle. So I'll pause just for a moment so you can take a look here and I can drink my water. So I want to take just a minute to address the following arguments that the rear resident appellant have expressed towards our outdoor living space. The appellant argues that their home will decrease in value due to crowding. The investment we have made in our outdoor living space will not only increase the value of our home, but also increase property values for the community and all adjacent neighbors. Included in our documentation are 5 signed letters from reputable, local, licensed real estate and mortgage professionals that specialize in buying and selling homes in Redondo Beach in the South Bay. With over 96 years of combined real estate experience between these 5 professionals, each one has issued statements acknowledging all adjacent neighboring homes will also directly benefit from our investment and therefore help to increase their property values as well. As far as the appellant's argument that the accessory structure enables overcrowding, please note the structure occupies only 17% of the building code's maximum allowable requirement. The building code, as it's written today, would actually allow us to build a 40-foot long by 10-foot high structure, thus increasing our existing accessory structure by a whopping 83%. Clearly, our accessory structure design does not take advantage of this opportunity. Reasonable people would agree that what we have in place is architecturally compatible, is low profile, and is void of bulk or mass. So the next claim made by our rear resident appellant argues that the accessory structure's wood ceiling surface and tiled patio somehow creates an echo chamber. This is false and not factually accurate at all. Wood, concrete, greenery, furniture are all excellent materials for sound absorption. The property fence line, barbecue, fireplace structures are all made of concrete block, which are also excellent barriers for noise attenuation. We have also installed 6 young trees and have used noise-absorbing materials for furniture. And just for reference, as cited in Wikipedia, a whisper or rustling of leaves measures at 20 decibels, and a conversation at home measures at 50. A washing machine registers at approximately 70 decibels, and a lawnmower around 90. The rear residents' argument that they have measured noise in our backyard at 65 decibels, and just to provide some context here, that's less than a washing machine. The rear resident has 2 barking collies they let out multiple times a day from 4 a.m. to 11 p.m. Their 2 dogs bark at a much louder decibel rate than what you will find in our backyard. Again, per Wikipedia, the average bark of a mid-sized dog, like their collies, is 100 decibels. And lastly, the rear residence appellant is concerned about rain runoff and drainage into their yard. And although this was not a requirement months ago, we wanted to immediately remedy the concern in another good faith attempt to find a compromising solution to the matter at hand. So since the Planning Commission meeting, we've installed gutters with a downward spout that drains into our yard. So here on slide 12 summarizes the findings and conditions proposed by the City Planning Commission on March 18th, upholding our appeal of the administrative design review by a unanimous vote of 7-0, as rendered by each planning commissioner. Number 1, the proposed accessory structure's roof complies with the provisions of Title 10, Chapter 2, as set forth in Section 10.2.1500 accessory structures in residential zones. Fully complies. Finding number 2, the design is compatible with the overall community and surrounding neighborhood. Once again, fully complies. Finding number 3, the application, specifications, drawings, and supplemental materials submitted with the application have been reviewed by the Planning Commission and are approved. Once again, fully complies. So based on these stated findings are the conditions within the body of the Planning Commission's resolution report to remedy the rear residents' concerns. Number 1, rain gutters to be added to the north side of the structure's roof. As stated before, since that meeting, we have installed gutters with a downward spout that drains into our yard. Number 2, additional plants and greenery for privacy. So in another good faith attempt to find a compromising, reasonable solution to the matter at hand, in the spirit of being neighborly, we are also willing to invest another $4,000 for the installation of a new vinyl privacy fence up to the maximum modification height allowed for by the planning department. The backyard grade elevation difference between our house and the abutting backyard is a minimum of 24 inches, about 2 feet. So our home is at a higher elevation and we are more exposed. And as a part of the City Council's considerations this evening, we are also requesting your approval for a fence modification to replace and extend our existing property fence line up to, once again, the maximum modification height as allowed for by the building planning department. Not only will this fence modification increase privacy, but it will further dampen noise, whether that be noise generated from the appellant's backyard or from our backyard. Slide 13 summarizes the remaining 3 conditions cited within the Planning Commission's resolution reports. Our family fully accepts and acknowledges these remaining conditions. There are no current or future plans to modify existing and or add accessory structures in our backyard. So now my husband will review with you a compliance assessment matrix pertaining to the building code itself.
Good evening, Mayor Brand and City Council. Here on slide 14 is our building code 10-2.1500 compliance assessment matrix. Paragraph B, stories. Our structure is not more than 1 story and is fully compliant. Paragraph C1, accessory structures occupying rear setback height. The height shall not exceed 15 feet. Our structure is 9 feet 8 inches and is fully compliant. Paragraph C2, floor area. The floor area shall not exceed 800 square feet. Our accessory structure is only 261.9 square feet. Again, fully compliant. Paragraph C3, side setback. The current side setback is 18 feet on each side for a total of 36 feet. Our structure is fully compliant. Paragraph 3A, property abutting alleys, not applicable. Here on slide 15 is a continuation of our building code 10-2.1500 compliance assessment matrix. Paragraph 4, rear setbacks. No rear setback required unless it's habitable. Our structure is not a habitable structure and therefore fully compliant. Paragraph A, setbacks between buildings. Again, please note that the word buildings as written in the building code is in bold text. The minimum distance between a dwelling unit and an accessory structure or between 2 accessory structures on the same site shall be 5 feet. Paragraph A clearly states between buildings. The building definition is clearly defined and must be enclosed. So in summary, our accessory structure fully complies to all 7 building codes, including paragraph 7A, distance between buildings. Our structure is not a building. By definition, a building must be enclosed. Our structure has no walls erected within the 5-foot setback requirement. Our structure has no impediments to the house. First responders have full access. The structure meets or exceeds all outdoor living space requirements, and the feeling of bulk or mass is minimized with the structure's fully open size. Our accessory structure is attached to the home's rear exterior facade, and the Redondo Beach Municipal Code specifically indicates an accessory building must be detached, but does not have this detached requirement for accessory structures. Slide 16. What's astonishing in the existing building code, as it is currently written, allows me to construct, and within the minimum 5-foot side setback on each side requirement, a 40-foot long concrete block wall, AKA accessory structure, that is 10 feet high and 40 foot long. A gross allowable structure totaling 400 square feet along my very own backyard property fence line. The existing building code as written would also allow me to construct that very same accessory wall structure in the middle of my backyard and set back 5 feet from our home. Would one define these structures being without bulk or mass? I would certainly think not. Our existing accessory structure is only 17% of the building code's maximum allowable requirements. The structure is on the very low end of the code and does not exploit the requirements opportunity. Again, our existing structure is architecturally compatible, low profile, and without bulk or mass. This current slide, slide 17, is a continuation of slide 16 and intended to visually demonstrate in a digital artistic photo rendering of the existing as-built condition of our accessory structure, which again is low profile and 17% of the allowable maximum code, versus on the bottom half of the slide, a rendering of what a 40-foot long by 10-foot high concrete accessory structure wall would look like. I think we would all collectively agree the existing as-built condition is in good taste and complies with the intent and spirit of the municipal building code and is not architecturally obtrusive to the surrounding neighbors. Here on slide 18, my wife and I conducted a very thoughtful and thorough owner-neighbor benefits analysis based off solicited survey feedback from surrounding neighbors and our exhaustive review of the building code. The objective of the analysis is to offer the City Council a quick look summary of the project's benefits and values. Of the 17 categories documented, all were determined to have overwhelming value to the neighbors and our family. Number one, safe new structure. No safety risk to residents. It's structurally sound construction as built in accordance with stamped drawings and plans developed by a licensed professional engineer in the state of California. The structure has no impact to public health and welfare for all. Number two, replace the old structure. It was unsafe as it was a deteriorating 17-year-old patio covering. Number three, neighbor property line encroachment. There is no encroachment into neighboring yards. The structure resides within our property line and property footprint. Number four, right-of-ways. The structure doesn't interfere with any residential right-of-ways. Number five, street frontage line of sight. There are no street frontage views. And number six, residential design guidelines compatibility. The design is consistent to the intent of the residential design guidelines. There is no appearance of bulk or mass. Number seven, neighborhood aesthetic enhancements. The structure contributes to the overall design quality and visual character of the community with stable, desirable characteristics. And number eight, noise dampening. The materials used in our backyard, such as wood, concrete, greenery, and furnishings are all excellent materials that absorb and attenuate noise. This current slide, slide 19, is a continuation of slide 18. Number 9, property values. Home improvers make good neighbors. And I quote a 2008 Harvard University study found that improvements make a neighborhood more desirable, ultimately increasing the house value of all homeowners, even those who did not undertake any improvements. Number 10, privacy. The accessory structure provides much needed privacy for my family and surrounding neighbors. Number 11, rain runoff. There is no rain runoff from this small roof. It's negligible. The surface area is only 240 square feet. There is no impact to neighbors. We have photos and videos to support. Rain runoff is a non-issue, and we've installed a gutter which drains into our own yard. Number 12, tree maintenance. We no longer have to pay out of pocket for the high expense of maintaining the overgrown 30-foot tall standard run-of-the-mill privacy trees. And number 13, health and allergies. Our daughter is highly allergic to these species of trees, including other weed and grass pollens, which all necessitated tree removal. My daughter now has a pollen-free environment. Number 14, backyard space utilization. We wanted to modernize our home and create a yard in which we could spend more time and relax as a family, improve quality of life for the new COVID environment in which we live in today. Modern outdoor living spaces are very, very popular in the beach cities. And number 15, precedents. These structures are well established across the city. Any resident just needs to take a walk down their very own neighborhood block. In the following slides, I show numerous accessory structures such as attached patio coverings, open-closed pergolas, and pavilions that exist today. Unfortunately, most of these structures are unsightly, lack proper maintenance, are health and safety risks, but exist and continue to remain in place. And number 16, resident support. Our package includes numerous signed letters, including a signed petition from our very own adjacent neighbors on the 2000 block of Spire and the 2000 block of Belmont Lanes, including other residents that are in full support of our backyard outdoor living space improvements. Slide number 20. As you can see from this neighborhood map, my wife and I are truly overwhelmed and humbled with gratitude by the outpouring of support for our backyard improvements from 25 of our fellow adjacent and block neighbors who currently live on the 2000 block of Spire and Belmont Lanes. We are deeply appreciative of the community's collective actions. Not only have they come out in full force, but they have signed a formal petition of support. Many wrote letters on our behalf, of which are documents included in our submitted package, and many this evening are on the Zoom call to listen in and or comment live on these proceedings. These circumstances have triggered an extraordinary outpour of support, not only from nearby and adjacent block neighbors, but from other residents that live across the city. They have all touched our hearts, and our gratitude is overflowing. These 36 residents took time out of their very busy lives to write impassioned formal letters, strongly recommending support of our beautiful backyard living space project, and to ask the City Council to please render a decision that supports the majority interests of all residents and not just one. Herein on slide 22 are 5 highly respected California real estate licensed and mortgage South Bay professionals that have over 96 years of combined experience and are in full support of our project. As we had stated previously, they have issued statements acknowledging all adjacent neighboring homes will directly benefit from our investment and therefore help to increase their property values as well. Slide 23. As another old adage goes, a picture is worth 1,000 words. The next 5 slides are photos of various attached closed accessory structures that exist throughout our neighborhood and are within a short walking distance of our home on Spire Lane. The improvements that we have made to our home are in step with the improvements that have been made by our other residents, which currently remain in place. I will flip through each slide and pause for just a few seconds to allow each city council person an opportunity to view each situation. Slide 24, and again, here are a few more examples. And again, more examples of various attached structures. And slide 26. Although my wife and I are fighting to preserve the beautiful investment made to our home, which is fully compliant to what is actually written in the building code and improves property value for all residents, we are deeply troubled that within a 1-block radius of our home, these unkept, poorly maintained, unsafe, and unsightly homes continue to remain in this dilapidated condition without any homeowner accountability. And because of one resident's complaint, we can't help but feel targeted and in many ways discriminated against. Here on slide 27, although we have shown pictures of our well-maintained backyard this evening, these photos represent the current and unfortunate long-standing condition of the appellant's house since the time that we had purchased our home in 2002. Slide 28. I take no joy in presenting this chart, but these are the facts. And as a father, I have a moral obligation to my family and to all of you as our entrusted city leaders to provide clear context and understanding of these circumstances leading up to these proceedings. Given the numerous complaints the appellants have filed against my family since June of last year, their actions represent a complete abuse of city resources. For example, they have called the police on my family on 8 separate occasions over a 25-day period, including calling the police at 6:30 p.m. on Halloween Eve while our children were in costumes and playing. Up until this point in time, local law enforcement has never been to our home in the last 19 years since we have lived on Spire Lane. We have been harassed and our privacy has been invaded, which is of particular concern as we have children to protect. The accessory structure offers some form of privacy from these inappropriate behaviors. While attempting to enjoy our backyard, my family and our guests have witnessed on several occasions the taking of photos, video, and audio by our rear resident appellants. It's disappointing the appellants continue to refuse to compromise or find neighborly common ground on any of their issues and will not stop until we are somehow punished, fined, and condemned for stumbling our way through a challenging building code and permitting process exacerbated by this ongoing pandemic. Regardless of these transgressions, we want to move forward and pass this. We want and we will remain open and we remain committed to any and all responsible solutions that will help to create a positive neighborly environment for both families.
So on this slide, my husband and I have painstakingly laid out the accessory structure project timeline from start to finish, including all approved plans, permits, inspections, stop work orders, appellant complaints, response to appellant complaints, many of which were falsely submitted or unfounded, with objective evidence and our full cooperation with all city officials. So I will walk you through these details in the next few slides. I do want to remind the public and the city council to please note this project timeline is in no way aligned to the appellant's appeal at hand, which is supposed to be solely focused on the building code of which we are fully compliant to. However, being the appellants want to use this public hearing as a forum for their own agenda with focus around our permits, the permitting process, and our compliance with city authorities, or supposed lack thereof, we had no other alternative but to present the truthful, documented facts around our very own project and our exclusive dealings with the city, as opposed to anyone taking action and providing misinformation from a third-party neighbor that lacks direct involvement in the details of our project itself. On May 26th, our project began, which included demolition of the backyard and also removal of our trees. On June 17th, we received a letter in the mail from code enforcement as a result of a complaint from the appellant. The letter referenced tree removal needed to be addressed and permitted work needed to take place. On June 22nd, a few days after returning from out of town and receiving the letter in the mail, I emailed Norma Cook asking questions about the tree removal and work that needed a permit. I also walked over to the appellant's house to inquire about the complaint, and they denied ever filing any complaint and raised no concerns about our project to me at that time. I did exchange numbers with Mr. Stock and told him to feel free to call me with any concerns or questions moving forward. On July 7th, the city approves our site plan that also included greenery that was to be replaced. On July 13th, the electrical permit and gas permit were issued. 2 days later, on the 15th, the electrical and gas permit inspection was completed and approved. On July 27th, we had a licensed door contract to remove and install new bifolding doors. This project took 72 hours as our home was fully exposed and unsecured. The appellant filed 2 more complaints after the doors were fully installed. And unbeknownst to the appellant, we had been actively working with the city to secure the required permits. Since those 2 complaints were filed, additional complaints continued over the next phase of the project. We had modified our accessory structure height from 4 feet to 9 feet. And once we built beyond 4 feet, the appellant filed another complaint. We did not know at that time that anything over 4 feet required a permit. Once again, we immediately complied with the city and followed the process to secure the required permit. Complaints including things like scaffolding that was hanging over into their yard came in, when come to learn the item of concern was actually a 6-inch projection of a standard 2x4, which I immediately removed myself the following day, only after my husband was threatened by the appellant that he would call the police if this wood was not immediately removed. On August 24th, the city approves the revised site plan with the new 9-foot high accessory structure. At this time, I had reached out to Chief Building Official Michael Ross to ask if construction could continue during this work stop order, but only to work on the other fully permitted items, which was the barbecue area. Mr. Ross approved the request to allow work to continue on the permitted barbecue area the following day on August 27th. Yet meanwhile, once again, the appellant continues to file complaints without the knowledge and details of our project and approvals. On September 10th, I received a call from Mr. Ross, and I was out of town, and he informed me that yet another complaint came in, and it was filed that work was being done on the accessory structure, which at that time, we were still pending our final permit. So I immediately called my general contractor, as they were strictly instructed to only work on the permitted barbecue area. I dismissed the crew, I sent them home and had them return the following week when I could be home to supervise the work that was just to be done on the permitted barbecue work area during this work stoppage. On September 23rd, both the bifolding doors and the accessory structure permit are issued. On October 5th, I actually sent a letter to the appellants providing them just a neighborly courtesy on our project and to inform them of our plans to add greenery, which would improve their privacy. The following day, October 6th, the permit inspection was completed and approved for the bifolding doors. 2 days later, the permit inspection was completed and approved for the accessory structure. On October 18th, another complaint was filed, and Mr. Ross actually stopped by our home. And I was actually there, so I escorted Mr. Ross to the backyard to find there were painters there, and there was no construction. At that time, Mr. Ross reported his findings back to Brandy Forbes, the city's community director, via cell, stating there was no construction workers on site. Once again, just more complaints filed, work stop orders issued, and at this point, the project was completed. Mr. Ross even came out on October 31st to find no workers on site nor any construction taking place at that time. So due to all of the appellant's complaints, I actually requested a meeting with Mr. Ross, the chief building official, after he dropped by the house and left his business card. So I had a meeting with Mr. Ross on November 2nd, and then after our discussion, proceeded with the administrative design review process. So, based on this timeline, we have been very proactive. We have been timely. We have been very responsive to all city requests. We have fully complied with all city directives and work stop orders. There was only one incident when workers did not comply for a short period of time when we were out of town. And that's when Mr. Ross called me. And I immediately dismissed the workers on site here and told them to return when I was back the following week so that I could supervise the work that was being done here.
Here on slide 36, the following slide is a detailed summary of the 4 city-approved building permits on file in support of our accessory structure project, with a total cost to my family that is well over $8,200. These fees cover the cost of the city permits and the supporting license, professionally engineered drawings, and various permit documents. The 4 signed-off city permits are for plumbing, gas, the accessory structure, and bifolding doors. In accordance with the building permits process and per the city's municipal code, we were charged and paid an additional $435 in fees, which are defined as investigative building permit fees. Here on slide 37 are screenshots of code enforcement's letter dated June 17th as a result of the appellant's first complaints, which immediately followed the removal of our overgrown property line trees that were damaging the footings, the patio, and the shallow root system encroaching into our foundation of our house. The letter cites Resolution 8913 from August of 2001, stating we must immediately discuss with the Planning Division the conditions of this resolution. The resolution states that trees in the rear yard shall be replaced if removed. This letter came as quite a surprise to us since we're the original homeowners of the rear unit and not been made aware of such a resolution. We contacted Norma Cook, the code enforcement officer to understand the situation, and we immediately modified our backyard plans, which were subsequently approved by the city, with the planting of the 6 new privacy trees, which were not in our project's budget at the time, however, costing us well over $1,750. After further review of the written language of the letter and after our immediate compliance to the resolution, it was determined these resolution conditions were clearly imposed upon the developer and builder of our home and not upon us as homeowners 20 years later. Even though the city accidentally misinterpreted the code and issued the violation in error, this is just one of several examples showing my family's full cooperation and immediate compliance to address any such matters. We are reasonable, cooperative people and understand mistakes happen by all and are just a part of life, particularly when communication channels have been truncated during the pandemic. Over the last 12 months, we have forged a trustworthy relationship with the city's building and planning department, such as code enforcement, and are grateful for the responsive service and willingness to work with their fellow residents in navigating the building process.
So in closing, we ask you as our elected Redondo Beach City Council members to not only encourage but support the very mission statement of Redondo Beach. The city of Redondo Beach is committed to providing the finest services to enhance the quality of life for those who live, work, visit, and play in our community. All of the adjacent neighbors and community have come together to show their support. We ask you to acknowledge their overwhelming support. There is no safety risk to us or any of the adjacent residents. Our backyard has no impact to the public health and welfare. Our improvements are aligned with the overall design quality and visual character of the community with desirable architectural characteristics. We kindly ask for your approval on our structure, which is fully compliant and does not violate the requirements of the applicable municipal codes. As elected officials representing all Redondo Beach residents, we ask that you be fair and that you be reasonable. Please consider all of this factual evidence and overwhelming support presented here today and render a decision not only on what is fair and reasonable, but what is defined and written in your code today and is fully supported by your 7 trusted appointed Redondo Beach Planning Commissioners. We kindly request the City Council vote to deny the appeal and uphold the Planning Commission decision that was rendered on March 18th. Thank you, everybody, for your time.
Okay. Well, that was quite a presentation. Thank you, Matthew. Thank you, Corey. Suffners. That was a fantastic job. So we'll move on now to the stocks. Lisa and William, are you guys ready to go ahead and get started?
Yes. Can you hear me?
Yeah, hear you fine.
Okay.
Welcome.
So, good evening. I'm William Stock. I live at 2014 Belmont Lane. And so I'm the appellant in this hearing. Please advance to the next slide. So I have a Master's of Science degree in Civil Engineering, 35 years experience as a structural engineer. I've lived in Redondo Beach since 1988. And the reason for the appeal is that, as previously mentioned in the city's presentation, it does not meet the requirements specified in the municipal code for setback between buildings. And the second reason for the appeal is the Planning Commission did not perform the required systematic review of the design. Instead, they discussed rationale to manipulate the existing codes to save an illegally built structure. So if we look here, the Redondo Beach Municipal Code Section 10-2-2500 states the purpose of an administrative design review. The purpose of administrative design review is to enable the community development director to review minor developments projects that otherwise meet the zoning regulations in terms of the appropriateness of the design. So again, the Planning Commission should only have been looking at the design. They should not have been considering what was already built. There was a lot of discussion. Oh, you can't do that because there's a bench there. You can't do that. There's a post there. That didn't matter. If they'd been looking at the design, that would have just been a matter of somebody pulling out an eraser and erasing something and moving it. But the Planning Commission was constraining themselves to what was already built to find a solution. And in addition, the Planning Commission hearing process only allows for the appellant, in this case it was the homeowner, to formally present. Everybody else was limited to just 3 minutes in the public. Next slide, please. Okay, so the issue with the construction project at 2015 Spire Lane is primarily how it was built, not what was built. The homeowners did not follow the clearly defined planning and permitting process, despite numerous notifications and warning from the city planning department and code enforcement. And as a result of this, there are safety concerns due to the lack of approved plans and inspections. In addition, the city of Redondo Beach was aware of the illegal activity, but did not enforce the existing laws. There are no valid excuses for not taking action. The city is obligated to enforce all laws. Next slide, please. In the Redondo Beach Municipal Code, under the Administrative Design Review section, there is a clause for revocation. And it basically says the planning director may revoke or modify any administrative design review approval issued on one or more of the following grounds. And I've highlighted 4 grounds there that I think are relevant to this case. 1, that the approval was obtained by fraud or misrepresentation. Number 5, exercise of the approval violates state, federal, or local statute or regulations. Number 6, exercise of the rights under the approval is determined is detrimental to the health, safety, and welfare of the community. And number 7, that exercise of the rights under the approval constitutes a nuisance. And so I recommend that the city council use these same criteria as a basis for overturning the planning commission decision. And again, the planning commission should have considered these criteria as part of their decision. Next slide, please. We've already seen this letter in the homeowners package, but I think there's some important things we need to see here. They claim that they weren't aware that they needed permits, but this first letter on June 17th, 2020 clearly says permits are required for construction work. It also says cease all outdoor construction. And it also says failure to comply will result in legal action to compel compliance. And it also states that not having permits was a violation of the Redondo Beach Municipal Code. So you heard them say multiple times that they didn't know they needed permits. But on June 17th, right in the main box on this letter, it says permits required for construction work. So right there, we know that they knew they needed permits on June 17th, 2020. Next slide, please. Okay, we've already seen some timelines, and I'm not going to spend a lot of time going through this. The blue line about center of the page is the timeline, and you can see it's June 2020 through March 2021. And what I've done is I've just basically taken the report that I got from the planning department and put the incidences on a timeline. So you can see we've already talked about all these things. There's 7 cases where the homeowner was told, this is above the line under what I've labeled notifications. There's 7 cases, at least 7 times they were told that they needed to have permits to do the work. And there's the 5 stop work orders there are identified that were issued and the dates. Below the line, there's the construction activity. So you can see what's happening. There was demolition. This is consistent with what we've seen. On August 3rd, there was a door replaced and a masonry structure installed. August 19th, the construction continued on the masonry structure. September 10th, work continued on the masonry structure. September 23, permits for the door and the fireplates were issued. But the important date is October 23rd, which just happened to be a city off Friday. So we have an off Friday, a large construction crew showed up and constructed a roof structure. And so they worked very hard through the weekend to get it up so that it was up before the 26th when the city was back in the office. And you notice on just above that, October 26th, that's when they were informed of that stop of the roof, and they issued the stop work order. So you can see that it's clear that the construction was done on the 23rd because they knew it was a city off Friday and nobody would be there to stop them, and that they could get it completed before it could be stopped. Next slide, please. Okay, so there's been a lot of accusations made about how we're making complaints, and that's absolutely not true. None of it's true. Let's look, what's above the line, the notifications are exactly the same as we saw on the previous slide. What's below the line is my involvement in this project. So on June 16th, I sent an email to the city inquiring if there were permits for the work that was being done in my neighbor's backyard. That's within my rights to do. That is the process. Permits are a matter of public record. If there's permits on file, I'm allowed to see the permits and I can get an understanding and some insight into what is going on. And that's it. That's the rules. That's the way it works. It ends up there were no permits. So on June 17th, I got a call from the city and they said, please send us photos. And they said, due to staffing limitations, as well as the pandemic, it was going to be difficult for them to come out and watch this project. So if we could please send them photos and keep them informed of what was going on. This was at the request of the City Planning Division Code Enforcement. So the next time I notified the city, and you've seen this before, was August 3rd, because work was being performed back there. They asked me to let them know. So I sent an email to the city on August 3rd with photos of the door that was being replaced, as well as the masonry fireplace. And then what was interesting was on September 2nd, we got a phone call and an email from the city. In this case, it's not me contacting them. On September 2nd, they're calling me and they're asking me for help because there's an issue regarding a roof. And they're saying, the quote from the email, adding a roof would be a violation. So on August 2nd, I knew that, or September 2nd, I knew that adding a roof would be a violation. I find it hard to believe that the neighbor didn't also know that adding a roof would be a violation. They also said, contact us if a roof is added. So again, the planning department, code enforcement was aware that a roof was in the works and they wanted me to let them know when the roof was added. They also said at the same phone call, they said, contact them if work continues on the fireplace and please send photos. So again, all the photos that we've been accused of taking in a malicious manner were done at the request of the city. On September 10th, I sent them an email with showing work on the fireplace and included photos. And then obviously on October 23rd, as well as the 24th, I sent an email informing the city of work on the roof. And actually beyond October 26th on the stop work order, when the homeowner claims no work was done, that electrical work was done the entire week of October 26th. I have photos that show the electrical work being performed. They're not being truthful with what happened. There was definitely work going on. I have it completely documented. All the photos have been sent to the city. Next slide, please. Okay, so I've had several discussions with people at the city as why nobody's enforcing the law here, because it's clear that there's been plenty of opportunities to enforce the law. What I've highlighted here in yellow are my, I guess, to me, this would have been the way it should have been handled. On June 17th, yes, people don't understand the laws exactly, so you give them a warning. We've already seen the letter that was provided on June 17th. It was very clear. You need permits to do construction. It's not, that letter was not ambiguous. It was very clear. So there was plenty of opportunities. Stop work order 4, number 2, 3, 4, and 5 easily could have been a citation from the city. And the reason I'm here today is because code enforcement did not act. They should have acted, and had they done that, this would not have been elevated to the city council. So again, I know that the budget you're going to talk about code enforcement. Okay, here's an example of why code enforcement's important. Next slide, please. Okay, so now what we have here, we've seen this already too, is that this is a plan approved by the city on August 27th, 2020. Note that this plan was approved after the fireplace and door were completed, but it does not reflect what was actually built on August 3rd. So that's important. So what we're doing is we're working with the city, getting a plan approved on August 27th that does not reflect what was built on August 3rd. And you'll notice in here that I've highlighted, it says that the concrete masonry unit must include rebar. So that's that plan. So let's go to the next slide. This slide, which is dated just a few days later, September 2nd, shows exactly what was built. These are the architectural drawings. It's obvious that the roof was always part of the integrated plan. If you look at the way the door works and the way the roof works and the way the fireplace works, it's an integrated design. It wasn't done piecemeal. They didn't say, let's put in a fireplace, let's put in a door, let's put in a roof. It all goes together. It was all being planned well in advance. And on September 2nd, they had plans of what they actually built, but a few days later, they had plans that they'd submitted to the city that doesn't look anything like what they built. And what I find interesting is that on September 2nd, the day that these plans were approved, that was the day I got the phone call from the city telling me if they put in a roof, call them. So it looks like there was some discussion between the homeowner and the city on September 2nd regarding the roof. And it's very clear the homeowner was probably notified they could not add a roof, because I was told they couldn't add a roof on that day. If we go to the next slide. This is just an example, a detail of the two drawings we just looked at. The upper one is the plan that was approved by the city on August 27th. You notice the tree planter is 3 feet from the property line. That's not what was built on August 3rd. What was built on August 3rd was 6 inches from the property line, which is consistent with the drawing that's below that was signed just 2 days later by an architect. And notice the tree planter is gone. The fireplace is 7 inches from the property line. And this is exactly what was built on August 3rd. So what this indicates is that there was 2 sets of plans being developed simultaneously. One set of plans that the city would approve, and the other set of plans of what they intended to build. So if we go to the next slide. Okay, this is the same timeline. Again, what's on top is the same. What's on the bottom, now we're going to talk about administrative design reviews. So if we start in June, oops, what happened? There it is. If we start in June, you can see that there's the solid red line there. It shows that I don't know the timing. I just know when the plans were signed. There was 2 sets of plans in progress. One set of plans for city approval, and one was representing what was really built. August 27th, the blue plans were completed, and they don't show a roof. These are the plans approved by the city. September 2nd, we have architectural plans that show a roof, right? So on September 2nd, we have 2 sets of plans. We're not in agreement. This is the design phase. Nothing's been built yet. That would have been the time for an administrative design review. We shouldn't have gone ahead on October 23rd and built the roof. We should have worked with the city to reconcile all of these issues. So we've seen there was 3 administrative design reviews that went through. That should have all been resolved prior to October 23rd when the roof was built on the city off Friday. And just as a reminder, the city development director did not approve any of the administrative design reviews that were submitted. Next slide. And now I want to talk about the planning commission solution. It's not feasible. And I've spoken with, I'm a structural engineer. I've spoken with other structural engineers. It could not happen. And the reason why is you can't just hang an eave off of a house. You have to have a post. The post has to be there to support the vertical loads on the eave. So you're going to get vertical loads. Well, here it's mostly going to be from wind. So you can imagine the eave flapping in the breeze. You need the post there to stabilize the eave. And so if you look at the diagram I've provided, you would have a post, and then you can have 30 inches of an overhang with a post off of the house. But then from the accessory structure, you would have to have a post that was 30 inches with 30 inches of overhang, but you have to have 5 feet separation between the 2 posts. And so there's no way that the planning commission solution could actually be built, even though it's, you know, in people that don't understand what's going on could say, yes, that could happen. But in reality, it could not happen. And furthermore, in the green box that's down below, it's very clear that the intent of all accessory structure laws is that accessory structures are secondary to and detached from the main building. I looked through several municipal codes, and every single one of them says accessory structures are detached from the main building. There may be some ambiguity in there may be some perceived ambiguity in the Redondo Beach Code, but it's very clear. And even the planning department agrees that the accessory structures are not attached to the main structure. Next slide, please. Okay, so now this gets into some current concerns that I have regarding the actual construction and the lack of inspections. So if you look, this is the door frame that was put in for the large accordion door. And I've on the left picture, this picture was taken on August 3rd. I've highlighted a joint there. I didn't have a good view of the other side. I don't know what they did on the left side of the picture, so this is the right side. There's two issues with this that make this, questionable. The first is that there's a main structural column there that's got a big notch in it. If you read through the building codes, no building code allows you to notch a load-bearing column without a detailed structural analysis to show that that's okay. And so that's a concern. The column is notched. It's highly unlikely. Well, as a minimum, that would need to be inspected to make sure that what is on the drawing matches what was actually built. What the structural engineer has approved is exactly what was done there. So that's the column. And also this bracket was not installed properly. So if we go to the next slide. Okay, so I don't know the exact model of the bracket they used, but I found a similar bracket online. So if we take a look, I've highlighted in the picture on the left, photograph. It's the same photo we had on the previous page. I've identified the beam. That's the main header beam that goes across the top of the door frame. Then there's the column. That's the vertical member that has been notched. And then there's the bracket. So if you look in the center of that page, there's a picture of the bracket. So you can see that that's the way the bracket is. And if you go to the next photo over, the right side of the frame, that is the installation instruction for the bracket. So you'll notice that the bracket, the first thing you notice is the column is not notched. If you look back at the photograph, you see the column is notched. You also see that all of the fasteners that are in that vertical plate of the bracket, half of them go into the beam and half of them go into the column. That's to transfer the loads, the F2 loads primarily, from the beam to the column. But if you look at what was actually done, all of the fasteners just go to the beam. So there's absolutely no way for those F2 loads to get transferred. Those are the axial loads, the tension loads in the beam to get transferred from the beam to the column. So it's structurally unsound. And the building codes specifically say the connectors shall be manufactured, identified, and installed in accordance with the manufacturer's published installation instructions. That clearly was not installed per the manufacturer's instructions. That's not the way that bracket works. I've added a table here at the lower left. And what this is the manufacturer's allowable loads for the particular bracket that I have for an example. And what these are, if you look in the gray box, you can see in the second row in the gray part, they've got F1, F2, F3, F4. So these are the maximum loads, the maximum values for F1, F2, F3, and F4 that can be carried by this bracket. But these loads were derived from a intensive and, a rigorous testing program where they put the bracket in this exact configuration that's shown in the upper right, and they tested it, and they have test data to back up these numbers. If you don't use the bracket in the way it's intended to be used, you have no numbers. You don't know what it's good for. You can't certify that it's good because the manufacturer hasn't published these tables. So the door frame modifications do not meet building code requirements. There's just no way. Next page. Okay, so now let's talk about the masonry fireplace. So there's the masonry fireplace. There's two types of loads that the masonry fireplace is going to see. It's going to be vertical loads and it's going to be lateral loads. So in the vertical loads, you'll notice there's posts on the roof. So the posts are there to carry the vertical loads. But if that's the left picture, but if you look at the right picture, this would be the case of an earthquake where it's shaking side to side. In that case, the posts are just, they're flexible. They just bend out of the way. So all of the loads due to the earthquake, the weight of the roof has to be carried by the masonry fireplace structure. The posts don't do anything for you in that case. It's all the fireplace. But in order to endure the shearing forces that are created by these side loads, the building code requires steel reinforcement in the concrete masonry structures. So if we go to the next page. Okay, I had a front row seat to this concrete masonry structure being built, and no reinforcing steel was put in it. I watched, I kept waiting for him to put it in. You can see in the photos, it's just not there. So those are 3 photos. It's clear I watched the entire thing be put up. I was watching for the steel reinforcement. It is not there. If you look on the left, it shows a diagram. Hopefully you can see it. But if you go down the left side of that, it talks about a mortar or masonry cap. That's not important. The second thing, it talks about horizontal rebar at the top. It is not there in that structure. The second thing, it talks about vertical rebar. You can see that the vertical rebar runs the total length of the structure. It was not in what they built. If you keep going down, there's a second row of horizontal rebar. It's not there. And the third thing is anchoring. I don't have visibility to the anchoring. I don't know if the anchoring's there. But again, I doubt if there's no rebar, the rest of the rebar is there, I doubt the anchoring is there. So how do we resolve this? We do inspections. So there's required inspections. And that is when the trench is ready, the first one is a foundation inspection. That's to verify that this anchoring rebar is there. There's the pre-grout inspection. That's when the first horizontal bar and the vertical bars are all in place. That was not done. And there's the final one. They claim the final one was done off photographs, but I'd love to see those photographs because we got photographs right here and none of them show any rebar. So it wasn't there. So there's no way that this fireplace structure is structurally capable of carrying any lateral loads that it would see from the roof. There's no rebar there. It's not in the photos. I watched for it. It's not there. Next slide, please. Okay, so I have a couple of screenshots from the Redondo Beach website about commencement of work and inspection. So I've just highlighted a couple of things here. It says, first thing, commencement of work. Only when a permit is issued can work on such a project legally start. So what that means is if you start work on a project without a permit, it's illegal. Second thing, why are inspections needed? And our inspectors confirm that actual job site conditions are in agreement with the approved plans and verify that construction materials are installed in a proper manner and in accordance with the approved plans and codes. So again, that's what we just talked about. We just talked about the 2 instances where the structure clearly isn't up to code and the inspections are there to verify that it is. So there's no inspections. There's no way that the structure can be deemed safe. Next slide, please. This is another screenshot. So this talks about the inspection. So it talks about a foundation inspection. We already talked about that. Foundation inspections would verify that the anchoring has been done. No foundation inspection was performed on any of the structure. Remember, the structure was built on August 3rd, and the inspections weren't done until October 4th, almost 2 months later. Rough plumbing, mechanical, electrical inspection. Again, that's rough plumbing, not when it's finished. You have to look at it before it's finished. Framing inspection. This is the frame that we talked about, the door frame. The framing inspection needs to be done after roofing, framing, fire blocking, and bracing are in place, and all pipe, chimney, and vents are in, before the finishing work is done, so the inspector can see the brackets. They can verify that the brackets were put in according to the manufacturer's instructions and the codes. Next slide, please. Okay, violations and penalties. It shall be unlawful for any person to erect, construct any building or structure or permit the same to be done in violation of this code. So right there it says it's against the law to build things if you in violation of the code. And then it talks about penalties for the violation. And it says a penalty for a violation shall be a fine, right? And so shall means that action must be performed. It is mandatory and required. The city is mandated to take the action. And furthermore, it means the citizens are entitled to the city taking action to prevent illegal activities. That's what fines are for. If you recall back on the letter that was from June 17th, it said that if you, the original letter from June 17th said, failure to comply will result in legal action to compel compliance. So right there, the letter on June 17th said the city was going to take action. The city's website says that they have provisions to take action. And so my question is, why was no action taken? Next slide. So now we've got the permits. So the permits are very limited. The scope of the permits is does not come close to representing the entirety of the project and what was actually built. So you notice that this permit, this is the first permit we're going to look at. Even though it's called an electrical permit, it's just for gas lines. It's gas line only. There's no permit for electrical on the fireplace. The fireplace has got electrical. There's no permit for electrical on the roof. There's heat lamps on the roof. In addition, which was missed earlier by the city, they've built a second pergola there, and there's heat lamps and televisions and lights on that pergola, and there's no permits for electrical on that pergola. All the electrical work that was performed was illegal because all the electrical work was done because there are no permits for electrical work. This permit does not cover electrical work. Next slide. This talks about the fireplace. It's called a concrete masonry unit wall, 9 feet high. Okay, so again, the masonry wall was built on early August 3rd, August 4th. The permit was applied for on September 3rd. And this is what's important. The permit is just for a standalone fireplace. The permit is not for a fireplace that also supports a roof. Remember, I showed you a few slides back that the fireplace is not capable of supporting the roof. And even if it was capable of supporting the roof, that would need to be disclosed at this time so that the structural engineer and all the people doing the inspections could inspect for the consequences of the roof. Again, the masonry structure was built in August. The permit was issued in September. All the work on the CMU was illegal. Next slide, please. This one talks about the door frame. The door frame. Again, it's the same story. Same stories we already saw. The door frame was put in early August. The permits are simply for replacing and repairing a door. But what you'll notice is that door frame, that main header beam, that's what the roof attaches to. So it's not just a door frame. It's also the support of a roof. This permit is for a door frame, not for a door frame that also supports a roof. And what's interesting is that, and this applies to the previous slide also, is that the permit was applied for on September 23rd, but on September 2nd, which I've already showed you, they already knew that the door frame and the fireplace were both going to support the roof. So why weren't they included in the application for the permit? Next slide, please. Okay, now I want to talk about the door frame inspection. So here's a picture of the door frame on August 3rd. You've seen it on the left side. On August 4th, it was completely sealed. So if we go down the right side, here's the dates. The plans were submitted to the city on August 24th. A month later, a permit was issued on the 23rd of September, and the inspection was done on October 6th. October 6th is 2 months after the door was sealed. There's no way somebody could have inspected the rough framing of that door and looked at that bracket that's in question. Inspection was not possible because the framing was not visible. Next slide, please. Same story on the fireplace. Here's the fireplace. You notice there's no rebar in that picture. You can see the scaffolding that's hanging over the fence that we talked about earlier. And here's the picture of the fireplace on October 4th, on the August 4th, on the left side. On September 10th, it's completely closed. There's no way anybody could see any rebar. It's got the tile on it. It's all grouted. There's no way anybody could have inspected that on October 8th. The inspection report, if you look on the right side, the third line down, the inspection report indicates it was inspected on October 8th. Not possible. There's no rebar in there. You can verify that from the photos that I have. But somehow the inspection was performed and approved. Next slide. So now I'm going to circle back to these criteria that we talked about. So I've given some data that are going to support these 4 lines that we've indicated here. So again, I'm going to go through these one at a time on the following slide. So if we go to the next slide, the first one we're going to talk about, the approval was obtained by fraud or misrepresentation. So it's very clear the plan submitted by the homeowner did not accurately describe what had already been built. So the fireplace details that I showed you again, and back at the end of August, plans were approved for a fireplace that didn't look at anything like what they had built a month earlier. Clearly, the plans submitted by the homeowner were not consistent with what they intended to build. Somebody told me this is a standard bait and switch tactic that people do all the time. They submit one set of plans to the city for approval, and then they have another set of plans that they build to. Again, the dates show that this is exactly what happened. On 8/27, we have approved plans with no roof. On 9/2, there's architectural drawings, which were clearly generated at the same time. They have a roof. The permits were submitted piecemeal so that the entire scope of the project was not revealed. So again, this is the door frame. When you do the door frame, we don't disclose the roof. We have a permit for the fireplace, but we don't say we're going to put on a roof. And so you piecemeal the thing through rather than getting a permit for the entire project. Again, that's another tactic that people use so they don't have to disclose when they're doing illegal work. And I don't know how to answer this. There appears to be fraudulent inspection reports. There's no way there's steel in that fireplace, but somebody signed it off. I can't explain that. Next slide, please. Okay, another reason you can revoke the administrative design review exercise of the approval violates any state, federal, or local statutes or regulations. Okay, clearly the work continued after 5 stop work orders were issued. I don't care what anybody says. It's very clear that people knew they weren't supposed to do the work. They did the work anyway. They worked through 5 stop work orders. Work was performed without the required permits. That's clear. That was done repeatedly. Even though on June 17th, it was very clear that permits are required to do construction. So now the next one is a code issue. It does not meet the building code. The door frame bracket is not installed per code. And similarly, the fireplace does not have the steel reinforcement required by the code. Next page, safety. Another reason to grant the appeal. The structure is not safe. It's not safe until it's verified safe. So without approved plans and inspections, you cannot verify the safety of the construction. Therefore, the project cannot be deemed safe because there are no approved plans or inspections. We've already mentioned there are no permits for the roof. There's no permits for the concrete masonry structure in the configuration that it's being used in. There's no permits for the door frame in the configuration that it's being used in. And so nothing is safe right now. There's no inspections for anything under the premise of what they're going to be used for. Nothing can be saved. In addition, I've shown you there are several concerns regarding structural integrity. A primary column in the house on a load-bearing wall has been notched. That's bad design practice. The door frame bracket is not installed properly. I don't know what happened there. It makes no sense how they installed the door frame bracket, but it's clearly not to the manufacturer's instructions. And the fireplace is not designed to support earthquake loads because it's got no rebar in it. A lot of people have pointed out the heat lamps and electrical work are likely a hazard because they require special electrical circuitry. And remember, there are no permits and no inspections for any of the electrical. And finally, next slide, the grant appeal on terms of a nuisance. So the approval constitutes a nuisance. So the backyard project includes a smooth tile floor. So anyone that's been in a public restroom or their own bathroom or their shower, everyone knows that a smooth tile floor creates an echo. In other words, it reflects sound. Similarly, the roof ceiling is composed of finished wood. So anyone that's been in a gymnasium, a school gymnasium, knows that it's very echoey in the gymnasium. That's because the smooth wood reflects sound. So the combination of the smooth tile floor and the finished wood ceiling creates an echo chamber that amplifies and projects sound. So I don't care what Wikipedia says. This is just kind of a common sense thing. And again, I've measured these sound levels and they are high. So the Planning Commission did address that. If you look in the green box, this is the wording from the Planning Commission approval that basically says that they shall install plantings to the height of the roof on either side of the fireplace to both buffer sound and incorporate natural elements. There was a concern from some of the commissioners regarding the harsh look of the structure, and the thought was that adding some lattice and some plantings would soften the look. And so again, the Planning Commission did address the nuisance issue. More could be done probably, but it was addressed. Okay, next slide, please. In the course of this, I contacted the Redondo Beach Police multiple times regarding the city noise ordinance. I've got some screenshots here of parts of the noise ordinance. I also provided as a blue folder item the complete codes, but basically the important part of this is that the noise ordinance is enforced in terms of decibels. I provided it here on the bottom here in the little table. You can see it's 45 and 50 decibels in the R2 zones. And so what I've underlined here in the middle says, upon the receipt of a complaint from a citizen, the noise control officer or his delegated representative equipped with sound level measuring equipment shall investigate the complaint. So, right, I called the Redondo Beach Police Department multiple times requesting them to bring out sound level measurement equipment to verify the sound measurements that I had made in our neighbor's yard that were in excess of the allowable limits. But it ends up, the city doesn't have any sound level measuring equipment. So basically we've got a noise ordinance that cannot be enforced. And I had several discussions with the Redondo Beach Police Department in last October, November timeframe. And basically their recommendation to me was that I needed to bring this issue to the city council and they need to approve funding for the tools required to do their job, which would be the decibel meters. This is in the box, in the upper right, and also training to use the tools, because right now they have a noise ordinance that they cannot enforce. Next slide. Okay, we did a little bit of talking about increasing the height of a fence, but there is a very clear California law, Section 841 of the California Civil Code, is called the Good Neighbor Fence Act of 2013, and there's also Section 841.4, which is the spite fence law, that basically says neighbors need to collaborate on fences. And so that means that, well, it says right here that in the adjoining neighbors are presumed to share equal benefit from any fence, blah, 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 and therefore they have to share equal responsibility in the costs of construction, maintenance, and whatever. So at this point, based on this law, the city council cannot approve a 2-foot taller fence in lieu of the planning commission's requirement for lattice and plantings. It just is not feasible. Next slide. Almost done. Okay. After the planning commission meeting, and we received a lot of phone calls, and people stopped by our house and asked us, what's going on? Why is this happening? And it became very clear that this all happened because Redondo Beach failed to enforce the laws. The laws, we've talked about them here. It's very clear what the laws are. They failed to do it. I asked many times for someone to enforce the laws. I said, I don't want to be in the code enforcement business anymore. I was essentially deputized to take photos and all this stuff, and it made me a villain. I didn't want to do it. There's absolutely no reason that the city of Redondo Beach did not step in those 5 stop work orders and enforce the law. It says that they will enforce the law and compel people to comply. They should have done that. So just to be sure, we circulated a petition throughout the city. We collected 123 signatures without any trouble. It was really easy. It was like asking people, is water wet? You know, everybody knows the answer, just like, should Redondo Beach enforce the law? And the answer is yes, obviously. Comments from Redondo Beach residents who signed the petition. So in general, everyone declared that someone who had been given multiple stop work orders by the city and went ahead and built their project anyway must have been fully aware that they were breaking the law. Nobody believed that somebody that did that did not know that they were in violation of the law. And nobody agreed that it was permissible for this to defy the city laws and authorities. And here's some selected quotes. It's not fair if residents bypass the permit process and build what they want. I'm still waiting for my permit for my air conditioning unit. Why should people be allowed to jump to the front of the line and build what they want by breaking the law? I'm a retired contractor. The city of Redondo Beach makes you get a permit to drain your hot tub. People need to do the right thing and get permits for the safety of the community. I can't believe that the city is not enforcing the law. How can this be? You mean all you're asking the city to do is enforce the law that's already on the books? And that's too much to ask? Wow, imagine that. People need to do the right thing and get permits. It's not fair to the residents and contracts who build legally. That's important because, again, this isn't fair. There's people that are told not to do something and they don't do it. But if you tell somebody not to do something, then they go ahead and do it, and then they're given permission that, oh, it's okay, you're not sending the right message. If everyone in Redondo Beach did what these residents did and built to their property line, what sort of place would Redondo Beach be? And one person asked, what does Christian Horvath have to say about this? So I guess we'll find out. So we gathered, as it says, more than 120 signatures. The following pages are the petition. So the petition action 4 in the second box from the top. We, the undersigned concerned residents of Redondo Beach, urge the members of the Redondo Beach City Council to act now to 1. Enforce Redondo Beach City building codes and ordinances. And 2. Use existing laws to hold accountable law-breaking residents who knowingly build non-permitted structures, especially when they are aware that approved plans, permits, and inspections are required. And again, we collected 123 signatures. So you can go ahead and scroll through those. So, as I said, those signatures were really, really easy to collect. It's clear that people expect Redondo Beach to enforce the laws. Okay, so I put together a decision matrix. I put together a decision matrix to look at the criteria here that I would consider if I was trying to decide if I was going to grant the appeal or deny the appeal. So the first criteria would be safety. And so if you grant the appeal, it eliminates risk by removing unsafe and potentially unsafe structures. So again, if you grant the appeal, you can do some code enforcement, you can go in, you can do the inspections, you can, do what's required to verify that it's safe. If you deny the appeal, then my understanding is everything's good the way it is, and In that case, the city would be liable if the structure ends up not being safe. And 20 years from now, it falls down. The city approved it without going through a rigorous, their self-defined rigorous inspection process. Law enforcement. If you grant the appeal, you condemn the lawbreakers. If you deny the appeal, you do the opposite. You encourage people to break the law. You enable them to break the law. That's not the message you want to send. You want to condemn lawbreakers. Intent of the law. Again, this is easy. By definition, accessory structures are detached from the main building. If you grant the appeal, then every, common knowledge, the intent of the law is met. If you deny the appeal, you're basically just setting yourself up for similar projects and additional manipulations of the code. That's what the people are going to expect. They're going to see this example and say, oh, we can manipulate the code, so let's just manipulate it again. And let's build our structure first and get approval later. Code enforcement. If you grant the appeal, it's consistent with the existing city codes per the community development director. Again, that's the city's authority on the codes. And you saw earlier today was presented by the planning department that they do not agree with the planning commission's conclusion. If you deny the appeal, that would be inconsistent with the existing city codes as demonstrated by the planning department earlier. Grant the appeal. Again, this is important because this neighborhood dispute, one of my neighbors called it a kerfuffle, has created animosity within the neighborhood. Again, that's a reason you enforce the code. You don't want the animosity within the neighborhood. The city needs to step up and make sure that doesn't happen. But neighborhood animosity, if you grant the appeal, it will end the discussion. It will initiate a transition to reconciliation. If you deny the appeal, it's just going to make everybody angry. Because at this point, everybody's already angry because people broke the law and they got away with it. And now if the city steps up behind him and says, oh, it was okay, and denies the appeal, then everyone's just going to get angrier and they're going to lose faith in the city to do the right thing. Neighborhood equity. If you grant the appeal, it makes everyone follow the same rules. The rules are clearly published on what you need to do when you build in the city of Redondo Beach, and everybody is expected to play by those rules. If everybody plays by the same rules, then everybody wins. If you deny the appeal, then what you've done is you've granted special privileges to lawbreakers. And that's not fair to people who obey the law. The only person that wins if you grant the appeal are the homeowners that built the structure illegally. Freedom to build. This basically means, are people free to build what they want in their own backyards? If you grant the appeal, of course they can. And I've circled this with an orange box because you're going to see a lot of testimony from neighbors and stuff that what people did in their backyard, they should be allowed to do what they want. Nobody's saying people can't do what they want. What we're saying is people can do what they want, but they have to follow the processes. If you deny the appeal, then it sets a precedent to build whatever, whenever, and however. Basically, that's what happened here. You had people build whatever, whenever, and however, and they asked for forgiveness, not permission. So the bottom line on all this is if you grant the appeal, you'll do what a governing body is supposed to do, and that is maintain order. All of the things under the grant appeal column maintains order. If you deny the appeal, it's just going to make things worse. It creates chaos. That's all I have. I will be here if you have any questions. Thank you.
Okay. Well, thank you, Mr. Stock. That was like the previous presentation, very, very, very impressive. Being an engineer myself, I can appreciate what you did, and drilling down on the codes myself. I cut my teeth being an activist. I can certainly appreciate what you've done, particularly about our noise ordinance and the inability of the city to enforce our noise ordinance. I've been talking about that since long before I even got elected to the city council in 2009. It's a sore point for me. Anyway, in this process, we give the appellant an hour to speak, as well as the applicant an hour to speak, which I think we've met that threshold. At this point, I guess, according to the rules, unless Eleanor corrects me, we take public comment. And public comment is 3 minutes each. It's getting late, folks. Let's try to be as concise as possible. You do have 3 minutes. And I'm not going to cut you off on that, but, be concise. And if you're repeating somebody, that's fine. You get to do that, but maybe just say, hey, I'm repeating what I heard and this, that, and that will help us be concise. So everybody gets 3 minutes. City clerk will keep track and say, time, and don't expect to get extended. It's getting late, and we got to get work done. So with that, I'll turn it over to city clerk, run the public comment portion of it. After that, the appellant will have a rebuttal of 20 minutes, proponent will have a rebuttal of 20 minutes, and then we'll go into council questions. Okay, does that sound about right, Eleanor?
Yep. Thank you, Mayor.
Okay, go ahead.
If you could please raise your hand, if you're on a phone, *9, and I'll go in that order. And then also we'll have e-comments right after. So the first person is Jens Wessel.
Hello, everybody. You can hear me?
Yes.
Fantastic. And thank you for calling on me first, because I'm dialing in from the East Coast, so it's a bit late here. So I appreciate it. It's indeed been a long, drawn-out process. I appreciated listening to both of the presentations. I've been involved as a supporter, and I am a fervent supporter of the project since day one. I think there's a couple of key lessons here. I think, number one, the city should look at the codes, how we can simplify them, how they're easier to interpret. It was interesting to hear the appellant's version versus the Sefnar's version. I think the planning commission staff earlier on, they might have wanted to consider to actually go out to the property to look at it, because this was all done virtually. And knowing that this project was a bit controversial, I think that's a key lesson learned. I think the Sefnars have been very consistent in their engagement, willing to do what the city required, willing to meet, willing to engage with the appellants. And conversely, the appellants have been very consistent of not willing to engage. And I'd also kind of like to know who deputized Mr. Stock to videotape kids in the evenings on Halloween and other occasions. That's not appropriate at best, right? Because my daughter was one of those that was kind of being videotaped, because I kind of saw it happen. I think also want to applaud the Planning Commission for actually doing their very best to come up with a workable solution that involved all parties combined. And I think everybody came in with good faith, and yet here we are. So I look forward to a positive outcome. I am a big proponent of it. We need to encourage more of these type of projects of beautifying our backyards. We live in arguably the best part of the South Bay in terms of proximity to beach, proximity to freeways, but we need to beautify the Golden Hills area. So I applaud the Sefnars for taking that leap of faith and doing that to their homes, and thereby improving their neighbors' property values, improving my property values, and everything. Thank you so much for the opportunity to comment.
Okay. Next person is Jennifer Dansleishin.
Yes, Danielson.
Thank you.
Can you hear me?
Yes.
Okay. Good evening, City Council members. We are Greg and Jennifer Danielson. We are writing this letter in support of the Sefnar family and their recent backyard improvements. We are a family of 5 and live approximately 1 house away from the Sefnars in District 3. We've been residents of Redondo Beach for 10 years and have lived in our current residence for the past 6 years. When we first moved into our current home on Spire Lane, the Sefnar family was one of the first neighbors to warmly welcome us to the neighborhood. Matt and Corey have always generously opened their home to friends, and it is the home that all the neighborhood kids want to be at. From assisting our elderly dog home after he had wandered out of the house more than once, to always making sure that our daughter had a successful run during the Jefferson Elementary Running Club, which Corey graciously volunteered for and oversaw, the Sefnars have been nothing but wonderful neighbors. They are the kind of neighbors that will drop what they're doing and help you out at a moment's notice. On more than one occasion, finding ourselves in a childcare bind, Matt and Corey were more than happy to lend a hand, welcome them over, and would even feed them dinner if things ran late. The recent modifications that have made they've made to their outdoor space are tasteful and completely in alignment with everything South Bay residents look for in a home. With so many properties in our neighborhood that sit there in a dilapidated state, currently lacking in maintenance and pride, one can hardly blame the Sufnars for creating a beautiful and stylish space where they can entertain and create family memories with their two children, Luke and Sophia. It is a space that encapsulates that ideal indoor-outdoor lifestyle that is in true South Bay spirit. It is beyond comprehension why these improvements would spark such anger and aggression as they have endured. I also have extreme difficulty understanding why the onus of increasing privacy falls fully on the Sufnars. Where in the building codes does it state that one neighbor alone is responsible for privacy? We currently have the same trees that the Sufnars planted, and we pay over $400 quarterly to have them maintained. That is our choice and not something that our neighbors have demanded of us. As homeowners in the South Bay, we clearly see the value in fellow homeowners and neighbors investing in their living space instead of condemning them. And need we mention that we were in a pandemic for the past year. We were spending more time than ever at home and under tremendous stress. These modifications hardly deserve the illogical and petty complaints that this neighbor is putting forward. Clearly, this is an example of a neighbor full of jealousy and a resentment. The Danielsham family enthusiastically supports the Sufnar family and their home improvements that not only bring increased value to our home and neighborhood, but most importantly, allows the Sufnars to enjoy the home that they have so lovingly maintained and invested in. We hope that you will see past this neighbor's narrow-minded pettiness and make the right decision. Thank you.
Okay, the next one is Mike Goldstein.
Okay, sorry about that. Are we good?
Yes.
All right. Thanks for your time. My name is Mike Goldstein. I've lived in Redondo Beach, District 3 for 21 years. I'm currently an elementary school principal, and I've worked as a teacher and an administrator for the past 22 years. I'm speaking today in support of the Sufnar family as great neighbors and people, and also in support of the recent backyard improvements they've made. It's hard to believe that during this pandemic, anyone would have to endure the additional stress and anxiety and harassment from a neighbor for the simple and necessary act of expanding their living area. In the Sufnars' case, this meant improving and remodeling their backyard to give more space in a time when we were all asked to stay at home for over a year. I've known the Sufnars for 10 years since our kids attended Jefferson and Paris school together. Corey and Matt are community-oriented, the kind of neighbors that we should all be so lucky to have. Prior to COVID, Corey volunteered at school, organized and facilitated the running club at Jefferson, is involved in the PTA, and she and Matt attend and support all school and community-related events, including donating to the Redondo Beach Ed Foundation. Matt is a disabled Air Force veteran. He's coached his kids in youth sports and is the type of person who would give you the shirt off his back. As an example, 3 years ago, we had a pipe burst and our home flooded while we were out of town. We returned to unlivable conditions that ended up taking 3 months to repair. The Sufnars, who were also out of town, without hesitation, invited us to stay in their house for the first week and a half while we sorted out our insurance and found a place to live. The recent decision to expand their living space during this pandemic is good for the neighborhood, the city, and most important, their family. Both Matt and Corey are forced to work at home, and their children, Luke and Sophia, have been dealing with the difficulties of virtual school along with the rest of our kids. We all need more space, especially much welcomed outdoor space. Unfortunately, during this entire construction project, they have been harassed and targeted by their neighbor. This includes the verbal arguments, photos, and video taken, and countless unwarranted calls to the city and the actual police. This harassment has had a negative impact on the entire family, especially the kids who are already struggling, as many of our teens are, with the isolation caused by school closures. The Sufnars have reached out to their neighbor on multiple occasions to try to work together and be reasonable, but they've been met with verbal aggression and additional calls to the city and police, and most recently, negative newspaper articles. Unfortunately, this neighbor has a well-known history of complaining and harassing the city and our neighborhood. At the Planning Commission meeting, it was clear they're not looking to coexist or work on a solution. Over an hour was spent at that meeting trying to work with them on a solution, and they didn't want to hear any of it. It's had a negative impact on the Suffner family and all of us who know them as friends. Please uphold the right decision and put an end to this nonsense. Thanks for your time.
Okay, next is Lisa Wessel. There you go.
Hello?
Hello.
Can you hear me?
Yes.
Oh, hi there. Good evening. My name is Lisa Wessel, and it's with pleasure that I submit my strong support for the outdoor improvements done at the Suffner home located on Spire Lane. We value the benefit this property improvement has done not only to their property, but also to the neighborhood at large. After participating in the previous City Planning Commission meeting, we look forward to the city updating outdated codes that will better serve our community and make it easier for citizens to navigate, as this benefits everyone. I can imagine the frustration the Suffners and city planners felt when navigating codes that are out of date, unclear, and do not address the modern outdoor living lifestyle we seek these days. Nonetheless, I am impressed how the Suffners and city planners work together to figure out the appropriate pathway. We do not understand why this one neighbor is so upset and invested with renovations that have been permitted and do not concern them. The appellant's presentation tonight had nothing to do with the code we are actually talking about tonight. It is not their property. Why this appeal was approved to allow this witch hunt and harassment to continue after a 7-0 all in favor City Planning Commission vote for a backyard renovation, and understanding the city building codes need some updating is also beyond me. This is a waste of valuable time for the City Council. This is clearly vengeful driven behavior, and we can do better than this. Thank you for your time.
Billy Arrett.
Hello, can you guys hear me?
Yes.
Great. Thank you, City Council, Mayor, and City staff. I appreciate the opportunity to speak at tonight's City Council meeting. I was previously prepared to comment at the City Council meeting on May 19th, and I was an attendee and prepared to make public statement at the recent Redondo Beach Planning Commission. As you're all aware, the Planning Commission made the unanimous decision in support of the structure being discussed this evening. Matt and Corey Suffner, as you guys have heard on multiple occasions now, are hardworking Redondo Beach professionals who I've only known to be kind and considerate. More importantly, they're also contributing members of the local South Bay community, and they generously donate their time towards projects like Feed the Children, Redondo Sunset, and numerous RBUSD events that immediately better our community. I've had the opportunity to participate and listen to the public comments, testimony, and prior decision made by the Redondo Beach Planning Commission, and now this being my second City Council meeting. Participating in this civic issue has honestly given me the ability to witness firsthand the city planning process, and I commend the City Council for its willingness to hear the multitude of issues confronted by its citizens. I'm sure you guys hear a lot of things. And while I am here to express my strong support of this outdoor project, I can't avoid the realization that this governing body has way more important agenda items to handle as stewards of our community. The decisions you're asked to review have much more significant impact on the citizens of the city, and I would much rather you all spend your valuable time discussing the future of our city rather than a home improvement project. In listening to the comments from the city staff and the corresponding code, it became very apparent to me that the planning code was far from clear and resulted in multiple clarifying questions from the Planning Commission to the city planners. In the end, the Planning Commission has fulfilled their responsibility and delivered their best judgment with their approval of the Suffner structure. As a matter of enforcement, as was part of a previous discussion, I'm sure you can agree it is very challenging to enforce building code related to this structure when there is so much room for interpretation. The Suffners have taken the appropriate corrective measures, paid for permits and penalty fees associated with the construction project. Their only goal with this home improvement was to raise the value and appeal of their community and provide a safe and happy place for their family to thrive. And in closing, I would hope that the City Council members agree with and uphold the decision already made by the Planning Commission and ultimately approve the structural improvements made by the Suffner family. Thank you for your time this evening.
Carrie Hayes.
Good evening.
Good evening.
My name is Carrie Hayes, and I am along with my husband, Bob Hayes, and I wanted to thank the mayor and the city council for all of your hours of service. I have been a homeowner in Redondo Beach since March of 2001, and I sat on the last city council meeting until 12:49 a.m., and I just want to thank you for all of your years of service, because sitting through these meetings and watching the Suffners go through this process has been very challenging on all of us. And I first want to just thank you all for your support and your service, because I never knew that city council meetings went until 1 a.m. So thank you, first of all. I wanted to let you know that we've been homeowners in Redondo Beach since 2001, and we've seen lots of our neighboring cities, real estate go up in value and lots of home improvements being done. You look at Hermosa Beach, Palos Verdes, Manhattan Beach. This gentleman tonight was talking about those doors, and I can tell you in Manhattan Beach, probably 70% have those doors. And that realtors say today that improving your indoor-outdoor space is all that the millennials are looking for. And it is the #1 home improvement project to get your return on your money. It is the #1 project. So as a homeowner in Redondo, I thank the Suffners, and I walk around that neighborhood and I see a lot of the houses unkept. And as a homeowner there, it's quite frightening. So for us to have community members, city council members, and property owners improving their property, we should all be thankful for that. We want our property to keep up in Redondo. It's the same thing happening at our pier. You know, look at Hermosa and look at Manhattan. They've been keeping up their pier. Look at all of that revenue that is being generated in those cities. So I am all for the improvement in Redondo Beach, whether it be for our city parks, our restaurants, our pier, and of course our homes. They've owned that home for almost 20 years. You're supposed to improve the home. And when you look behind, the neighbor has not done anything to improve their home. And on another note, my daughter has been over there in the evening as a young middle school daughter, and it is quite frightening to have somebody poaching on their space. Quite frankly, it's harassment. And I'm scared sometimes for my daughter to go over to their home because of this gentleman from behind. So the fact that they've spent so much time on the Suffner's home, they could just go outside and power wash and get a good use of all of the other neighbors' time. I thank you so much for your time and for you guys to listen to us. And I know we're emotional, but you've had a group of these people on for more than 15 hours for a couple of meetings. And I'm thankful, and we appreciate your time today. We hope you make the right decision.
Thank you. Next is Rolf Struttenberg.
Good evening, Mayor and Council. Rolf Strutzenberg, Redondo Beach. I was a member of the Planning Commission that voted 7-0 in favor of the decision for the roof structure to be attached to the residence. So it's no secret that I'm normally the one to research the Muni Code to find out why something should not be allowed. In this case, I was not able to make such findings. In fact, everything I found supported that what was built did not violate the code. In summary, what is built is clearly an accessory structure and not an accessory building. This is undisputed, and the Suffners had pointed out the differences between those. A 5-foot setback is required between a dwelling unit and an accessory structure under 10-2.1500A. That's true. However, section 10-2.1522 creates an exception to allow for the projections into required setbacks for eaves and other similar elements of up to 30 inches from both the dwelling unit and the accessory structure. So 30 inches from each, total 60 inches, thus bridging the 5-foot setback for such elements. The reference made by staff to 10-2.1522A to F with the height limitation of 9 foot would apply if this were a pergola, which we have all agreed it is not. As an accessory structure, the height limit is 15 foot as defined in 10-2.1500C1. Finally, under 10-2.402, while accessory buildings are specifically defined as detached, accessory structures are defined only as a structure which is subordinate to the main building. An accessory structure is not required to be detached. The Planning Commission's 7-0 decision to allow the accessory structure roof to attach to the main dwelling is in full compliance with the municipal code. It is also noted that attaching the accessory structure roof creates a more stable, structurally sound, and less bulky solution. It's actually an elegant solution that does not violate code. During the Planning Commission meetings, it was quickly resolved that the only issue was the accessory structure roof attached to the main residence with regard to the 5-foot setback. All other issues had been cured or were in the process to be cured, which is in line with what is stated at the city website, that the intent of the chief building officer is not to prosecute citizens. Rather, it is his desire to assist those citizens in correcting any violation and secure proper after-the-fact permits and inspections. That's what has been done here. It is no easy process for the people that went through this. So with that, I encourage you to deny this appeal. Thank you.
The next person is Carrie Bossi.
Hi, thank you. Can you hear me?
Yes.
Just wanted to read the letter that I had written previously, but also have a few comments after. So I'm writing this letter on behalf of our friends. We have known each other for over 10 years and have watched our kids grow up together in this amazing community and neighborhood. A community that we hope to spend the rest of our lives in, growing old with our families, neighbors, and friends. Like many of us in the South Bay, the Suffners enjoy the outdoors, not only at the beach, local parks, and athletic fields, but also time spent with family and friends at home. The beauty of the South Bay is that our weather is amazing. That means a lot of family time at home outdoors, either in the front yard, patio, or backyard. The more time we spend outdoors, the more we want to make that outdoor space special, and the more we want to create opportunities for people to come together. Matt and Corey have done just this. They have created an amazing backyard space that allows for their kids to play with their friends, for adults to come together to watch a game or sit by the fire, and for their family or four to enjoy meals, birthdays, and holidays throughout the year. Their newly built outdoor space is absolutely beautiful, a space that almost every neighbor would love to add to their home. The addition of this space has most definitely increased the value of their home, which means other homes on the street and the city of Redondo Beach will also benefit from that increase. As you know, Redondo Beach is a city where we strive to enhance the quality of life for those who live, work, visit, and play in our community. Saying just that, the city of Redondo Beach needs to support the residents of Redondo Beach and the families in its community, families that work hard every day to enhance the quality of life for their own families and continuously improve the community in which they live. The Suffners' backyard improvements have absolutely enhanced their quality of life for them, for their neighbors, their friends, and ultimately for our community. The city should support these efforts not only for the Suffner family, but our community overall. And I think that's what's so important, is that we need to recognize that this is a community improvement. And you guys are here for the community. And unfortunately, as I'm looking at this computer screen, I see 2 city council members on video. So where is everybody else? Where is the mayor? Where are the other people? What happened after the first 3 hours that we sat here and listened to you? Why are you not publicly showing your faces? This is important for us to hear this. This is important for you to support this. and you should be actively participating and listening to this cause. I don't care that we are at 10 or 4 hours out. This is important. This is important for the Suffners. It's important for the community, and it's important for everyone. And the fact that people are shaking their heads and not paying attention and not listening is really disrespectful. So I would say what you should be doing at this point in time is paying attention to this cause and listening to this hearing and supporting the Suffners 100%. Thank you.
Next person is Jasmine Rashes.
Hi there, can you hear me?
Yes.
Hi. I'm not really sure how well I can follow that really powerful speech, but I will definitely try. My name is Jasmine Rasek, and I would like to share with you my personal and professional opinion regarding the Suffners project to beautify their home. I have lived and worked here locally in the South Bay for over 30 years. It is clear to me that this structure is compliant with the written code. As a real estate professional and a mortgage professional, I know that one of the driving forces for our booming real estate market is our beaches and our beautiful weather. Buyers are looking for homes with outdoor living space so that they can enjoy the great weather, thus making homes with outdoor living spaces statistically sell much faster and at a higher price than homes with no outdoor living space or homes that have unfinished or unkept outdoor space. Now more than ever, buyers and sellers are realizing how important it is to have a well-maintained and functioning outdoor space because most people are working from home and or have kids that haven't returned back to school on a full-time basis yet, making it necessary to utilize this much-needed space. My professional opinion, I think the structure in question is complying with the current City of Redondo Beach municipal codes. Personally, I have been dear friends with Corey and Matt for over 20 years. I am 100% in support of their beautiful project and wanting to beautify their home. I will say that I have had very little experience lately going to their home because the last few times that I was there hanging out, just Corey and I and Matt having a conversation, I did see the neighbor in the back videoing us. That makes me feel very uncomfortable, a bit towards violated and harassment. I don't have young kids, so I can't imagine what it's like to have teenage girls that live in the house and you're constantly wondering if your next door neighbor or your back neighbor is videoing you. But my choice is to not go there as often as I used to because I just don't feel like hanging out at my friend's house and feeling uncomfortable. Again, my other personal opinion is that this matter could have been and should have been resolved between two neighbors. This is something that could have been talked out and worked out between two neighbors had the back neighbors been open to a resolution. And unfortunately, we are here for the second night in less than a month, listening and waiting to get something resolved that should have been resolved a long time ago. Anyway, I thank you for your time, and hopefully this will be the end of it and you will support the Suffners like we all do. Thank you.
Marina Moore.
Hello.
Hello.
Hi. Are you able to hear me? Yes?
Yes.
Okay. So clearly I am a great friend of the Suffners, otherwise I would not be up right now. I am a resident of Redondo Beach. I am actually a school teacher in the district, and I live in District 1 for 8 years now. My husband and I have known the Suffners for 7 years now, and so we definitely wanted to speak on their behalf. I had a big letter for the last meeting, but after tonight, I did have to change my wording. Something that struck me was the quote, "It is not what they built, it's how it was built." And that just gives me the clear idea of why we're here tonight, and it's clearly vengeance. Clearly, there's really no issue about the structure and how far it is from the house. We listened to her presentation about a door for about an hour. I mean, it's just, to me, it's insane how much this man knows about the Seffner's house and how he has seen the door structure that clearly. I moved here from Bakersfield, California, where we had a lot of space, a lot of open land, big property. So my idea when I moved to Redondo, knowing that it is a pretty much concrete jungle, you cannot expect to have quiet and peaceful times in your backyards. It's just not going to happen. We're one on top of another, 3 on a lots, 2 on a lots, kids running around, and that's what Redondo Beach is, and that's why we moved here. So having the noise level issue, that's just going to happen, and that's just what we live with here in Redondo. I have also experienced, yes, the videotaping and the photos, and actually it was not on a day that construction was actually happening. It happened during a Christmas brunch at 12 o'clock noon, and we had 3 visits from police officers within about a 6-hour period, all before probably 7 p.m. And so to me, it just seems like this is becoming a bit out of control, out of hand. I was really uncomfortable when we saw the video, and as soon as they saw us take note that they were recording us from their top floor, they quickly pulled the camera back away from the window. So that's concerning to me that apparently he's saying that the city has told him to take pictures and videos of what's happening in the Seffner house. So that to me is something to be looked into. Overall, I won't sit and take more time from you. Obviously, the Seffners are an amazing family. They've done a wonderful job on their backyard. I mean, it's caused my husband and I now to start our backyard renovations. It's all we have here in Redondo, so we have to use our space wisely. And yes, home improvements are 100% needed here in Redondo Beach. I thank you for your time, and I hope that you make the right decision tonight.
Thank you. Next person is Paige Howell.
Hi.
Hello.
Hi. I have been a friend of Corey and Matt's for over 15 years, and actually neighbors for over 15 years. We have kids that are, weeks apart. I am in definite support of their outdoor space. It was such a great space that I could go and feel comfortable during this pandemic, having older parents and wanting to be outside. It was definitely a place that I felt safe and comfortable. It was also a place that our kids could go to where I felt that they were also safe, and it was a nice outdoor space where they could socialize. I am kind of echoing Verena. I was over at an early Christmas brunch and was also, I saw some paper blinds go up, and I noticed a man filming and recording us. They did start calling the cops. I think maybe 4 people were there. It was probably 11:30, maybe 12:30. They started calling the cops. They've done everything in their power to make everyone feel very uncomfortable. I felt violated. It just makes you feel like you can't enjoy your home. And that just makes me sad because, they say there's no place like home. Well, they're taking that away from them, and they're taking it away from their friends, because you don't feel comfortable when you think, oh, someone's watching from their paper blinds, they're pulling them up. Anyway, I hope that you guys will make the right decision. Like we said, it just seems very vengeful, and it's not about the space, because it's not about the space. There's so many horrible unkept homes. There's a home on the corner that I live at, and there's 3 used lawnmowers. It's a complete junkyard. If we want to start doing, we need to focus on things like that versus people beautifying their homes. And I hope that you'll take that in consideration.
Thank you. Okay, so anyone else, you only have one time to speak. I don't know if anyone in Zoom, please raise your hand. Otherwise, we're going to go to e-comments, which Vicky, we have 10, I believe.
Okay, the first comment is from Ling Yu Kung. My husband and I have been neighbors with Corey and Matt Suffner for the past 3 years and are writing in support of their home improvements. As newer residents to Redondo Beach, we could not have asked for a more like-minded, considerate, and thoughtful set of neighbors than Corey and Matt. Over the past few years, we have greatly appreciated and benefited from their desire to both maintain the appearance of their home. You'll often find Matt washing down the house and fence on weekends, and also creating and improving value to our shared property. When we first moved in, Corey sent us a list of painters, woodworkers, and remodelers, knowing that we were interested in updating our home. In the past 2 years, we partnered to install new plants and lighting on our shared driveway. Corey also single-handedly convinced our side neighbors that we needed to replace our shared wooden fence that was falling into disrepair with a lower maintenance vinyl fence. She did all the research to find high-quality vendors at a reasonable cost for all 4 families. When we refinanced our home earlier this year, we were delighted that the collective improvements we made increased the value of our home. Corey and Matt are extremely considerate neighbors. Corey knew that we needed peace and quiet while we adjusted to life as parents of a newborn. Our son was 2 weeks old when her daughter had a birthday party. Fearing it would be too loud for the baby, Corey and Matt offered to put us up in a hotel so we and the baby could get a good night's rest. During this remodel/improvement period, Corey and Matt have been transparent and good communicators about the work being done and the noise level for which we are very grateful. We know that the updates and improvements Corey and Matt make are always tastefully done with the intention of improving not only the value of our property, but also the value for the homes in the neighborhood. We encourage the City Council to uphold the Planning Commission decision and oppose this appeal. Next comment is submitted by Greg Thatcher. To whom it may concern, as a longtime resident of North Redondo Beach and a realtor in the South Bay for over 13 years, I'm providing this letter from a professional point of view. I have reviewed countless properties in this area and found the backyard improvements of 2015 Spire Lane No. B, Redondo Beach, would substantially increase the value of the subject property. The design was well planned and executed with excellent attention to detail. Quality of the materials and workmanship are both above average. They do not negatively impact the value of any of the surrounding properties. As well, improvements and consistent with the general look and feel of the neighborhood. There is not, in my view, any reasonable argument that it is anything but a valuable addition to the neighborhood. In my opinion, having neighbors who invest in their homes with improvements only increases property values for the area. The Suffners should be considered valuable neighbors and to have on your street. Sincerely, Greg Thatcher. Next comment submitted by Jean Leary. We are writing to you in support of our friends Matt and Corey Suffner in regards to their recent addition to their outdoor/backyard space. We are a Redondo Beach family who has known and have become close friends with the Suffners for greater than 12 years. We have spent countless family gatherings at their home over the years. Matt and Corey are hardworking Redondo Beach residents and professionals who are kind, considerate, generous, and very much admired and respected by many in our community. We are having a hard time understanding why their backyard has received the attention of the City Council. With everything going on in our community these days, it is embarrassing to think this is how we are using our city resources. What is the point of having a building planning department and appointed planning commissioners if you do not empower them to do their jobs and uphold their decision-making authority? Up until these recent backyard renovations, when visiting the Suffner home, we have felt safe, comfortable, protected, and private. Since their backyard space has been renovated, visiting their home and spending time in their backyard, we have had our conversations recorded by the neighbors, and we have had the police called on us, their guests, multiple times due to noise disturbances in the middle of the day. We have felt violated by these activities initiated by their neighbors and feel that it is shameful in the context of a pandemic when most of us are working from home and schooling from home and wanting to spend more time with our friends and family outside where it is safer. Instead, it feels as though the Suffners are being punished for improving their home's property value while at the same time improving the quality of life for themselves and their children. I hope you can see through all of this and allow the Suffners to live in peace and deny this appeal. Today's appeal is just another example of their refusal to be neighborly, and their vindictiveness toward the Suffners is clearly evident. Thank you for your consideration. Respectfully, DJ and Jean Leary. Next comment submitted by Patricia Moore. Today is a demonstration that our processes are broken and there are more pressing city matters that need to be addressed. How an appeal to the council was approved after a 7-0 vote by our planning commissioners on a low priority backyard project needs to be investigated, as the appellant's appeal is baseless. Allow the planning commission the authority to adjudicate these matters. The March 18 or 3/18 commission meeting ran 4 hours. The Stocks had their voice heard as the commission extended their speaking length 3 times. The public had their voices heard. A decision today against the Commissioner's 7-0 vote will not only undermine the Commission, City Building and Planning Department charters, but will bring more frivolous appeals to the Council. It is known the Stocks are extreme animal rights activists and use their skills to harass the Suffners and bully the city on a campaign that should not even be a topic of these proceedings. They are using this hearing as a bully pulpit for their own agenda, which is insubordinate to these proceedings. Think about their behaviors over the last year. Consider their 2 appeals in 2002, bullying the city to have trees planted in someone else's backyard of which they benefited from. And the tipping point publishing an irresponsible, biased article in the May 18 Easy Reader paper condemning the actions of our city leaders and attempts to damage the Suffners' reputation. Consider the attempts made by the Suffners, the commissioners, the council, the alternate dispute resolution lead, all reaching out to the Stocks on several occasions to bring resolution. Again, the Stocks' refusal to be cooperative or compromise. I ask the council to not be bullied by one resident who is out for vengeance. As reasonable people, we all agree the improvements made by the Suffners are beautiful, built and fully compliant to the code. Neighbors are not against the Stocks and are standing up for what is right as they see what has transpired here today. We all are in full support of this project. Put an end to this and allow the Suffners to live in peace. I urge the City Council to vote to deny the appeal and uphold the Planning Commission decision rendered on March 18, 21. Submitted by Christine Abramowski. Dear Redondo Beach City Council, I am writing on behalf of the Suffner family and to show my support for the beautiful addition to their home and to our community. We are neighbors of the Suffners and are in shock that a unanimous decision by the appointed planning commissioners is now at the City Council level. We are concerned that this is how our valuable local city resources are being exhausted as a result of one maladjusted neighbor. Redondo Beach residents want outdoor living space. This is one of the main reasons we all choose to live in this community. We, just like the Suffners, have teenage children who have been told to stay locked inside for the past year. They've been stripped of all normalcy as they knew it, as a way to safely provide their children a place to socially distance with their friends and to help to avoid depression and anxiety that was showing up. Corey and Matt made a wise investment for their family. Their outside space is tastefully done, pays attention to detail, and provides the space needed to safely congregate with family and friends during this incredibly difficult time. It is Corey and Matt's love for time with their family and friends that motivated them to move forward with the project and spend a sizable amount of money during a most unstable period, and this is a characteristic that our city should cherish in its residents. I am proud and grateful for them as our friends and neighbors. We ask that you take all of these things into consideration and support the outdoor living space, which is clearly compliant with the Redondo Beach Municipal Code in place today. Respectfully, Jim and Christine Abramowski. Next comment is from Kirsten Rosenberg. I support this appeal. The additions to this residence are a travesty. It's hard to believe so little consideration has been given to adjacent neighbors and the surrounding neighborhood. It truly is criminal, and the law needs to be upheld. Next comment is from Marshall Gelb. To whom it may concern, we have lived in Redondo Beach for 41 years. We are the original owners of 2017B Spire Lane and have resided here for more than 33 years. In that time, we've watched the neighborhood change from single-family houses to predominantly 2 on a lot. Over the years, we have worked cooperatively with our neighbors, current and past, regarding fencing and tree trimming. Currently, we live directly east of the Suffner family. We share a new vinyl fence, which we cooperatively financed and had built to replace the old worn-out wooden fence. The Suffners have always meticulously maintained their property and have recently improved the living area in their backyard. We feel that these improvements are very well done and enhance the property. We are writing this letter to express our support of the backyard improvements. We concur with our neighbors, the McAvee family, that it is refreshing to see neighbors that invest in their home and community. Their improvements to the driveway and backyard area are tastefully done and adhere to the diverse architectural styles throughout the neighborhood. Their improvements and their significant financial investment contribute to the overall property values in the area. The Suffners have always been considerate neighbors. They have notified all impacted neighbors regarding their construction and the lengthened timetable due to unforeseen circumstances. We feel it is quite unfair for one homeowner to create such difficulties for the Suffners when the majority of the surrounding homeowners feel that the improvements are beneficial to the overall community. We hope that you consider all these facts and rule in favor of the Suffners on this matter. Sincerely, Marshall and Diana Gelb, 2017 B Spire Lane. Next comment is from Jerome Chang. The following is my professional opinion as a licensed architect with 20 years of experience. Additionally, my opinion is not intended to disparage any parties involved. There seems to be some level of politics involved with the history of these appeals, when the proposed structure should have been already denied on technical reasons alone. The reason this issue should be determined only on technical reasons is because the current owners may sell, but the structure remains permanent. No amount of nice neighborliness or even beautiful design should factor in for this structure. Therefore, I would like to remind council that there are at least 2 technical issues that should be left only to the building and planning departments to address. 1, fire spread to neighboring buildings is more likely when any building encroaches a setback. 2, precedents do not necessarily mean they justify a proposed structure to be approved. One would have to verify each and every precedent to see if they were properly permitted. Many of these seemingly ad hoc structures were not permitted. Further, a structure that was permitted 20 years ago may not be compliant if built today. This is why the planning and building departments take the opportunity to encourage and enforce compliance to today's code for any proposed design they review. Finally, while it is great that the property owner has great neighborhood support, what I find missing is support from any licensed architect. Please note that a licensed professional who submitted the proposed design of this structure was a structural engineer, not a licensed architect. An engineer does not readily deal with the safety issues of setbacks and adjacent structures or the code issues of precedents. They primarily focus on the structural integrity of the proposed design in isolation of other structures. Submitted by Susan Hartland. The building laws need to apply to everyone. If you want to make improvements or changes, you have to apply for and get permits that comply with the current laws and building codes. This work continued through 5 stop work orders and multiple warnings. Ignoring warnings and a lack of permits for this structure is irresponsible, inconsiderate, and illegal. Submitted by Michael Dworsky. I support the Stock's right to have Redondo Beach city building and zoning codes enforced. We cannot allow anyone to build anything they want without following the law. It should be abundantly clear that the city must be able to stop illegal development, and no planning commission decision should favor individuals who did not pay city fees, did not obtain city permits, did not follow city codes, and then ignored the city's request to stop building unpermitted structures. This should be self-evident. The city should enforce its own laws. Otherwise, what is the point of having laws? Can anyone do whatever they want with their property? Allowing the planning commission's wrong-headed decision to prevail sends a clear message to all city residents. Build whatever you want. We won't stop you. In fact, we will approve it after the fact. This is wrong, plain and simple. I sincerely hope the council recognizes this. Respectfully yours. That concludes the public comments on e-comment for this item.
Okay, Mayor, this is it. So this is
All right.
this is the conclusion of the public comments for 3 minutes. So next would be the appellant rebuttal for 20 minutes.
Yeah, great. Thanks. First, I want to thank everyone for their comments and hanging in there. It's obviously well thought out. And as you said, as Eleanor said, it's time for the appellant to have 20 minutes. Mr. Stock.
Hi, it's actually Mrs. Stock.
Oh, hi, Ms. Stock.
Hi there. How are you? Thank you so much, Council, for listening to us tonight. I wanted to just say good evening to the council members, to the mayor, to other city officials and staff. My name is Lisa Stock, and I am one of the homeowners who is asking you to overturn the Planning Commission's decision to approve the neighbor's attached accessory structure, concur with the recommendations of your staff, and grant this appeal. I have worked for charitable entities and conservation for more than 20 years. My husband has worked in structural and aerospace engineering for 35 years. We've lived in Redondo Beach for 33 years, and we love our home, our lifestyle, and our city. Among your blue folder items, you will find several letters supporting our position from a neighbor, a realtor, and 2 private homeowners, real estate developers. Allow me to highlight some excerpts. From our neighbors at 2016 Belmont Lane, Beth and Ken Mulholland. We are the next door neighbors of William and Lisa Stock and have been friends of theirs for 18 years. We have been very disturbed to hear the Stocks have had such immense difficulty with the neighbors directly behind their home for the last year. These individuals have built an oversized structure in their tiny backyard without any setback. Furthermore, they did so illegally without securing the necessary permits or approved plans and in defiance of 7 violations, stop work orders, and warnings issued by the city. We are wondering why the city allowed the situation to get so out of hand. According to what we understand, this project does not meet building codes. If Redondo Beach enacts building codes, then it should be their responsibility to enforce them, not the Stocks. Otherwise, it is the city's responsibility to change the codes. This situation has managed to cause a great deal of animosity among our neighbors and place the Stocks at the center of it. Please do the right thing and take responsibility for your laws. The actions you take tonight will send a message to all of Redondo Beach that either we are a lawful city or a lawless one. Lawbreakers should not be given preferential treatment. We also want to add that the neighbors at 2015 Spire Lane who built this illegal structure worked to retaliate against the Stocks by rallying the neighborhood against them, all because they reported this illegal project. We know of several neighbors who have been afraid to speak up about this issue due to the bullying tactics by these vindictive homeowners. When they gathered support from around the neighborhood for their construction project, we wonder if these individuals happened to mention that their structure was built illegally. We highly doubt that they did. From managing broker with Real Logic Sotheby's International Realty, Rick Maynard. This letter is in support of William and Lisa Stock regarding an appeal before your body. I have been long-term friends with Bill and Lisa. The Stocks are very ethical, honest, and bright people who have a general live and let live attitude about life. I've been a realtor in Washington State for 20 years. Currently, I hold a position as a managing broker and Real Logic Sotheby's International Realty in Seattle, Washington. I have dealt with permits, plans, inspections, and I've also assisted my clients over the years with navigating permits, plans, and inspections with multiple building agencies. As a realtor, I'm generally pro-growth and development, but not all development is warranted. In a previous lifetime, I was a staff member of the Washington State House of Representatives and worked with the committee chair, Maria Cantwell, of the House committee who drafted our Growth Management Act of 1990-91. Now, U.S. Senator Maria Cantwell, Democrat, Washington. She worked to create a fair system that balanced the needs for growth while maintaining the integrity of good design and planning, but also preserved rural and open spaces. The Redondo Beach Planning Department seems to have not issued permits for the addition in the backyard of the Sufnar's family home. Land use designations and permits exist for a reason: to create a fair and balanced system for a comprehensive plan to add both aesthetic values and preserve quality of life. Ignoring your own professional planners in the city building department will set a precedent for homeowners to simply ignore zoning, permitting, or design guidelines. In my experience, residential structures that are not built to municipal, state, and federal building codes negatively impact the property values of the adjacent properties in a neighborhood. From private real estate developer and homeowner Mike Dorsky. I'm a homeowner who has remodeled 5 houses for my own personal use in Los Angeles and Washington State in the last 22 years. I've worked with general contractors on some projects and acted as my own general contractor on others. Here we have a situation where it appears residential building permits were not pulled and zoning and building codes were not followed, and warnings from the city of Redondo Beach to cease construction were ignored. I believe that anyone who has purposely built unpermitted structures should be required to come into compliance with everything they have built, and anything that does not meet current code or zoning regulations should be removed. If that does not occur, what message does it send to other residents and builders who want to ignore building codes and laws in the future? Do whatever you want because the city of Redondo Beach won't enforce existing laws. I also don't understand a planning commission decision to ignore such violations. Is a precedent being set for future development in general, or was this a one-time exception? If it was a one-time exception, why was it allowed? I have known Bill and Lisa Stock for 38 years. They are honest and considerate people who have been responsible citizens of Redondo Beach for more than 3 decades. They are simply requesting that the existing laws, rules, and codes of the city be enforced. This should not be too much to ask. No single homeowner should be able to adversely affect the quality of life and the property values of their neighbors by willfully not building to code and permit. From private real estate developer and homeowner Mark Muller. My friends Bill and Lisa Stock, whom I've known for more than 2 decades, are good, reasonable people. They've lived in Redondo Beach for as long as I've known them and love their home and city. However, their enjoyment of their home was severely disrupted last year when a neighbor began what I understand to be multiple unpermitted building projects. I'm a homeowner who's renovated several houses in the state of California. I've worked extensively with city building and zoning departments in order to gain permits for these renovations, so I'm well aware of what you must do to be a good citizen. Get the approval of your city before you start a project. I may have been frustrated with the limitations imposed on me occasionally, but I understand why there are limitations in place. They protect property owners from unsafe, illegal structures and rampant, unpermitted construction. Unpermitted projects can ruin neighborhoods. They also rob residents like Bill and Lisa Stock of the ability to enjoy the quality of life that I hope the city of Redondo Beach would ensure. I hope you take the appropriate action to remedy this situation. That concludes the letter excerpts. Now I'd like to conclude with my statement and some of the rebuttals, which will include the rebuttals. What my husband clearly showed in his presentation tonight is that our neighbors who illegally built their backyard structure did so knowingly and deceptively to skirt the law, to the point of even having two sets of plans so they could bait and switch their project with the city. When we reported them, they declared we ratted them out to the city, and they retaliated by spreading mistruths and defaming us throughout our neighborhood. This is apparent in the defamatory words they've used to negatively characterize us in their presentation to the Planning Commission. And even tonight, those untrue and defamatory remarks continued in their presentation and in the public comments from their supporters who spread mistruths such as we verbally attacked them, or we are somehow maladjusted, or other falsehoods. It's important to keep in mind these people don't know us, so everything they are saying is hearsay. And that hearsay is coming from the fabrications they were told by the neighbors at 2015 Spire Lane. Name-calling and personal attacks are common tactics used to divert attention when there is no valid argument to support one's case. They are also the MO of individuals who believe they are entitled to trample upon the rights of others. This evening, you have an opportunity to correct a wrong and end this nonsense that we have endured for the last year. I was a proud commissioner of this very city on the Environmental and Public Utilities Commission for 4 years in the 1990s. I take my civic responsibility seriously. It's unfortunate that this matter had to escalate to where we are addressing you here tonight, but had the city enforced the law when we first reported this matter a year ago, we would not be here. Tonight, we are asking you to not only bring the Neighbors Project into full compliance and issue meaningful citations to the homeowners at 2015 Spire Lane for repeatedly and knowingly breaking the law while creating widespread animosity in our neighborhood. We are asking you to look into ways to prevent lawbreakers from defaming their neighbors who are acting as good citizens on the city's behalf. This is a serious matter because if allowed to go unchecked, it will deter citizens from reporting suspected illegal activities in our community or otherwise cooperating with the city in the future due to concerns of retaliation. With all due respect, by not enforcing the law, the city enabled this retaliatory behavior. During the course of this matter, we have spoken with several licensed contractors and builders in Redondo Beach. They told us that they are irate because they have gone to the city asking to build similar attached structures at homes they were building, but they were denied. So of course they did not build them. So if the city denies this appeal and residents are watching, it seems that if you want to build something, just do it illegally and you will be forgiven. But we all know that if a contractor had built a structure like this in defiance of the law, they would have been fined and reported to the Contractor State License Board, potentially losing their license and their livelihood. How is this fair? Why should law-breaking residents receive preferential treatment? Residents are upset as well. As you saw with our petition, 123 adult residents we queried from all throughout Redondo Beach, from Riviera Village to Dominguez Dog Park, from Burl Avenue and Artesia Boulevard to PCH, they all believe that illegal residential construction should not occur in our city. And when it does occur, it should not go unpunished. People have stopped my husband in the street wondering why this project has been approved despite the residents' blatant disregard for the law. I'd like to add that from the beginning, the neighbors have verbally expressed their confidence that they would get to build and keep whatever they want in spite of the law. We are all wondering why. There's been discussion about the neighbors' children being impacted by the events of the last year. Our children have been impacted too, including having a video camera pointed 24/7 into my 20-year-old daughter's bedroom window to surveil us. Our children are older, they're voters. But there's a bigger issue at stake here that I want them and all of our kids who may be watching to learn. And that is that the government is there to uphold the rights of all citizens fairly and equally, and that there are consequences for those who bully others and break the law. There is no question that from the beginning, this was a calculated effort by our neighbors to deceive the city, and those efforts should not be rewarded. Please do what we elected you to do as city council members and send a message to those who choose to willfully defy the law and build illegally that the city of Redondo Beach is a law-abiding city. Bring this structure into full compliance by removing or rectifying what does not comply. While the neighbors would like you to believe that they are the victims here, that is simply not the case. The victims here are all the citizens of Redondo Beach if the Planning Commission decision is allowed to stand. If you approve the appeal, everybody wins. A message is sent and lessons are learned. But if you deny the appeal and uphold the Planning Commission decision, only our neighbors at 2015 Spire Lane prevail, while our children and everyone in the community will lose because they will see that our government is broken and that lawbreakers win. And one more thing I wanted to add, and that is that it seems that these particular proponents of the structure, the neighbors, have trouble following rules, because you notice that in all of the comments from their supporters, they were having meetings and gatherings during Christmas, during Halloween, during Thanksgiving, and we were under pandemic orders by the governor at that time to not gather. So I think you can see who are the law-abiding citizens versus who are not the law-abiding citizens in this scenario. Thank you for your time.
Okay, thank you, Lisa. Next up are the proponents, softeners. Go right ahead. You have
Yes, thank
20
you. One
minutes.
second, please.
Hello again,
Hello.
William and Corey.
Okay, slide 39, kind of a continuation from our previous slide deck. So, reporting the news and the actual facts at hand. Ever since the removal of our trees, there have been over 28 documented incidents that have transpired over a 7-month period, which equates to on average to 1 incident per week. I am very sad to say that our children today are afraid and uncomfortable to go into their very own backyard. We all know backyards are intended to be a source of enjoyment, not a reminder of undue stress and emotional distress. Over 17 known complaints filed to all levels of city leaders, including the mayor, 8 complaints filed to the police department, several instances where family and friends have bared witness to being video and audio recorded, and the appellants caught taking photos, not to mention other documented outrageous conduct that has transpired. Even after all of these transgressions, and considering that as a father, my sole purpose is to ensure the welfare and safety of my family, still in the spirit of being neighborly, patient, and kind, we have not taken any action against the appellants in the hopes that there could still be a resolution. We have been passive in our conduct and behavior. Here on slide 41, my family, as we mentioned before, we're kind, we're well respected, we're very active in the community, serving and giving to others. We believe in the golden rule, or the ethic of reciprocity, the principle of treating others as one wants to be treated, particularly our fellow neighbors that we live amongst. Unfortunately, we still do not understand the appellant's grievances, given the accessory structure fully complies to the building code and the many attempts made by us, the city planning commissioners, the city's alternate dispute resolution department, the city council, and late night discussions during the March 18th planning commission meeting to find some kind of solution that meets the needs of the appellants. We do not understand as a neighbor why they have never stopped by to talk things out or to even write us a note after all these years. Phone calls, letters, face-to-face engagements at all levels of city leadership continue to be offered and continue to be rejected. No cooperation, no compromise by the appellants. This public hearing is an appeal on the Redondo Beach Municipal Code's accessory structure building code 10.2/1500 and allowable projections in residential zones 10.2-1522, in which our structure complies with. The appeal is not a referendum on the permit and enforcement process, which are secondary causal factors to the true matter at hand, and those need to be tabled outside these proceedings. Although stakeholder attempts to find a solution have been unsuccessful to date, as we've stated throughout this evening, again, my family remains open to all opportunities to address appellant complaints. Here on slide 42, here's one of our many examples at attempting to seek resolution and address the appellant's complaints. This is a personal letter that we mailed to the appellants on October 5th of last year, letting them know the status of our project, and a kind comment about putting our differences aside and to treat each other and our fellow neighbors with respect and kindness. The letter then goes on to apologize if there were any miscommunications and to inform them of us having planted greenery to help with their privacy. The letter closes by stating to please reach out to us if they have any questions or concerns, and that we'd be happy to address them personally.
So as you can imagine, given the exhaustive project timeline that we have presented in detail, we've captured several lessons learned. The most notable and worthy of discussing are listed here. So what we have learned: do not, I repeat, do not proceed with home improvements during a pandemic. While city offices are closed and services are either curtailed or made only available remotely by phone or email. I am the first to admit I was unknowledgeable about the permitting process as to what work requires permits, and do not accept the burden or responsibility of pulling the permits for the contractor. And so due to the pandemic, we signed in our agreement with our contractor stating that we are solely responsible for all permits and compliance issues. That's a big lesson that we've learned. Pandemic home remodeling boom at a 58% increase in projects, primarily driven by demand for outdoor living spaces. Our contractor was overcommitted. He was managing multiple projects, and our small project was just not a priority. There was no full dedicated superintendent or foreman on site. The responsibility was really left upon myself to manage. I'm working full time. My husband's away at work. That was an impact that we had on this project. Also, what we've learned is the city is very collaborative, and their intent is to work with residents to correct any conditions. If residents agree to comply, such as securing permits, then violations are suspended until permits are approved. Once again, failure to respond to any city notices puts the resident at risk of the penalty fine process. Never the case with us. We've been very cooperative with the building planning department and all levels of code enforcement. So we've learned once again that building codes can be very challenging to interpret, even those experienced in the codes themselves. And there is lack of uniformity or of interpretation or misinterpretation to the actual written language. The code is antiquated and has not been updated, changed, or modified for the accessory structure building code, which was established over 25 years ago. So this code must be brought current to today's modern living standards. We've learned the city really has no program to educate homeowners on the building and permitting process. So it's kind of like a trial and error method. We originally submitted for what we thought was a pergola, but through self-discovery and back and forth conversations with the city, the structure was properly classified as an accessory structure and not a pergola. So having gone through this process, we are now more comfortable and knowledgeable. And as a result, we are now advocates and actively share our experiences with those who are considering making home improvements themselves. We've learned 5 out of 10 homes have some form of unpermitted work, and that we now know there are very few work items that do not require a permit. We also learned that the city has a systemic non-compliance problem to RBMC 4-10.02, declared and public nuisances. There are numerous blighted, poorly maintained homes that are in derelict and dangerous shape. Remedy of these conditions should be the city's top priority, as it will improve property values, health, and safety for all. So in final closing, I just want to remind everybody, given the wide ranging of discussions today, this public hearing is to listen to arguments for or against the appellant's appeal of the City Planning Commission's unanimous 7-0 decision on a building code 10-2.1500 pertaining to accessory structures, and building code 10.2.1522 allowable projections in residential zones, both in which our structure fully complies with. This hearing is not a referendum on the permit and enforcement process, and as such should further be discussed independently of these proceedings. We ask for your approval for a fence modification to replace and extend our existing property line fence up to the maximum modification height as allowed for by the building planning department. We kindly ask for your approval of our structure, which is fully compliant and does not violate the requirements of the applicable municipal codes based on the evidence provided and what is defined and written in today in your code and fully supported by your 7 trusted appointed Redondo Beach Planning Commissioners. Please acknowledge the outpouring of support of the 25 adjacent and block neighbors and numerous other city residents that have written letters strongly recommending support of our backyard living space. You know, what we heard today are statements from the appellants that the city is fraudulent, and basically in all areas of the city's processes, from planning to building to permitting to inspections. He has accused the city of just being fraudulent, and I frankly find this very shameful. In addition, he has now accused us of everything we have done as being fraudulent as well, including the state of California stamped license engineer plans that we have. So, you know, let me remind you that none of his arguments have anything to do with the appeal itself and why we're actually here today. I mean, this is a very straightforward topic. So I hope, you know, prevailing minds see through the appellant's, you know, desperate attempt to punish us in a fit of vindictiveness. If the appellants have an issue with the city and their processes, this is really not the right forum for this discussion. So we kindly request the City Council vote to deny the appeal and uphold the Planning Commission decision that was rendered on March 18th. Thank you.
Thank you.
Okay, thank you, Matthew. Thank you, Corey. Thank you, William and Lisa. I must tell you guys, I was an activist for 8 years, starting in 2001, before I got elected to City Council in 2009, before I got elected to mayor in 2017, and before I just get reelected. And I've never seen this sort of conflict, neighbor to neighbor, go so far. And I must say, I see why there was no settlement here between the two of you. And regardless of how this council rules here, I hope the waters can calm afterwards, because we are going to have to make a decision one way or the other. And probably no one will be happy. It's the way these things usually work out. But, you know, we do have to live together and we do have to figure that out. So we can't fix that, you know, but we can do it the best we can with what's before us. And I just have to reiterate, I've never seen such good presentations. And frankly, I can just see why there was not a settlement. Both sides very passionate. And so, you know, for me, it is pretty simple. For me, I mean, I will ask, although it's not simple in the other sense. Our planning staff again, and I really don't even feel like it's been answered. Is this compliant with codes, our existing codes? And both sides, one side says it's not, one side says it is. Planning Commission says you can make it compliant. And so I guess I would just ask for, you know, Sean or Brandy or whoever, do they feel the way after what was built? And believe me, I just went through a remodel, so I know how hard it is. And we had to hire a structural engineer, and we had no idea we were going to have to do that, but we did. And so these things are trial and error for people who are brand new to this process. And if you're an engineer like I am, and like Mr. Stock is, and you drill down on things, yeah, you find problems. So let me just ask staff, what is your opinion? Is this, now that it is built, regardless of how messy it was getting here, is it up to code? And yeah, what's your opinion? And if it's, you know, kind of a gray area and up to us, then, you know, let us know that. So
sure. So the first application was a pergola, and there are those two different categories that Lena had mentioned. One is if it was an architectural feature. In that case, it cannot exceed 9 feet in height, and that could have worked had the roof been at a 9-foot height all the way across, and it could be attached. The other is regarding accessory structures. And although the definition doesn't say one way or the other about it being attached or detached, there is very specific regulation under the accessory structures in residential zones. Now, the proponent had mentioned that the heading for that section is called setbacks between buildings, and thus it doesn't apply. Yet the actual language of that particular subsection specifically addresses accessory structures. And our Redondo Beach Municipal Code talks about the rules of construction of language for how you interpret our zoning code, and specifically notes that the section headings contained in the chapter shall not be deemed to govern, limit, or modify in any manner the effect or scope or meaning or intent of the section. So, you know, the intent of that section is talking about specifically about accessory structures. So unfortunately, this, yes, it qualifies as an accessory structure, and we all agree with that. You know, that is the one section of the code that specifies that that distance from the accessory structure to the dwelling, as well as between accessory structures. So, and that's why I made the determination I did on both of the ADR applications that came through.
Mm-hmm. Okay, so are you saying then that the way it is up to code?
No, the accessory structure, if it, you know, because it can't qualify as the architectural feature because it can't be approved as an architectural feature because it exceeds the 9 feet in height. So thus it does qualify as an accessory structure, yet it's attached to the building and doesn't have the 5-foot setback. So I'm saying it does not meet the code.
Right.
And that was my determination that was appealed to the Planning Commission.
Okay. All right. Let's go to the council. So we got Councilmember Obaji, Councilmember MD, Councilmember Lowenstein, Councilmember Narenheim. I'm sure everybody's going to have questions and chime in. So let's start. Councilmember Obaji.
All right. Let me just ask a couple questions of staff, and then I'll kind of give my thoughts on it. Brandy or Ms. Forbes or Mr. Scully, can you tell me, is this part of, or actually the proponents, was this here part of the project, or is this just what was revealed when you took off the wall?
Actually, I can speak to this. I spoke at length with our chief building official today. The bracket that's shown here is not the bracket that was installed. The one that's installed is a heavier support than what's here, and it does meet the code. The point about the inspections, as we noted in the presentation, that, you know, there are different ways that if it's already in process or after the fact, how you can have that. They actually did have an engineer of record that was doing the structural observations throughout the construction and has that documented both in video, in photographs, as well as had to sign off with their engineer license that this was compliant with the code.
All right, thank you for that response. So my perspective on it, after having talked with everybody before this, and I'd also like to disclose that I did talk to the mayor and the city attorney, but not about the substance of the law as much as trying to reach a settlement here, and wish they had more time. But in any event, what I think was missing, I'd like to say that I think that everybody here is a bit of a victim. That's the Suffners, that's the Stocks, and frankly, that's city staff. And I think the culprit here is city councils of past who didn't set up a city that was funded to enforce the laws that we have, that was funded and enabled to enforce its own stop work orders. So what I think is glaringly missing from Ms. Suffner's presentation is all the stop work orders. Take a look at her timeline. They're not there. And in fact, when she said, when I got a call that they were working there, I was out of town, I would have come back and told them, I told them to stop working and wait until I was back to supervise. Meaning, it didn't seem to me like she was ever really intent on stopping the work. it also seemed to me like they had their project in mind and they were going to go for it kind of regardless. With that said, if you're living in a city where the reputation is the city's not doing anything, that is a kind of a reasonable position to take. Nobody's enforced anything. Everybody does everything without permits. Don't worry about it. Just do what's going to make your area more beautiful. I heard regret from Ms. Suffner when I spoke to her at some point about reducing the privacy they had because they got a lot more exposure to their neighbors once they remove those trees. And part of it is Mr. Stock, taking pictures and the like for the purpose of help, enforcing the law. And I think genuinely what I hate the most about what happened here is that these neighbors became alienated from one another. And I'm glad they're not in litigation where they just spent tens of thousands of dollars more. But Mr. Stock just wanted the law to be enforced. And he just, he was just inquiring about whether you had permits or not. And he just is like, well, if they don't have permits, they should get permits. And they got to stop work or they should stop work. And that's a totally reasonable position. As for the city, I totally understand, Ms. Forbes, why you take that position that it is not allowed. But in fact, by the way, another class I took in law school, it's called Statutory Interpretation. It's a 2-unit class. I got an A in it. So let me go over why I got an A in it. I highlighted here, what's underlined here is what is the same in these definitions as between accessory building and accessory structure. The difference, as has been noted, is that accessory building says detached. All right, that necessarily means that accessory structure is attached because otherwise it would not be 2 words. And what a statutory interpretation tells you is you must give meaning to all the words on the page. All right. So setbacks between buildings, when I read this, I don't even pay attention to this. So I agree with the maxim that says you need to ignore that. Nonetheless, I still reach the conclusion that this accessory structure can be attached, is not required to have a 5-foot setback, because when it goes to say the minimum distance between a dwelling unit and an accessory structure shall be 5 feet, it is basically saying that an accessory structure must be detached. And that's not what these definitions say. So this is a poorly drafted, ambiguous statute, and it must be read to give meaning to accessory structure as is written here. And what this should have said clearly, structure is building. But an accessory structure can be attached. At least that's a plain text reading in light of a clear scrivener's error or writing error. So I do think that it is legal, and that's the interpretation potentially that should be given. Mr. Stock is in the right. I don't want them to tear it down. I visited it. It's beautiful. The Planning Commission did a really good job in going through the negative effects it was having on the neighbors, on Mr. Stock's family, and suggesting or ordering, directing mitigations that should take place. I would really like to see them repair their relationships and the community embrace both these families because they both seem like very smart, very capable families. That was very impressive, both the presentations. So my recommendation would be to grant the appeal insofar as deeming Mr. Stock, the winner, the correct party, but allow the Suffners to keep the structure in place and adopt all the Planning Commission recommendations or requirements within 3 months. And that would be my motion.
Hold on, what does that mean, Mr. Baji?
Hold on.
Well, let me just say that there's a motion on the floor. And so let me see if there's a second. Is there a second?
Can I interrupt?
Wait. You're supposed to.
Councilmember MD, will you please wait? We'll handle this. Councilmember MD. City Attorney Mike Webb has a question. You're not running the meeting, Councilmember MD. Will you please be quiet and put your hand up and wait for me to call on you? Our City Attorney Mike Webb has a comment. Go ahead, Mike.
It was a similar comment that you have to make a motion to close the public hearing. And also, under the rules that you've adopted, you should have council questions. Sorry, I tried to hit that first, but under the rules, you really should have all the council questions and then a motion to close the public hearing. Once all the questions are out of the way, because you can't ask new questions without reopening it. And then there's the council discussion and deliberation.
Okay,
and
thank you.
All right.
And also I would like to, Zane went to a better law school, but I have a slightly different interpretation because of something that wasn't included on his slide, so that he may not be taking into account.
Did you want to expound on that, or?
Yeah.
Okay, so I agree with him that it is outdated language, and it is there are difficulties in interpretation, but I would agree with Brandy's interpretation. Let me see if I can share my screen. So up here, the top, it wasn't on saying it's accessory dwelling structures in residential zones. And so the general definition of accessory structures, I agree with him 100%. It's essentially buildings is detached. There's no requirement that accessory structures be detached. And also, accessory buildings are considered a subset per the code of accessory structures. So that's the more general, like difference between an orange and talking about fruit. A fruit is an orange, not all. An orange is a fruit, not all fruit is an orange. And that's important because there's an additional requirement in residential zones, not in other zones. So the general rules, the definition apply to all zones. And in this case, you can see that they said a dwelling unit and accessory structure, or even between two accessory structures, have to be separated by 5 feet. And that doesn't matter if they're detached or even separated by an inch. The accessory structure, they use the broader term. So in my analogy, all fruit have to be separated by 5 feet. It doesn't matter whether it's detached or not. And I believe that was the interpretation that Ms. Forbes made. You certainly are free to determine otherwise if you're doing it pursuant to the code as written. And that's what happened, is that the Planning Commission disagreed with Ms. Forbes' interpretation and reversed it. And the appeal by the Stocks is to try and get this council to reverse the Planning Commission's decision and go back to Ms. Forbes. But I'll turn that back over to you. Again, this is the time for all council questions, and your time for discussion and deliberation and further motions will be after you close the public hearing.
Well, thanks, Mike, for identifying that gray area and clarifying it. And yes, Councilmember Obaji, Councilmember MD and Mike are correct. We do not make motions until the public hearing is closed. Big question. We make comments, and the public hearing has to be closed. This is different than a discussion item.
All right, I'll withdraw the motion, obviously, and if I just may conclude my remarks by saying, I get a lot of the comments about the photography of the Seffner's property and the like, that's not something that we should take into consideration. It's not something that before us. That's really a civil dispute that sounds in tort. But I understand what he was trying to do. I could see also, though, how it would be disturbing to you. So with that, I'll yield any more time. Thank you.
Okay. Councilmember MD.
So my question is so thank you for asking about the sliding doors, because that was one of mine. And what about the masonry fireplace and the earthquake concerns? Was the rebar put into the fireplace?
It was the same situation where the structural engineer of record had done structural observations for that. So I don't know the technicalities of that construction, but that was something that was reviewed by the building division with their structural engineers observation documentation. So they have to again sign off with their engineer license. They had to document what was done on site.
All right, and clarify something for me. It says since it's in the structure, if the director cannot approve it because it's higher than 9 feet, then if you cannot deny it, then who would approve it? So in other words, that was unclear. So if you can't deny it, can you approve it? I mean, it just doesn't make sense that you can't do both.
That was if it's an architectural feature. If it's above 9 feet in height, I cannot approve it.
So if you can't approve it, if you cannot approve it, you can't deny it either then, right?
Well, it's my discretion on the review of it to see if it meets the criteria. It didn't meet the criteria, so it's denied. So they don't have they couldn't get an approval for that architectural feature.
Because it's higher than 10
There was
feet.
no additional, it was taller than the 9 feet.
So then where would that structure go? If it's not an architectural feature, who would be able to approve or deny it then?
If it's over 9 feet, it's not permitted.
Period.
Yeah.
Okay. And there was a question about the electrical work permit. So was electrical permitted, the electrical and the heater?
It was, no, the electrical and the heaters that are within that roof structure, those are not approved. What is approved are, and Lena had those on the slide, was the barbecue, the gas line to the barbecue, the gas line to the fireplace, the structural for the fireplace, and the structural for the replacement doors.
So just to make it clear so then it's just the actual roof, which was pergola or not pergola, that structure itself is really all that's in question at this point. So it's
that and the electrical work within it, yes.
Within it. So based on Mr. Webb's clarification, so the two options they have then is they either bring it's just to make sure I'm understanding this, is they either have to bring it in 5 feet from the residential I'm sorry, what am I trying to say? The
lot line.
Thank you. From their lot line, from the rear lot line, or they have to detach it and have 5 feet clearance between the residential and the structure.
The options are they could reduce the height of the roof to 9 feet, and it could be an architectural feature and stay remaining attached to the house, or they'd have to separate it 5 feet from the dwelling unit.
They can't bring it in. They can't bring it in from the lot line in the back.
That's not going to bring it into compliance. No,
it's not going to bring it in compliance. So, and if you were to lower the height based on the pictures, you'd be working into the window itself, right? I mean, it seems like it was right on top of that window. You'd have to actually remove the window and then to lower it below 9 feet. Is that what? Am I seeing that correctly?
I mean, I don't have the dimensions on that to, in front of me to see that, but it definitely looks like it would be in that range of where that header is.
Lena, what do you think?
Me unmute.
Yes, so the height of 10.7 inches is to the top of the roof line. Under the roof line, I guess to maybe the ceiling of that roof, I believe is still 9 feet 8 inches. So you're correct. To bring it down all the way to 9, it would likely encroach into that bifold door, technically.
Okay, and so when they realized they had to get permits, and they show up to the, well, they didn't show up to the counter probably, but they go in and get their permit. Why isn't there any, was there any kind of discussion of what would all be taken into when they brought in their plans? Like, just like, hey, if you're going to do electrical, you're going to need this. If you're going to do that, based on these plans, these are things that we think you might run into? Or do you just go by what they actually asked for or brought in?
The plans that they submitted were, we want to install a barbecue and this fireplace. And that's what they said that they were looking to do in the very initial. And that's what we had them submit so that it could, and they had already started the work, but we, so what are you looking to do? And that's what they informed us that they were looking to do at that point.
Okay.
And then when they started working on the door, then it was, okay, this is not something that's permitted and you're going to need a permit for it. So another stop work order for that. It was not something that we had been provided comprehensive plans of full build out of what they were looking to do.
Okay, I believe that's all the questions I have. Thank you.
Okay, Councilmember Lowenstein.
Yeah, I would first off by saying I agree with Councilmember Obaji. The language, especially the heading setbacks between buildings, is misleading. It should also say structures as well too. So that should be cleared up. That is not accurate, it seems like. Brandy, let me ask you a couple questions. One is the structure. We can all agree it's a structure. It's not a building. I think everybody agrees here with that. What is considered the structure? Is it the roof and the fireplace, or is it the fireplace?
It's the roof and the fireplace.
Okay. What would you consider the roof to be? Would you consider it to be just a roof? Would you consider it to be an eave? Would you consider it to be a cornice? Would you consider it to be any type or similar architectural feature?
I would consider it to be a roof.
A roof, but why not an eave?
Well, there's an eave on the one end. An eave is the end of the roof.
Okay.
It would be, there's the eave on the fireplace side. On the other side, it just goes into the house, to the main structure.
Okay. So let me ask you this. This is tough, but I'm going to ask you to get into the minds of the planning commissioners, because it's very hard for the planning commissioners to agree on anything. 7-0. Why do you think they ruled 7-0?
I totally understand why they ruled 7-0. The point being is, there could be an eave that comes off the house, and the eave could go from the structure to, they could actually touch, but so they were looking at it as this is serving in the same that it could be built. Now you would have to require them to put posts in. I'm at the mercy of what the code has, whereas I understand their conceptual, conceptually that it would have the same bulk and massing, whether it's attached or detached, and having the posts that would support the support beams being 5 feet from the house and having a break in that roof line, but that's not what I have available to me in the code.
You just said an eave coming from the house, correct?
Right. Okay. You can have an eave come off the structure. People have like a little bit of an eave or roof that comes, like a little piece that can come over like an entryway. And that can be an eave off of the house. That could come out 30 inches. And right. The eave from the structure could come 30 inches into that 5 feet and they could touch. Like, I understand that whole concept. I'm just acknowledging that the code talks about having them detached by 5 feet.
Okay, so an eave is generally speaking the underside of a roof. So you have a roof there. Underneath it where the heaters are is considered an eave, essentially, correct? Because that's a roof, and then the underside of it would be an eave, right? So,
we don't have a specific definition of eaves in our code, but an eave is, the end of the roof. So you can imagine, like, your roof may overhang the wall of your house, the outer wall of your house. That's the eave. It's the end of the roof.
well, yeah, it's an underside of a structure. Basically, that's what, if you look at a dictionary, that's what it says, is the underside of a structure, of a roof structure, basically. Mr. Webb, question for you. Is it possible, if you're around?
I'm around. Just slow on the hitting the right buttons.
I'm not going to criticize you for not being on camera, Mike.
I have no comment, but thank you.
Yeah, okay. 10-2.1522 creates exceptions, right? It creates exceptions. It allows for projections into required setbacks. So let me read it and tell me if I read this, if this qualifies.
I will say that I was just speaking to Zane, and Ms. Park has been the attorney assigned to this, so I may lean on her for this, but go ahead.
Okay. The following projections may be permitted into required setbacks and setbacks between buildings. And
where are you reading?
10-2.1522 from the code, subset 1. All zones, cornices, eaves, belt courses, sills, water heaters, cantilevered bay windows not containing any floor area, awnings affixed to the building facade, and fireplace chimneys or any other similar architectural feature may project into a required side setback 1/2 the distance of the required side setback, or 30 inches, whichever is less, and may project into a required front or rear setback, or into the required setback between buildings no more than 30 inches. So this is what I think the Planning Commission was looking at and saying, this is an exception. This is a projection from a building, whether you consider it an eave or some other architectural feature. You can still have it attached to the building as long as it projects out 30 inches from one end, 30 inches from the other end, and they meet somewhere. If I'm not reading this right, let me know, but that's how I interpret this. Does that sound right or not right?
Well, I'll let Cheryl address, and certainly she was present at the Planning Commission, but if you look up above, that's Division 3, all zones. And the residential zones have a more specific requirement. And I don't see this as necessarily, but I'll let her discuss it, and then I'll look into that as well. But she and Ms. Forbes may have already considered that. I don't necessarily see an exception to the more specific requirement that Brandy denied the application based on, in residential zones. Ms. Park?
And they also have a 15-foot height limit, if I'm not mistaken, versus a 9-foot. Is that right, Brandy?
That's correct, yes.
Okay, Cheryl, sorry.
It's okay. And just a point of clarification, I was not present during the Planning Commission hearing, but I think you are correct, Councilman. I think that section was probably the basis for the Planning Commission decision. And that's why Brandy reiterated a while ago that she thought that the portion that came out of the roof attached to the building could project 30 inches, and then the portion that was attached to the fireplace could project 30 inches. And so that could touch, but the Planning Commission decided, instead of having them, create a a separation between that building eave and the fireplace roof, and then have posts put up. Essentially, it's the same thing. And so I think that was the reason for their decision, the basis for their.
So it's more the spirit of law than the letter of the law that supports their decision. Is that correct, Ms. Park?
I believe that to be the case. As I said, I wasn't there, but judging from the wording in the resolution and reviewing the minutes of the Planning Commission, I think I'm assuming that's how they came to their decision. Correct.
Okay. I honestly see with the ambiguous language like this, how either side could say they're in the right. I mean, it's very clear from this. The question is, how do we deal with it from here on out? So I just wanted some clarification on the ordinance. It's obvious we need to clear up this ordinance. We're going to run into this again. The other thing that was really interesting is when they were showing pictures of the areas, you saw a lot of pergolas and roofs that are attached to buildings. It's clear that and they're definitely newer than 25 years old. It's clear that we have a problem here with either enforcement or understanding by people that are assembling these that this is not done right. This is not done right by code enforcement, and this should be very obvious. This should not be. It's up to the person doing the construction or not. I think I'm the owner of the house. This should be very obvious. And the way that this is written shows that it's not obvious. And this is where we are tonight. So I'm just stating the obvious, but for me, I honestly could see it going either way. But to me, I look at 1522 and I say, this makes sense. This could be considered a projection. So that's where I'm at. Thank you.
Okay, Councilmember Nierenheim.
Thank you, Mayor Brand. Wow. I just want to say, first off, I'm beyond impressed with both presentations from both parties. And I'm beyond impressed with the amount of participation from the fellow neighbors that you've been able to get tonight for this issue. Clearly, everyone's done their homework. Clearly, everyone has deep roots in the community and neighborhood. There's a lot of emotions involved in this. And the ability to reach so many neighbors is truly impressive. I've gotten a lot of complaints over the last year during the pandemic regarding the planning department because of everything that's been going on. This is about the process. Nothing is perfect. Things are what they are. The code is old. During the legato hearings, when we talked about that, we had our planning director at the time said that the person who applied for the 180 units had a different interpretation than the city had. And that's important because it's for us, the council, to decide what's going on. I want to thank Rolf Stressenberg, who we talked a few minutes ago. I talked with him earlier. He's a planning commissioner, weather definition. He really got into it. Brandy, I have a question for you. So when you talked a minute ago regarding the 9-foot issues, if you cannot approve that, but you didn't say if there was an application for a variance, you could approve the variance if there was a variance for application for variance, correct?
Well, I don't approve variances. It would have to go to the planning commission.
Right. That's what I mean. Sorry.
There are very strict criteria for variances because you don't want to zone by variance, right? You don't want to have. So there have to be unusual circumstances. And then as well, it has to be, you can't be granting something to one that others don't have.
Right, but what I'm saying is not for you to decide, but the planning commission, if there was an application, the planning commission or could hear, there would be a variance that they could approve or not approve. That's what I'm asking. And when we talk about the eaves and the heights, this isn't like we're approving a variance for lack of parking or an issue to a greater community impact that would negatively affect the community impact.
I understand what you're saying. It's still the same criteria regardless of what the code section it's a variance from.
Right. Okay. So my point is this: is like what I'm seeing here is there were large trees there that created privacy and soaked up the noise. Now suddenly the trees are gone. Now suddenly there's a lot less privacy. There's a lot more noise because the trees are gone with the new construction that has happened. The gas, the fireplace that's in place, that's gas. That's not wood burning, correct?
Correct.
Okay. Looking at exactly what Councilmember Lowenstein just brought up regarding the eaves and the structures, looking at what the Planning Commission voted on, I mean, they had a 7-0 vote. I'll pull it up here, their motion. They were allowing the accessory structure's roof to be attached to the main house. I agree with that because that was just, it's a roof. And the second part is stormwater runoff from the accessory structure to the neighbor's property. So basically they wanted to add additional conditions to mitigate the possibility of stormwater runoff from the accessory structure to the neighbor's property. Totally agree with that. You can't impact neighborhood property, neighbors in general. I mean, that's what we're looking at here, impacts to neighborhoods and the general community at large. And require plantings to be installed on either side of the fireplace structure to buffer noise. Now I would add noise, it's not just noise, but also privacy impacts. And that's the crutch of the issues here that we're dealing with. Because before there were trees that buffered the noise and prevented privacy issues. So to me, that's what this comes down to. I agree with the Planning Commission would be saying. So is there a way we can install trees? I'm seeing the pictures here by the proponent presentation by the backyard. Brandy, is there a ways that we can get more trees, whether they're potted plants or going into the ground? What does the backyard look like?
I believe that planters were a requirement of the Planning Commission. One of the
how large of a tree could they sustain?
I'm not an arborist to know how large that would be, or what type of tree.
Right.
I'm sure that we could, certainly help advise on what type of planting might provide some of that barrier or buffer.
Yeah, I mean, I don't want these trees to suddenly disappear. That's what I'm concerned about because I've had the same issue in my district. Structure went up, privacy issues, noise issues, and all of a sudden there was a planter there, and all of a sudden the planter is gone. So I'm very sensitive to that issue.
Well, these residents in particular had a health issue with their child with the particular type of tree. So if you require a tree, it's certainly going to have to be in consultation with them.
Yeah, that was not in consultation. So that gets even more complicated. Those are my viewpoints for now. That's all the real questions I have before I start making motions or start talking with my fellow council members. But I see to me, it's the views, which equates to privacy, and therefore also the loud, the noise issue. A variance could be given for the structure. While I don't appreciate at all the stop workers or work orders and the work that was being done, I could see why they did what they did because they can get away with it, so to speak. I think the cities handle it as far as best as they could. It's as Councilmember Baji summed it up. I'll just leave it with what he said. So that's all I have to say for now.
Okay, Councilmember Horvath.
Yeah. So most of the questions I had written down here have already been answered in one way or another. So I just want to make some clarification questions. So Brandy, when you talk about the architectural structure versus an accessory structure. It's one thing if it's not attached, or it's one thing if it's attached and then it has to stay at a 9-foot limit, but it's an accessory structure if it's detached and then it can go to a 15-foot limit. Is that?
It's an accessory structure. I mean, it could have qualified as an architectural feature, except for it exceeded 9 feet. It could have qualified for an accessory structure, except for it's attached to the.
It's attaching, right?
Yeah, so it's not quite either.
Right. I get it. And so, and if I'm putting you on the spot in the sense that you can't really answer this, don't bother. But, you know, as a community development director in the 21st century, in 2021 now, when you look at that code, to the point that Councilmember Lowenstein and Councilmember Obagi made, right, do you look at it and as a professional see the ambiguousness and the issues with the way it can be interpreted? And is that something that you as a professional would recommend that needs to be changed on a go-forward basis?
As far as how it can be, you know, the interpretation, sure, there's ways to clarify, you know, really clarify that language. I think Councilmember Lowenstein mentioned if it had said accessory buildings and structures, that just even the heading could have clarified that a little bit more. However, I think the bigger issue is, you know, lifestyle changes, right? So where things were with a pergola, you know, 30 years ago, 25 years ago is something different than what the needs are today. You see, you know, changes in weather patterns that may, you know, now people they don't want to have the sunlight come through a pergola. They want to have a little bit more of the shade structure to keep out the heat. You know, there's I think just the pandemic alone has demonstrated that people are going to be reevaluating what they're looking for in their homes. And so just even the last year has made a shift in difference in what we're going to see people interested in, because they've learned to spend more time at home and have that. We have the influx of the applications for air conditioning units. You know, that's that in and of itself, you know, shows that there's a change in what people are looking for. But I think most definitely there's a difference in how people utilize their space.
Okay, and then later on tonight, like 3 a.m. by the time we get to it, the design guidelines, these kind of questions that we're talking about here, right? Are these things that will be addressed as part of reevaluating our design guidelines? Do we, as a part of that process, go in and look at these areas of the municipal code as it relates to this that can potentially be corrected and fixed?
The residential design guidelines are outside of the zoning code itself. So okay. Referenced in the zoning code, but they are their own separate document. That doesn't mean that there couldn't be different design review that you'd want to include in there regarding this, but that doesn't change that the language isn't the most clear.
Okay.
Right now, yeah.
I think Councilmember Obagi made a really good point earlier on, in that this is like, what do you call it, a Mexican standoff. Everybody's pointing a gun at each other here, and the three entities, right? The appellant, the city, and the proponents. Brandy, throughout the process here, and you know, I have emails with the stocks, you know, starting in July. And the quality of life prosecutor and code enforcement. And as your team went through this process, were there any, whether it's departmental or pandemic, were there any areas of deficiency where we did not do our job at the right time in trying to rectify the situations? Because when I look at the timelines, it looks like we were we were responding, at least to my emails, fairly quickly. So.
Right. And as we've, I've presented, at least 3 different times to council in the short time I've been here is, historically our code enforcement has been, to really try and bring people into voluntary compliance rather than just, using a hammer. And so that is what we were moving forward with as well. We were faced with, even if it's something in a rear yard, just even the first request for an image, for a photo is, I don't know if what they're doing is something that requires a permit or not. And we don't have the ability to go and walk in people's backyards. That it said, we can't even, during a pandemic, we couldn't even go up and knock on people's doors and say, hey, let us in so that we can go see what you're doing in your backyard. So there were a lot of restrictions when it came to COVID, as far as us being able to more regularly go out and check on the site. That being said, we took a lot of precautions with PPE, with our building official, but that's why we were trying to work with the neighbor. Is we're hearing this complaint that there's something happening, and for us to impose on somebody else, we got to remember, we're all now at a place where vaccines are readily available. We're not in that place throughout this entire process.
Okay, and then final question. So there were statements made to the effect of that the proponents were trying to game the system, and I think we hear this all the time when we get complaints about things going on in each of our districts. But was this? Is it the view of staff that this was an evolving project, and so it required a lot of stop and start because things were changing, like going from the 4 feet to the 9 feet, or did staff have a different perception of this project as it moved along?
Evaluating it's not uncommon for somebody to not realize they needed to get a permit for something like a fire pit, like a barbecue. And maybe not even the replacing of the doors. So it was something gradually. We weren't thinking that it was anything that was an intentional trying to game the system. It's just, right now we're having so many homeowners that are wanting to do some projects at home to make the livability much easier. And so that's what we were seeing. When it came to this last structure, it was like more than we had expected, because we were told it was a replacement of the pergola. And when the drawings came in, it was something different. And that was harder for us then to, as you can see, find something where it complies.
Okay, so I was going to make a motion to close the public hearing, and then while I had the floor, at least start off with my thoughts. But I see Councilmember Obaji has his hand up, so I'll yield my time to him if he's got a couple of questions.
Thank you, Councilmember Horvath. I'll just pose my questions, and I'll move to close, and then yield it back so you can make your motion since it's your district. My question is, Ms. Forbes, do you see any problems with the structure as it is right now, besides the fact that it's not complying with this 5-foot setback, of course, the space difference between it and the main structure?
I can't say one way or the other, just because we don't have the structural permit application for that. But that's part of what I know the Planning Commission had put forward, was that they would have to get those permits. We'd have to have the documentation of that, meaning the structural quality of construction that's required. And then as well, the Planning Commission gave them the heads up. There may need to be some things that might have to be exposed, especially with like an electrical or the heating elements inspections. So I can't say that it's otherwise okay, except for the 5 feet or except for the 9 feet in height, because we just don't know if it meets code. That being said, I know that the Suffners have utilized contractors that have have their licenses and have their business license with the city.
The last question, maybe for Mr. Webb, are we able to find the Suffners here as part of our decision?
No, this evening is not about enforcement. It's not about who's a better or worse neighbor. It's not about changing the city's approach to code enforcement. Or changing the code. It is simply make a determination on the appeal from the Planning Commission and essentially deciding whether or not Planning Commission's interpretation is correct, or if you believe the community development original determination was correct.
I'll move to close the public hearing.
Second.
Okay. Any objections? Okay, hearing no objections, the public hearing is closed. So I'll entertain motions at this point. Councilmember Horvath, you had something in mind, I suppose?
Yeah, so, I just wanted to say, just quick comments. I think this was an extremely interesting hearing. It is a shame that it did get to this point. And so I'm just echoing some of the comments made by my colleagues. But I think it was enlightening, and I think it presents this council with an opportunity to look at things that we do need to really have some serious discussions about. And so this keeps happening to us, right? And code enforcement and these conversations keep coming back up, but there are certain aspects of that were brought up by Mr. Stock that we do need to figure out how to address. And we have to do that in a collaborative fashion with staff. And part of it is educational. I think that there is a bit of a black box as to what people think they can do and what they can't do, and they're extremely surprised by what they need permits for. I think the Suffners have learned that you never ever do your own permits, and you have a general contractor handle that for you. And there's good reason why. And by the way, I have two different contractors on my street that have clearly not done things right either, and so they've created issues for their clients that are trusting them. So I don't think a lot of times that people are trying to skirt the issues. Maybe sometimes contractors are, but I think a lot of times it's just, well, this is how we do it in Torrance, and there's a lot of assumptions made. So I get it. It's a wonky space to be in, and it's probably not easy when it's not what you do all the time. With that said, clear lines of communication are completely important between either contractors or residents as they're going through this process, and the city is relying on you, and you are relying on the city. And so anyways, with that said, I think school board member, former planning commissioner Strutzenberg, I think laid it out quite simply, right? This was simply about the two different sections of the code and the interpretation of that. And a few of my colleagues did note the ambiguity or the way the language was written, and I think that's really what creates the issues. And that's really what this appeal is about. It's not to diminish some of the other things that were brought up by the appellants. I think that, as I said at the beginning of my comments, I think we're going to need to address that in greater detail. But that's not what we're here to discuss tonight. So I am of the mind that we should deny the appeal based on the information that was presented and uphold the Planning Commission decision. I do not think that we should opine or take a position on the fence. I think Mr. Stock did present some information related to state law and how neighbors need to work collaboratively when it comes to a structure that is in between their properties. And I don't think that this council should be dictating that. If that is something that the Suffners and the Stocks want to work on in a collaborative fashion, to the mayor's point, if there is an ability to do so after this, then they should. So I would keep it specifically to the project as it has been done already, and not add on any additional requirements beyond what the Planning Commission has already requested.
Okay, is there a second to that motion?
Second that.
Okay, there's a motion and a second now on the floor. Councilmember MD.
I just want to say, first, thank you for everyone. I agree. Both the presentations were top notch. There were amazing amount of research that was done. And there's several problems to this entire process of what happened. Number one, the fact that staff was telling the stocks to take pictures to prove their point is just a practice that is just not okay, because it pits neighbor against neighbor. And I hope that the people that called in and thought that it was intrusive that the stocks were taking pictures heard the fact that they were being asked to take the pictures. So just in the name of some understanding from different points of view of what might have been going on. And that we see this also with leaf blowers. We have neighbors being pitted against neighbors because some are following the laws, some are not. And then people that want to be law abiding and make the sacrifices to not have a leaf blower are pretty angry that their neighbor gets away with it day in, day out. So I fully empathize with the stocks on this whole process. And looking at it from his point of view, I could see why he was concerned. I was also, when he showed me that the masonry fireplace wasn't earthquake compliant, because I mean, that could definitely fall on his side of the fence. I can see why he would be concerned over the joist, but he didn't know any of the things that were maybe found out tonight. And so again, if staff's asking them other people to take pictures, it seems like there's a close of communication not happening, in which they should have been telling the stocks or informing them, hey, we've inspected this. If you're going to ask them to be part of the process, you should include them in part of the solutions, and to help avoid this whole negativity back and forth between the neighbors. As far as the trees are concerned, I agree that the reason for the removal was the allergies. The trees are already gone. The neighbor next door, I believe, said something about the fact that they're glad that the trees are gone so that it helps their garden. There's a lot of things identified as a problem, and council not budgeting enough for code enforcement resources is definitely being seen across the different rules that are being put in place. And I think I agree. Somebody said it earlier that it's the three are definitely, well, actually, I think the city had a hand in part of this dispute, and I want to apologize for that. And I hope that the neighbors can, no matter what resolution is that they can walk away from here hearing both sides, that there's maybe some understanding as to where the two sides are coming from, and that there wasn't any intentional gotchas or ill intent from either side on different things that were being assumed on that. So that's what I hope that we walk away from, and that when we talk about the budget, that we consider these kind of enforcements. If we're going to be a city that's enforcing things, or if we're going to, we either got to enforce it or we got to stop passing these laws that pit neighbor against neighbor. So anyway, that's all I wanted to say on that.
Okay. Councilmember Narenhan.
Thank you, Mayor Brand. Yeah, I look at the Google Maps location, which has the old trees, which are big and massive, and really created that privacy. And the reason I didn't go much further in the trees and asking more questions in the trees, what the Planning Commission did, was because I think that the Planning Commission understood and saw what the 1, 2, 3, 4, 5 trees there that they have put in place. You can reinstall massive trees in that location, but then you might have other issues like what was just brought up regarding, it hurts other people and their light and their air and their wind, which they value, which we don't have a views ordinance. But we can only do so much. And I do believe what the Planning Commission, which was a unanimous vote, which is really tough to get out of them for something like this because they're so different thinking, all those individuals there, that we're going to have to trust those trees to remain in place and grow to a large size. The bigger, the better. And to absorb the sound and increase the privacy for the neighbors in the back. And those are the neighbors that are most affected with this issue. The more I look at this property, neighbors on the sides don't have the issue. It's the neighbors directly behind because it's the privacy and the sound issues. Exactly like Councilmember MD just talked about, the pictures and the video were requested by city staff. We don't have the allowance by city staff, code enforcement, and thankfully we don't, to go on people's private yards to start doing code enforcement because that could be a huge issue. I would never be a proponent of that. This is something that I can't express enough to both sides of the equation here. You guys both did a phenomenal job looking at the individual little pieces of the pie and seeing what's going on. But I think the number one thing to move forward between both neighbors is to increase the privacy through the use of the trees, let the trees grow, to decrease the sound attenuation from neighbor to neighbor. And I think in the future, it's going to be moving forward happily. But I will say that, for everyone that's watching, you got to do this with the permits in place. And what we have here is a situation where people look at the code and says, "Oh, I can do something," and they found what they think is a way around it. But I think I agree with the Planning Commission. So those are my thoughts. I agree with the motion on the floor. Thank you.
Okay, thank you, Councilmember Nairn. Let me ask Brandy a question. Brandy, what happened with the electrical? Councilmember MD asked about the electrical, and you said that it was not to code or permitted inside. I didn't quite.
Yeah, what's been permitted is the barbecue, the gas to the barbecue, the fireplace, and the structural for the door replacement. But there's electrical that's in the roof of the accessory structure that's serves the lights and the heater, and that electrical has not, because they haven't received the permits for those, because this was something that has not been yet approved.
But they've installed it.
They installed it.
And so how does that work in the planning department when something like this happens?
That goes back to, there'll be probably it'll probably be a combination on when it comes to the inspections for, if they have the engineer of record was there for the structural, that can help for documenting the structural observation. But as well, for the electrical, they may have to open up an area for that to be inspected. But it's not a unique circumstance. There have been other situations where something was built, they didn't have the permits, and or they didn't request the inspections and closed everything up. And there's just different ways that can be inspected and approved.
Well, what I'm getting at is if something was not done to code and you figure that out, it's potential they would have to poke holes in the wall and redo it.
Oh yeah, yeah.
And
it
so
still has to meet code.
Right. So
right.
The proper process is to come to the planning department and the building department with your plans for your electrical, get them approved, amended, however, get them approved, and then go put the electrical in, not what has happened here. And so now you go out and you inspect it and you say, okay, it's up to code, and then you sign off on it if everything's fine.
Yeah, if however the building division determines that it meets the inspections, then they'll be approved. Excuse me.
Yeah, I don't think anybody watching this hearing is going to think that they can just go out and do whatever they want. I wouldn't think you'd walk away from this hearing thinking, okay, I'm just going to go build whatever I want and ask for permission later, because here we are months later. And if it's not done right, then yeah, you will, because I've heard of this happening. And, you know, structures coming down. It does happen. So, but there's also contractors in town that have gotten away with things. And I've seen that several times. And so it didn't surprise me when those pictures came in from Mr. Stock, of a variety of I think it was from Mr. Stock, of pergolas, structures, whatever, that were not in compliance. I can't remember who it was actually now. I think it was the applicant. So apologies. Anyway, so you're going to follow up on the electrical.
Right.
Okay, so I see Mike Webb has his hand up, and then Councilmember MD.
Yeah, if the motion maker could, the motion should be, if it's coalescing around denying the appeal, to deny the appeal and adopt the resolution that is denying the appeal. And I would ask the council to take some time in reviewing it. Todd, I've had some chance to look at it, and I think it is a valid interpretation that 1522 provides an exception to the general setback requirements. And if you're counting 2.5 feet from the building and 2.5 feet from the structure, you can make the interpretation that it's to 5 feet. In reviewing that, that wasn't mentioned in the planning commission resolution. They just referred to the 1500. Now, they may have viewed that it met within 1500 by the exception of 1522. As I indicated, I wasn't at the planning commission. But you may want to look at the actual resolution. There was one submitted to you by planning department that both granted the appeal and denied the appeal. And you may want to look at that. You know, do you want to pin it based on that 1522? Do you want to go with Councilman Obaji's interpretation of 1500 or both? And the reason your discussion, Mayor, as to the requirement to get permits done, that's in the Planning Commission resolution, which is null and void because there was an appeal. And so it will only be a condition if you make it part of your resolution. They were giving 6 months. If you want to give some, different period of time to get the permits, then you should modify the resolution. So if the council majority is coalescing around denying the appeal, then I suggest you take some time to make certain that everything in that resolution is in line with what you'd like to see done. Okay, I'll leave that up to Councilmember Obaji and Councilmember Lowenstein to correct all that. But first, Councilmember MD has her hand up.
I also forgot to mention the noise factor, the fact that there's 2 televisions in the backyard, and then there'd be a party, and the fact that it's tile on the floor, I can totally see how that would be extremely noisy for the stocks. And so when you are considering conditions, there's got to be a way to kind of deaden that sound somehow. And again, come to Mr. Stock's point that we have no way of measuring or confirming their decibel levels on that. So there's, I don't know if outdoor rugs would be an option or something along those lines, but either way, when we go to discuss residential guidelines and relook at some of these codes, these are some of the things to consider as we do. I agree everybody wants to do outdoor spaces, but there's certain things and limitations that we might want to consider when we're talking about having people get good along with neighbors, and having an entire party central in your backyard might not be the best conducive thing for the neighbors as well. So just some things to consider. That was that was it.
By the way, it's not just tiles on the floor, but it's tiles on the ceiling too in that pergola structure.
It's really?
You know,
I thought that was wood.
It is.
It's wood.
Oh, is it wood? Oh,
I thought
okay.
it was wood. Yeah. Okay.
Sorry, I thought it was
wood to tile, tile to wood. And on the whole noise ordinance and enforcement, you know, and the budget coming up, it probably is something we should consider because we don't have the equipment, we don't have the training, and we should probably direct staff to look into how we could begin enforcing our noise ordinance, either through some sort of consulting contract with a firm that does that. But right now, and it's been going on forever, that we have these noise codes and we can't enforce them. And it always says it's always too expensive, and then these hearings are expensive, and it's costly to the residents, and it's costly to code enforcement. So got to weigh everything and consider that with the budget discussions coming up, whenever that's going to be. It's 12:09. So anyway, did you want to clarify your motion? As City Attorney Webb was explaining that since you made the motion to deny the appeal, you now need to be probably more complete in your motion and not just what you provided so far. For instance, a time frame. Or did you?
I mean, we can so we can be more specific if we want to add in language under the findings section 1 here. So Todd and Zane, if you want to add in the specifics. Right now it just mentions 10-2.1500.
Well, I'm sorry, you made the motion, so I was going back to saying it really should have been talking to you.
So we might want to refer to the projections of 10-2.1522. I think that would be something you could point to and clarify it in the resolution. I don't know. I have to look at I'm trying to find the resolution itself.
Page 1074 in the packet.
Thank you.
I mean, if we go with 10-2.1500, we are essentially opening the floodgate for interpretations that an accessory structure need not be connected, which I also don't see the reason it should that it should be separated. Sorry, that an accessory structure.
Are you saying the first paragraph, to deny the first paragraph, strike through?
I wasn't opining on the first paragraph.
So this is
which code section was it? 10-2?
So it's 10-2.1522. So I would maybe strike the part that says does not meet a 5-foot separation requirement. Because it does. If you look at 1522, it can be considered to meet that.
That's in the first paragraph, correct?
That is in the second. Well, after the recital.
Are you?
It's in the recital. It's in the recital.
Are you reading the resolution to deny the appeal or grant? You got one for each. And
oh, you're right. That's right.
Yeah. So that shouldn't be in a reso denying the appeal. And you may want to leave in the language about 10-2.1500, but you may want to put in a second paragraph about how it also complies with the exception provided under the section that you referred to, Todd, 10-2.1522, if you're making a finding. And then you'll look through the list of conditions and determine if all those things are things that you want to condition the denial of the appeal on.
So, Mike, what you're saying is add in a B and then move B to like a C, but put in a B that says per criteria for 10-2.1522. Yep.
And so, if that's the interpretation that the council is making, and then you go through the conditions such as have all permits completed within 6 months. or do you want to have a different determination? Those were all the conditions under which the Planning Commission granted the Suffner's appeal. And if you're denying this appeal, do you want to keep them or do you want to modify them? And
yeah, the original motion did say to keep the Planning Commission conditions. So we would be doing that and or adding anything if members here felt that we needed to add more noise attenuation mitigations.
My only addition to that is to codify the amount of trees they have in the back. I know it sounds ridiculous, but that's what's going to create the sound attenuation and the mitigate this privacy issues and mitigate the sound issues, because that's what this comes down to. I don't see that in here about the amount of trees.
Number 2, Nils, plantings as approved by the Planning Division.
Yeah, but and I go back to the Planning Commission review or Planning Commission motion, they did not have in there the amount of trees.
So what I'm saying is, do you want to modify to be more specific?
So include 6 trees, ensure there are 6 trees in the backyard along the fence line.
Why? I don't know why you want to be that specific, but
because I don't want those trees to disappear in 6, 7 months, 8 months. That's the crutch of the issue here, is the trees disappeared. And
as between trees and vines on a lattice, which is going to be more insulating of the noise? Do we know?
Probably lattice.
They would have to install a lattice, though.
But the problem with the lattice is now it's part of the fence structure, which is larger above this 10-foot or 6-foot level, or 8-foot level, whatever is allowed. So trees can grow a larger size, and trees were there beforehand, originally before this issue was created.
Yeah, do you really want to get that specific about how many trees?
I do, and the reason why I want to keep 6 is because in the proponent presentation, they specifically have in here on page 11, they said we have installed 6 young trees and have used noise-absorbing materials in our furniture furniture. So I don't want to sit here and talk about their furniture, but I can talk about their trees. So at least we have, as per their documentation, 6 young trees, which will grow to be mature trees. That's why I'm
realize that the backyard is entirely tiled over, so these are going in planters that are movable.
Right, exactly. And as per the pictures, as per the Planning Commission review, and I don't want these trees to disappear in 7 months from now.
Well, they should be. It says this shall be maintained by the owner. I mean, I think that would basically keep them from removing them, right? You could say not removed by the owner.
I don't want them to die, or you didn't say how many trees, or I want to ensure that there is a
minimum of 6 trees. How's that? Yeah. Something like that.
I like Todd's language there. Just
Which language?
Minimum 6 trees.
There you go. Perfect.
Okay.
Of their choosing.
Of their choosing.
Daughter that has allergy.
Yeah, she's allergic to trees. So. Okay, so are we adding the section about 10-2.1522 and on number 2, Christian?
Number B under findings, it would be city attorneys said to keep A, we would add a B, and then the existing B would move to C, is how I read it.
Okay, so what is B going to say then?
So I would assume it would read a little bit similarly, right? Per criteria, one for the ADR review, the proposed, well, actually it may need to change, but the proposed accessory structure roof complies with the provisions of blah, blah, blah in section 10-2-1522. But the language
projections and the required setbacks. Okay. That's fine. Does that make sense, Mike?
You got to give Mike a 5-second delay to turn his video.
Yes. So, yes, it makes sense if that's the finding that the council is relying on, not only the general 1,500, but the exception of projections.
Okay, I'm good with that. Christian, you're good with that?
Yeah.
Okay, well, there you go. We got a motion and a second. Councilmember Narenheim, you still have your hand up. Did you mean to?
Sorry, nope, I don't.
Councilmember Obaji, you have your hand up? No, you don't anymore. Okay.
It can be artificial acoustic trees, right?
We didn't say it was true.
Of their choosing.
They're choosing.
All right, guys.
With an allergy. So, anyway, I'll do a roll call vote. Councilmember Narenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
I'm going to abstain and side with Mr. Stock being in the right here, just from the standpoint, give him support.
We can vote no. You don't. Why would you abstain?
I'll vote no.
Okay.
I support y'all's project too.
Councilmember MD.
So you're supporting both. My concern with this motion is that you're adding trees, and so who's going to enforce that once again? And so now you're putting Mr. Stock in the same situation, that if the trees don't grow in, they don't make it in a pot or whatever it is, you're putting in enforcing things that again are going to create conflict. And so based on that, although I love the softeners, I'm in the same boat as Mr. Obaji. I love the project, but we're setting it up to create a conflict again. So I think I'm gonna have to go vote no with Mr. Obaji.
Okay, well, I'm gonna agree with Councilmember MD and Obaji and veto it. So you guys have to get rid of the trees.
So same motion, but remove the.
Yeah, I mean, I agree with Councilmember MD. I mean, you're just setting up a whole nother, we don't have a tree ordinance, how big are trees, and then they disappear, and somebody's not happy with what they are. I mean, it's just, I've never even heard this before, and I think it's something you want to do, but it's too undefined.
So I would just make it the same.
You guys want to do a tree ordinance, but this is not the place and time to do it.
Then it would just be the same motion with the addition of the 1522 language, and then just keep the language under the conditions as defined by the Planning Commission as is.
All right, I'll second that.
Can I make a suggestion?
Go ahead, Mike.
So remember, you can't veto a resolution or an ordinance.
I knew you were going to say that.
Except in writing. So
you had to say that, didn't you?
Sadly, I didn't want to say it, but I had to say it. So I was thinking that a motion to reconsider by someone who is in the majority, such as Councilman Horvath and Lowenstein, could be a motion to reconsider the motion they just passed, except without the tree requirement. And that might pass, and therefore there'd be no need for you to.
So maybe the thing for me to have done, Mike, is said, okay, you guys, I'm going to go back in my office and write a veto. So why don't you amend your thing? Because
so we need an official motion to reconsider.
Yep.
That motion.
And then vote on that, and then you can make whatever ordinance you
Thank you, Mike.
you want. You're welcome.
Okay, motion to reconsider.
Second.
Okay, is that sufficient, Mike?
No, you need a vote.
Well, I mean, meaning
yes, and then if you'll vote on it, and then if it passes, then Christian will then be free to make the motion he was going to make with Todd second.
Okay, do a roll call vote on the motion to reconsider. Councilmember Narenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
No.
And Councilmember MD.
Aye.
Okay, great.
So I will make the motion again to deny the appeal with resolution 2105-044 to add in the language under section 1, the findings, to add in a section B related to 10-2.1522, and then to approve all the previous conditions as dictated by the Planning Commission as is.
Second.
Okay, there's a motion and a second. Mike, you had your hand up. Did you mean to, Mike Webb? No? Okay.
I don't think so.
Do a roll call vote. Councilmember Narenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
The judge orders me to do something, I gotta abide by the order. When the city orders you, you gotta abide by the order. No.
Okay, Councilmember MD.
Aye.
Okay, there you go. It passed. Was that 5 hours?
Pretty much.
Oh my gosh.
I need to read the resolution.
Okay, go ahead.
Adopt by title only resolution number CC-2105-044, a resolution City Council City of Redondo Beach, California, denying the appeal and upholding the Planning Commission decision approving the request for an accessory structure attached to the rear elevation of the main home within the rear setback of the rear unit of an existing 2-unit residential condominium development on property located within a low-density multi-family residential R2 zone at 2015 Spire Lane, Unit B, as amended. Thank you, Mayor.
Okay, thank you, Eleanor, and thanks to everybody. Thank you to Matthew and Corey Suffner, William and Lisa Stock. It's a very unique situation, and I hope things smooth out. Often I find in these situations, it's everybody just take a time out. But yeah, it's a tough one. It's a very tough one. Hopefully it works out. Hopefully it works out. So anyway, we got to move on to the rest of the council meeting. Thanks for all the public for attending. It is now 12:25. We have some items left to do, obviously.
Councilmember MD.
We have some people who've been waiting to talk about M1. We have the budget. We have consulting. Maybe I should turn to our city manager, Joe, give us some ideas on what we might have to do and what we might want to continue. What's your opinion, Joe?
Well, we do need to hold both public hearings, L2 and L3. Don't think they'll take a long time in terms of the public input, but in order to stay on track with our budget review, this is the first of 3 public hearings related to the budget. L3, L2 is street landscape and lighting charges. We do need that to move forward. M1 is not time sensitive. M1, the consulting agreement, that one could push, not ideal, but it could come back next week. And then we've got your mayor council item.
Yeah, I meant to pull that. I don't have any appointments tonight, so we'll go ahead and move with L1 and L2. Although there's people waiting for M1, so we could push that off. At least let them go and not have to listen any further.
We should end this at 10:30, as Laura always likes to hop in. I'd like to just make a motion then to continue with L1, L2, L3. And
but we have to do all the public hearings. They were noticed.
Right. I know. That's what I'm saying. Making a motion to do those 2 public hearings, L2, L3.
There's 3, L1, L2. Oh, I'm sorry.
We did L1.
My bad.
We did L1.
Apologies.
L2, L3 do referrals to staff and closing memorial of, and then move items M1 and N1 to and P1 to next week, Tuesday.
Okay, so the motion is to go ahead with L2, L3, continue items M1 and N1 and P1 to the next council meeting a week, and do mayor and council items.
Yep.
Is that it? Okay, is there a second?
Second.
Okay, I'll do a roll call vote. Councilmember Narenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
Aye.
And Councilmember MD.
No.
Okay, well, there you have it. So M1, who's ever here for that, many apologies. I know some people stuck around for that. Yeah, so welcome to the party. This happened with the softeners in, yeah, the hearing we just had last week. So many apologies. And item N1, likewise, that'll be heard next week. So with that, we'll move on to L1 or L2. L2 is a public hearing to consider the assessments for street landscaping and lighting assessment. Ted Samant. Oh, I need a motion to open the public hearing.
So moved.
Second.
Any opposition? Okay, so ordered. Ted Samant.
Thank you, Your Honor. We do have a brief verbal presentation that Andy is going to give you, but it is that time of year again for you to conduct a public hearing and consider levying the assessment on the lighting and landscaping district. So Andy, I'll turn it over to you.
Thank you, Ted, and good morning, everyone. Wanted to reaffirm that we have set this time and date for the hearing at the May 4th meeting. And at that meeting on May 4th, you got the presentation of the report of the landscape lighting district, as well as the diagram and the methodology. Tonight's meeting is about deciding whether or not to authorize collection of the assessment to take public input before you make that decision. The revenue collected is via the annual property tax bill, as you recall, and the proposed resolution authorizing the assessment proposes the same amount that's been collected every year since 1991. The maximum assessment that can be collected is based on a formula that results in a charge of $59.20 for a typical residential parcel and about double that for a typical commercial parcel. The maximum that can currently be collected from all the parcels in the district in any year is just over $1.5 million, which typically falls about $1 million beneath the projected expenditures for the district. And historically, the city's general fund has covered the gap between the expenses of the district and the assessment collected via the property tax bill. This year, staff is again recommending the maximum amount of the assessment be collected to minimize the gap and subsequent impact to the general fund. If the assessment is approved as recommended, the gap for the next fiscal year is expected to be just under $890,000 before any of the decision packages are considered. However, 3 decision packages addressing one-time increases totaling about $332,000 are in the budget proposal for the year, and you'll discuss those at a future time. Decisions made on any of the decision packages presented will impact the value of the gap, the subsidy, by changing the expense side of the equation. Those decisions will not affect the assessment collected, just the size of the subsidy. So to be able to collect the assessment, staff is recommending that the City Council take testimony from the public, close the public hearing, and adopt the attached resolution by title only, which would authorize levying the assessment in its full legal amount. That concludes my presentation. Happy to take any questions.
Okay, thank you, Andy. No questions from council. Any comments from the public?
No one appeared to have signed up for this item, but if there are several people signed on, if anyone wishes to speak, they should raise their hand. There are no comments in e-comment right now, so it appears that we do not have any comments for this item. No one's raised their hand to speak, sir.
Okay, and Councilmember Horvath.
A motion to close the public hearing.
Second.
Okay, any objections? Okay, so ordered. Is there a motion?
Yeah, I would make a motion to adopt the resolution.
Second.
Okay, there's a motion and a second. Make sure. Okay, I'll do a roll call vote. Councilmember Narenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
Aye.
And Councilmember MD.
Aye. And Nils, if you're going to yawn at 12:30, maybe you should make that motion at 10:30.
I know, right?
Right in the middle of the public hearing, just close it and just send everybody home. Yeah, sure, that would have been great. Anyway, I guess we could have talked about it, but it would have been too complicated. Anyway, with that, do you need
Bill,
to?
it's a joke between Nils and I. Stop.
Yeah.
Yes, we do have a title.
She's poking.
Council adopted by title. Oops,
Seriously.
sorry.
Okay. All right. So, do you need to read this, Eleanor?
Actually, Eleanor stepped away. I'll be happy to read it.
Go ahead, Vicky.
Adopted by title only, resolution number CC-2106-051, a resolution of the City Council of the City of Redondo Beach, California, confirming the diagram and assessment and levying of the assessment of the street landscaping and lighting district for the fiscal year from July 1, 2021 to June 30th, 2022. Thank you.
Okay. Thank you, Vicky. So next up is item L3. This is a public hearing to consider fiscal year 2021-2022 city manager's proposed budget. Yeah, it's in our 5-year capital improvement program. So with that, I'll entertain a motion to open the public hearing.
So moved.
Second.
Okay, motion by Councilmember Horvath, second by Councilmember MD. Are there any objections? Okay, so ordered. Looks like Marnie, are you gonna lead us off here?
You know, I think at this late hour, I'll just cover it. We did have a PowerPoint, but we're going to skip that. We, 2 weeks ago tonight, you received and filed the budget. The budget's been out for a couple of weeks. We've had a presentation to the Budget and Finance Commission. We're following the budget calendar that you approved earlier this year. This is the first of 3 public hearings related to the budget. What's really new tonight is we've got a number of budget response reports that are in your packet. What we really would like to hear from you tonight, we know we have others that you've directed us to do. We're working on those. We'll have those to you at the next 2 public hearings. But if there's additional budget response reports that you would like to see, this would be the time to identify those. And certainly you've got all the key staff here that's been involved with the budget. We're happy to answer whatever questions you have or focus on whatever part of the budget you'd like to. But what would be most helpful to us would be if there's additional budget response report topics you'd like to have covered to let us know about those. So those are the staff comments.
Thank you, Joe. And thank you to Marnie and the entire staff that's worked on this. I know it's a tough time of the year for everybody and every department, and not in the best of financial times, to say the least. So just want to thank everybody who's been working on this in our staff, and likewise the council. You know, we've tried to manage how much we ask for, but there are some important things, obviously, we have to address. So I'll just turn Councilmember Horvath. You had your hand up first.
Yeah. So I do have one. I thought the BRR on the dog run facility and existing dog parks was going to be more generalized, but it reads more specific. And so I just wanted to know if I could request an expansion onto that BRR for similar type structures at McNeil JC, Franklin Park, and Lilienthal Park, just to have an understanding of what that would look like. That's it for now.
Okay. Does it requires an answer right now? Or?
You had McNeil, JC, Lilienthal, and what was the third one?
Franklin.
Yeah.
Okay.
Public Works will be able to follow up and have a comparable report for those parks.
Thanks.
Okay.
One comment, if I could, Mayor. Anything that's requested tonight is likely to be part of your July or June 15th packet rather than your June 8th packet, unless it's very straightforward. So we're trying to get through all of the remainder of the items on the current list. You can see those titles in your budget response report packet. So anything added tonight is likely to come to you either as a blue folder item next week or as part of your packet for the June 15th hearing.
Okay. Councilmember Narenheim.
Thank you, Mayor Brand. A couple quick ones. What was the status on the Nob Hill? Did we have a budget response report? The lights on the stairs at Nob Hill between Esplanade and the bike path.
Yeah, that was something we talked about months ago. I don't know where that's at.
I thought there were
or Ted, or I think Ted was working on it.
It is, and I believe it's listed as lighting along beach access and pedestrian walkways, number 2. That's the upper walkway of the front of the beach, basically from Nob Hill up to Vets Park. And then the others are the connectors from Esplanade to the beach walkway.
Got it. Okay, perfect.
That's in your packet tonight.
That is, yep, I saw that now. Okay, thank you, Ted. How much is in a Quimby fund right now, if we can get that answer on that? I didn't see that in the in the budget. Veterans Park, the old library. I heard from Mayor Brand that the people that we had the contract with, that contract has run out. Is that so?
The Veterans Park Library.
The old
Historic
library?
Yes, with COVID restrictions, they basically were unable to operate, so they have essentially ceased operation. We are working on an RFP that we'll have before you to solicit another operator. So we'll take that through the RFP process.
When will that be coming forward, Joe? That we can see the RFP and give our comments on that?
Yeah, that should be soon, the next couple of meetings. I don't know if Lori or Cameron has it calendared yet, but I understand there's been a lot of work that's happened on it. So I think we're almost ready to bring it forward.
Okay. Let's see here. Dog park group. Did you guys have a budget response report on the dog park? And that dog park, what do you mean? Let me rephrase that. The dog park budget response report, does that include talking to the dog group, volunteer dog group, the 501c3? Joe.
Now, let me do a double check here.
Okay, if not, if you could please reach out to them and see what their needs are, include that part of the budget response report so that we can be sure to add their requests and their needs.
Thank you. We could certainly do that, Councilman. We do, I believe, discuss in the title a description of what's planned for those improvements, and that is a CIP. So we have an opportunity as we go forward through our normal implementation process to gather feedback and ultimately have you all approve plans and specifications for that project. So you'll have a few bites at the apple at that, along with the nonprofit.
Okay. I did not see in here, maybe I didn't have it ready yet, haven't seen it or missed it. The Performing Arts Center, the position to add back the events coordinator. Do we need to add that position back in? I didn't see that in the budget.
Yeah, that is not in the that has not been returned to core as part of the proposed budget. You would have to add that as a separate decision package or item.
Yeah, the positions that were hard layoffs last year where individuals were displaced.
2 of them.
Yeah, that was not part of your motion last year, adopting the budget to, it's difficult to lay off someone just for a year. I mean, that was a permanent action.
Right.
Holding the positions vacant, you made all of those 1 year to return to core budget, and those all return with the exception of the ones that you see in the budget decision packages that are still holding some positions vacant for a year.
Okay, perfect.
And Councilman, back to your original question about Quimby, we have $600,000 of estimated revenue in the Quimby account this year with $450,000 of planned CIP uses with some additional carryover available. I think we're projecting a year fund balance, if approved as proposed, of a little over $200,000. But if you'd like a more significant breakdown of those estimates, we can provide that. I think we've done that BRR in the past.
Yeah, if you can just include the CIPs that they're going to, that'd be great. A simple breakdown, not very complicated, just so I can see what's going on. That's it. Sure. Thank you.
Yeah, that would be great to see a breakdown of the Quimby fees, but also decision package 36. You may want to fund that from a different source than Quimby's. Or the special other than open space acquisition fund. I'm sorry. It's not necessarily Quimby. So yeah, it'd be good to get a breakdown of both the acquisition fund and the Quimby fees.
If you'd like, we can provide for you in a BRR an alternative funding source or alternative.
Yeah, I was going to ask that, but yeah, that'd be great. That'd be great. Councilmember Alonso.
Yeah, thank you, Mayor Brand. A couple things. One is, I just want to make sure that we're on target to get the estimate on what it would cost for stepped up code enforcement. Okay, good. I'd like to get a budget response report on phase 2 of the county fire study. Okay, that would be one. I'd also like to see a budget response report, maybe in the same one or a different one. Any dollars saved by combining fire chiefs with Manhattan Beach and El Segundo that we've talked about? Okay.
I think we have, Councilman, let me see if this title, I think we have a bit of a catch-all for both of those.
Yeah, the first one for sure we have on our list we're working on. The second one we may have to modify.
Okay, got it.
Right now, the way it reads is, what is the process to obtain an updated fire services proposal from Los Angeles County? And what is the status of the review with Manhattan Beach and El Segundo for the possible sharing of fire administration personnel? That's
okay.
BRR.
Okay, great. I have a question on BRR 3 that was supplied tonight, which is the vehicle replacement fund. In there, it says the first unit 104, Chevrolet Suburban EQ, which is, I guess it's equivalent. Fire department, replacement revised budget, $191,492 for a Chevy Suburban. What am I missing here? Is that a typo or is that real?
Well, if it's real, why don't you just give us a breakdown of why it costs so much?
Yeah.
I can go buy a Suburban for 60 grand and
what the alternatives are, I think. That's the major question.
Yeah. And also, why some of these vehicles, whether they're police or other, how much extra is it to equip them than, say, buying it off the street? I'd like to know that. That would be interesting because I know that they're not street package vehicles. The other thing is I'd like to be able to see, and I read this a little bit, but I'm a bit confused when I read the report. It says the beginning balance is 7.2 million. And when I read the report, it says 7.35 million. I'd like to know what, I'd like for us to go through this maybe the next time around, what the ending balance is if we approve this budget, these budget response reports, these decision packages, what the ending balance will be for sure July 1st of 2022. Right now it reads 8.4 million. I just want to make sure I understand that correctly. So if we could review that at our next go around, that would be great. And that's it, I believe, for me. Thank you.
Okay, Councilmember Obaji.
Thank you all for preparing these budget response reports, especially as to the dog park or the dog runs. Really like them. And as for quick question, and then I'll get to the others. But I see that Perry Park, you essentially cited these two locations. One other that I don't think it'll make a difference as far as cost. Maybe you could tell me though why it's unsuitable. Is another location I was thinking of is this box right here, because it's just got a walkway on either side. People sometimes cut through it, but otherwise it seems like it's not right next to a field, so it wouldn't disturb, you wouldn't have dogs barking while people are playing sports or while parents are trying to watch their kid in the outfield or something like that. I know this area gets used quite a bit. Is that a suitable spot for a dog run?
My recollection, it seemed a little bit on the narrow side, but we can definitely go look at it and amend the BRR for the dog run for sure.
All right, cool. Thank you. And then I know that it's been a hot topic. By the way, I'd like to commend Ms. Rulin because I saw her handling the Budget and Finance Committee's meeting and answering all their questions basically on behalf of the entire city staff. And while she may be retiring, she's probably one of the sharpest people there in the city. So give her props for dealing with all their questions. On the administrative office or administrative ordinance review, I think this is kind of for Mr. Webb, but are we going to get a draft ordinance at some point, and do we have a BRR coming up for what it would take to fund a robust enforcement program as far as building, commercial, residential, leaf blowers, unleashed dogs?
well, I'm not the person on a budget to do that because I don't do the investigation. We do the prosecution. What I indicated is that if the council determines to go through with an administrative hearing process, there's a cost to that. And there's, we're a smaller portion of that cost. We would handle any lawsuits that get filed by someone who the city manager or the hearing officer appointed by the city manager. If there's an adverse decision, we could be tasked with defending an appeal to Superior Court or in trying to collect the judgment. The cost would be in terms of how many officers do you need to do it? What does the city manager need in terms of additional staff to or contract services to properly do an administrative hearing? The city has gone through various stages of, everything is by default a misdemeanor, and except for the sections of the law specifically designated as infractions. And I've mentioned to you that early on, the council's determination was just we enforce everything that gets sent to us by way of misdemeanors, such as not having a dog properly licensed was a misdemeanor, and we used to file that. There were a number of complaints from people who didn't think that they should be criminals because they didn't have a dog license, and that has steadily dropped off our compliance. So first, the council has to have the determination of what type of enforcement they want, then what is the most cost-effective way to comply with that. My portion of the administrative ordinance, I said, would be relatively straightforward. We'd look at cities such as Manhattan and Hermosa who use administrative hearing process and as opposed to criminal prosecution, and go forward with that. Downside is that traditionally it hasn't had as much teeth. However, by not criminalizing everything, I think city staff was less adverse to taking quicker enforcement action. So, I would leave that up to the city manager.
Yeah.
And part of your budget proposes moving code enforcement from the police from the community development department to police. Well, they're not at all adverse about taking action, and you'll have to hear from them. But so my part of it is at the end, and I have a small part if you decide to have a minute go down the administrative hearing. Okay, what additional resources do we need, or what time constraints would that additional demands on our time would suing to collect, providing legal advice to an increased number of administrative hearing officers for the city.
Do we already vote to agendize that at some point?
I think you were looking for, as I recall, and correct me if I'm wrong, Joe, I believe you were looking at having a budget response report of the options of code enforcement. It could be everything to just having more code enforcement officers. It could be contracting out, or it could be changing the way we do code enforcement, going less criminally and more administrative hearings, and what the costs of that would be. And then once you make that decision, then certainly I think I said we could bring back to mid to late July the hearing ordinance.
Mr. Afkin, anything else?
Yes, as Mr. Webb described it, we're going to do kind of an update to the budget response report that was done last year that talked in terms of options for supplementing code enforcement. So additional staff, either full-time or part-time, contract service. This last piece in terms of moving to kind of administrative hearings and a hearing process. I would have to get with Brandy to see if that's something that she's incorporated into that report, or if we may need to do some additional work to modify that.
And the council may want to think through the list of code sections that you would want criminally prosecuted and have more robust enforcement, to have them send it to our office. Things that you may want to have administrative hearing. For example, we've had a noise ordinance for 30 years. That's in you have a vague one that is unreasonable, noise to an unreasonable person, and you have a very specific decibel level. But when I was the city prosecutor years ago, the police department had officers trained, and they had a state-of-the-art for then machine to measure decibel levels. Well, it's part of a council policy decision. Do you want your police responding to a number of noise complaints on a Friday and Saturday night? Because that takes them a time away from other enforcement. And so a lot of it will be, what do we want? Immediate enforcement, but maybe less, punitive enforcement. And you can, if you come to that discussion with that kind of refinement, that may end up expediting the process.
I feel like money motivates people here. If they're going to get cited for it and a fine for it, then they're going to, especially our commercial property owners, they're going to fix it.
Well, but I would say that the money is applicable to either, because we're going to fine them if they're prosecuted for a misdemeanor, and then the judge will enforce the order, or you can do administrative hearing, and that's quicker. But we have to go out and collect it.
What I understand is that when we give somebody a speeding ticket in our city, most of that money ends up at the courts, not with the city. And whereas if we give them a fine, just a citation, hey, pay this to the city, it's going straight to the city. Don't involve the courts. Don't pay the courts.
Yeah, that is absolutely true. However, we don't have the courts to enforce them unless we take a separate action to enforce, say, a hearing officer's adverse judgment. And so there are lots of things to consider. And if you come to it with more set ideas, then we can suggest, ways to accomplish the goal that all of you have mentioned, which is more certain enforcement and appropriate enforcement for the level of violation.
Thank you for that. Two more questions, but not for you, Mr. Webb. If we wanted a budget response report on, I guess, enhanced attention to the North Redondo bike path, is there anything we can get on that? Yeah.
Yeah, we can get you some. Well, I believe we're already planning to provide the cost of irrigation repairs to the area to try to increase just general watering. But we could supplement that with additional.
It's a huge area, and it's where it's part of the bike path is in the most dense area of our city, and it's an open space that people use, and they'd like to see beautified. And we'll tell by this Saturday when people come out to clean it up how much people care about it. But so far, it seems like there's a lot of interest in it. So thank you for that. Now, last thing, I noticed that. We requested a BRR on the bulb outs on Grant Avenue, and I recall Grant Avenue bulb outs being part of the CIP. I don't see them in the CIP still. Are they still there, or do they drop off the CIP entirely?
So they should be there. Grant Avenue itself has its own CIP, and that is in motion. And okay. Bulb outs, we do have, for the non-signalized intersections, right. BRR for that.
Okay, and we don't have it. I don't have it yet, right? Or we do?
I don't think that's in your packet yet. And
that's not in the packet yet.
It's
Okay.
going to answer for you which bulb outs are not included in the current CIP. So you'll have a cost, and you'll know exactly what portions are not currently covered.
Correct. All right, and Maybe if we can get some, I don't know if you'll be able to do this by the 18th, the last thing actually. If we can get some cost estimate on every level or every parking space for underground versus over what is it? Above ground parking space. I think that's something we're going to be interested in North and South Redondo.
50 grand versus 25, 30.
Yeah.
Yeah, we've got some common metrics we can share with you.
All right, cool. Thank you. That's it. Thank you all.
I had a couple questions. What is the street sweeping parking fine now? Is that half? Are we going back to, I remember we had a discussion, I guess that's my first question. I can't remember. I thought we'd reduce the street sweeping fine, the parking.
Yeah, that had a very finite time period on it due to the pandemic. We're now back to regular enforcement and regular fine levels.
Okay, thank you, Jim. And then the last thing, and I talked to Chief Kaufman about this briefly, was potentially installing parking meters along Francisca between Redondo and Catalina. We've got a lot of oversized vehicles starting to park there as long as they want. And plus just a lot of cars parking there, and it would be good, and it's seriously doubt there's Redondo residents parking there. I was wondering what it would cost to install meters there, and yeah.
Yeah, I believe that's in the proposed budget, Mayor. In fact, to finalize the remaining installation of areas where we still have old coin-operated meters, as well as we have a figure in there for you to expand the parking area to include Francisco, which is in our parking resolution.
Okay. I didn't see it. Apologies. I saw a decision package that talked about, the meters that we needed to finish, but I didn't see where there was, I don't know what you would even call it, adding meters.
Yeah.
Where is that?
It's a portion of that. So if you'd like some additional breakdown on.
Oh, I see. Okay. No, that's fine.
We could do that.
Decision package number 43. It talks in terms of the installation of an additional 86 metered spaces along Redondo and Francisca west of.
There it is. Yeah. Thank you.
So I think it's
96. I didn't realize there were that many spaces. 96. I guess that includes part of Redondo.
It does. Right. Everything as you move up towards PCH.
Okay, we can decide what to do with that. Okay. All right. Are there any public comments related to the budget? I don't see any more hands up from the council.
Bill, I was just wondering, based on what you were just talking about, if we could separate it by Redondo versus Francisco.
What about it?
Spaces. The number of spaces that would be metered each place.
Yeah, it'd be good to have that breakdown, Mike.
Yeah, we can answer that for you.
Yeah. Okay. Francisco's probably more like 20. So, okay.
Okay, Mayor. There are no Zoom hands that are raised. So we do have 3 comments. Vicki, if you can please read that.
Thank you. First comment is submitted by Mark Nelson. I oppose any expenditures with BCHD that are not specifically tied to services provided inside Redondo Beach to residents and workers in the city. Per Public Records Act requests or responses, BCHD demonstrated that 84% of its COVID testing and presumably 84% of its other COVID services and expenses were for non-residents. CEO Backley makes vague statements absent any facts. A public records request was filed at BCHD. However, they have up to a 1-year lag in fulfillment. That's the 84% worked in the city. BCHD has such poor budgeting, cost accounting, cost effectiveness, and tracking systems for programs that taxpayer funds cannot be trusted to BCHD for any service provision that is not explicitly measured and evaluated. Next comment, submitted by Lisa Rodriguez. I oppose the $35,000 capital improvement program for community gardens, an initiative of South Bay Parkland Conservancy, until a complete investigation of the $18,316.50 to this organization is conducted, and a complete investigation can be provided of the related parks and commissioner. The next comment is submitted by Sandra Siegel. I oppose any partnership with South Bay Parkland Conservancy, such as for line item community garden infrastructure improvements, $35,000, due to this organization's documented history of routing taxpayer funds to its board members and their companies. A full investigation is in order regarding the $18,316.50. That includes public comment for this item.
Okay. Yeah, with that, I guess I'll entertain a motion to continue the public hearing to June 8th.
So moved.
Second.
Okay, motion by Councilmember Horvath, second by Councilmember MD. Councilmember, I'll do a roll call vote. Councilmember Narenheim.
Aye.
Councilmember Lowenstein.
Aye.
Councilmember Horvath.
Aye.
Councilmember Obaji.
Aye.
And Councilmember MD.
Aye.
Okay, next up are mayor and council items. Councilmember Narenheim. Referrals to staff, I'm sorry.
Yeah, exactly. 1 second here. Lights. I think I'm good. Thank you.
Okay, Councilmember Lowenstein.
Yeah, Mayor Brand and I were at Veterans Park yesterday, and the railing that goes down from the parking lot to where the Veterans Memorial is really unsafe. And
From the Elks Lodge.
By the Elks Lodge, right. Actually on both sides, but on the right side specifically. Before somebody gets hurt, we need to repair that.
Yeah, I'd spoken earlier, Todd, with Ted Simon, and he said that's probably doesn't require a budget response report, but that something that we do.
It doesn't, Your Honor, and just so you're aware, we did actually look at that area railing already, and we've got things in motion to get that replaced.
Okay,
Thank you. That's it for me. Thank you.
Councilmember Horvath.
Nothing this evening.
Councilmember Obaji.
I suppose this should have been in the budget response report, but or discussion. But can we get an estimate, maybe if not for this cycle, for next, but on converting a couple of our tennis courts to flexible tennis or pickleball? That's been a request that's received as pickleball has grown in popularity, and it's, I guess, pretty versatile with existing tennis courts.
So the proposed CIP includes $15,000 to conduct a feasibility assessment for just that very question, as well as explore all possible park locations for the installation of pickleball facilities. So,
nice.
CIP document.
All right, and is that budgeted for like a year far out or this next year?
It would be funding for this next fiscal year.
Perfect. All right, thank you for that. Also, there's been some, maybe you guys can give me some direction, but there's been some discussion by residents about, let's say in front of this curb right here, for example, there's enough space for 2 cars. People have that very, very prevalent here where we have lots of driveways. But residents want to know, can we get parking spots drawn in so no one car parks in the middle and takes up both spaces? And if so, what's the minimum length of the parking space that we can draw? And essentially we'd have to pass an ordinance saying that if lines are drawn, then you have to park in those lines, or does that exist already?
That exists already as far as parking outside of the lines, and they are generally 22 feet in length. That's what you would need in order to create a space.
Okay, and do we know whether those would work in residential areas, or is there a reason that they have historically not come to residential areas because they would reduce the number of total parking spaces that you can have?
Absolutely, that's one of the primary reasons, and then you're just adding a lot of paint and a lot of additional materials onto the residential streets. But generally speaking, yes, they will take away more parking spaces because now that 22 feet is significantly more than you can actually fit cars into, especially with the new compact vehicles.
Got it. Okay. That answers that. And maybe we can move to agendize a discussion about painting the train track bridge across Artesia Boulevard. Either repainting or with a muralizing it.
That's a great idea. Adding a mural to the...
Yeah, it's not easy. I'm discussing with Ted. It's something that they struggled with out in Hawthorne or Torrance, but I think it's something that we could have success with if we persist in it.
So the motion is to agenda as a discussion about decorative painting for the overpass at Artesia.
Yes.
Okay, is there a second?
I'll second that.
Wasn't that part of the ACAP?
Can we?
I thought that was part of the ACAP was to improve that. I thought that was specifically one of the things in it.
Well, I think you wanted an arch, but is it?
It wasn't physically part of the ACAP. ACAP was part of the arts and murals in general, but I would like to expand that, Councilmember Rabaji, to include murals throughout the city on all large walls, public and private, so that we can get a broader discussion on the city as a whole, because murals are fantastic art pieces on both a public and private locations. So
And really an expensive way to beautify our city. So I'll accept that amendment.
Thank you.
Okay.
I think it's already in the art commission.
We don't have a mural ordinance though, right?
Yeah.
So
I think we do. But
do we? Mural ordinance?
I've searched the municipal code for the word mural, and the only place I think is on U projects you can apply for public art.
Do you know where this code is, Christian?
I just I remember Paul Moses talking about it at some point during a meeting, that it was something that the art commission had drafted up. So I'd have to go.
What you might be thinking of, Councilman, is we have an inventory of potential locations throughout the city that could house public art of all varieties, and including murals. I don't believe we have, to Councilman Obaji's point, I don't believe we have an actual mural ordinance. We have an ordinance to discuss as funding for public art. And then from there, we partner with artists and take that through the Public Art Commission process to identify prospective projects. So I think what we would probably do is bring back to you a conversation about what that inventory currently looks like, and then perhaps ways for us to expand on our efforts to expedite installations throughout the city. But it might just be time to have a full check-in with kind of the state of public art in Redondo Beach, and kind of go through broader background and talk about potential prospects and future installations.
And an allowance of private murals on private property.
But give us some time on that. Your calendar is so full.
Yeah.
Now
I'm not saying it should be done next week or two or next month, but when it comes back, to allow for private property as well.
Special meeting in June? Is that what we need?
No.
Tomorrow.
Trust me, as tired and worn out as you guys are, we are too, I'd say.
Yeah, I agree.
But you just keep coming with stuff, though, Zane. Now we're going to talk about murals.
All right, but
good.
We didn't put a time frame on that, so whenever we get
let's say by September. How about that?
Well, let's
by the end of September.
I mean, you just heard the speech from our city manager last
October.
month. November.
Yeah, guys, our meetings are so crowded right now. We're not even getting through stuff.
In case you hadn't noticed,
December, by the end of the year, our first year in office.
We're 11.
Are going.
What would work for you, Joe and Mike?
I would say we could leave it a little bit open when we get caught up with the referrals that we have. I'm thinking probably December is probably the best date I've heard so far. So
okay,
I'll write that down.
By the end of the year.
Get right on that.
Oh yeah, I think we decided this. Is there a discussion coming back about street vending? I know we brought this up, and now I can't remember because I'm getting a lot of complaints, and there's huge amount of chatter about street vending that's popping up in the state law that's governing it, where they have license, whether they have permits. Is that discussion coming, Joe?
Brandy, I think is.
Yeah, it's coming. Jillian is working on what we can change per our ordinance, and I think she was looking at it one of the next couple meetings to bring that to council.
Okay, sounds good. Couldn't remember what we had. Okay, with that, I guess we're at the point of adjournment. I would.
Well, Laura.
Oh, I'm sorry, Laura, apologies. Councilmember MD.
It's okay. I'll wait for next time. Thanks.
Oh, thank God. All right. With that, I guess I'll entertain a motion to adjourn. It is now 1:13.
So moved.
Second.
Okay, motion and a second to adjourn. Any objections? So ordered. I will see everybody a week from today, or actually a week from yesterday now, at 4:30.